Gosh, hi, Gwen. Hi, Julia. Okay. Can y'all hear me? Can y'all hear me? I had to upgrade my StreamYard. I used up all my free stuff. So now I'm big time. I went back and watched a bunch of other tail ends of trials. I'm super tired. So no makeup today, you guys. Sorry. Oh, I left my computer in the other room. Oh. Oh, come on, Boo-Boo. Good morning. I'm glad you guys are making it back. Oh, yeah. I saw that. They denied him. I was going to mention that this morning. I totally forgot. Okay. I didn't see the whole thing. I just saw that the judge, I just saw the caption that the judge gave an upsetting ruling for him. What did the let me look it up. What did they say so they just aren't going to give him a new trial? Did they say that, or they just said they were dismissing the new evidence? Ah, shouldn't they have already done this retest though? Like his team? Uh, okay. I just figured if they had new evidence, they would have brought it to the judge with new evidence. Right? I thought that's how it worked, but gotcha. I don't think he's going to get a new trial. Oh, I didn't see that this morning. The prosecution is holding their evidence very close. They're not letting go because they don't. I don't know. I'm on the fence. I don't know about you guys. I think Julia and I yesterday were feeling the same, but I'm on the fence about this guy. I don't know if they even have evidence against him, and if they do, they're holding it very tightly. And I don't know. I just think it's kind of hard. Excuse me, to stab four people to death and no one make a sound, you know? And especially a guy like that guy to me, I mean, if I'm a dude, I'm protecting my girlfriend and I'm going to do something, and they didn't have any of them from what I heard, I don't know, I'm not positive, had any defensive wounds. So, I just find that kind of strange. They just forgot about it. That's terrible. I don't know if they have a strong enough case. I don't know how they got past the grand jury. I hate that we don't ever get to know what was actually said in the grand jury. Yeah. Sometimes I wonder, do you guys ever see these trials and you wonder how in the heck they ever got to trial? I mean, when you're watching the prosecution team put on their evidence and you're just like, how did this person even make it this far? Yeah, you know what's crazy about Hollyweird? That's what I call it because I used to be in the industry. Um, all those people they always find redemption and they always make it back. It's so crazy. I mean, look at Chris Brown. He beat the ever living snot out of Rihanna. And what did they do, a duet together or something? Um, all of Hollyweird, those people somehow manage to uh, end up doing great. People welcome them back with open arms. Yep. It's disgusting. I'm doing a film this year. It's a actual true story. One of my friends, she was sex trafficked as a child, and we're doing a film about her. And it'll probably be the last film that I do. It's not. I don't consider it necessarily a secular film, but it will be. We've already done the short film. We're going to do a film, and then we're probably going to make a series. But she she knows a lot of information about a lot of people. and she worked with the FBI and people, very important people. So that's why I actually got out of Hollyweird, because all those people praised Harvey Weinstein. They thanked him from the bottom of their heart for everything he ever did for them when they won their awards. And then they wanted to get up and jump up and down and kick and scream that he was a terrible person. And I was like, oh, but you were accepting awards and thanking him when he made you famous. So I just think it's a sick industry. Yeah. I have a lot of people, like, you have a choice. I don't know if you guys watched the Kevin Spacey thing. Um, but a lot of those guys that were talking about Kevin Spacey, I mean, you have the option. You can walk out. If you see a guy open the door in a bathrobe, I mean, and if you get asked invited to their hotel room, I'm sorry, but like, sorry, not sorry, actually, but like, you have the option to say, I don't want to go. Yeah, these things have the kids, that's it's awful things that are happening to kids. I mean, quiet on set, that actually is happening, and that's what like made me realize that this is not where I want to be. So, yeah, I think Hollywood is awful. Danny Masterson, I mean, all of that 70s show. I mean, Ashton Kutcher, he actually had an entire organization against sex trafficking little girls. And then you look back and you see that he was an adult when he was with Ma- uh, Mila Kunis. She was only 14 on that show. She lied about her age so that she could get on that show. And Danny Masterson and Ashton Kutcher were both after her. That whole crew, the whole cast was just crazy, except for Topher Grace. Topher Grace was the only one who did not hang out with the rest of the cast. He separated himself quickly. It's like you literally have to sell your soul to the devil to be famous there. It's weird. Super weird. But they'll be famous again soon. You know, you'll see them in lights, and they'll make a comeback and all that fun shenanigans, and people will pay to see their movies. It's kind of sad because there's so much talent out there that doesn't get recognized. So did everyone get some rest last night, or did you go back and watch some other trials? I know Gwen went back and watched. I'm wondering if China's going to join us today from work. Definitely. Gwen, from being in the industry, not don't get me wrong, I was like the bottom of the cesspool, so don't I'm not crazy. Um I dipped my toe in. So I was around some famous people, and I got to be around some people and act, but you are right. I definitely feel like I feel better about my soul and my mind and everything because I didn't go further. Um, yes, you are right. Uh, it's definitely tough. I've been on sets where the director, we would be told like you can't look at this person, you can't speak, don't speak to them, don't look at them, don't even say their name. And I'm just like, wow, really? It's like that? Like they're not God, you know? I mean, and then God would not even say that. So how can you I mean, it's crazy industry, crazy. But yes, uh it's like that. Good morning, Selena. So now I'm paying for StreamYard, you guys. So I think as if we start doing more lives and we get more people in here, I think I'm gonna have to start adding some moderators at some point. So if anyone would like to be a moderator, let me know. Um, I appreciate that, Gwen. I do too. I definitely do. Um, Yeah, I would do Christian films. I would do something more, I can act it in local theater or something like that, but I don't feel the need to be on screen anymore. I've lost a lot of who I thought were my friends. I don't have those anymore. I used to be very involved in the Asian American Film Festival here in Austin. I was on the actual operations team. I was a part of the Asian film group here. I was a part of the Asian American group here in Austin as well. But because I'm very vocal about my Christianity and about God, they have completely blacklisted me. So the all inclusive people are not all inclusive. They have literally shunned me, took me off the email list, took me off the chat group, took me off of everything. And literally the Austin Asian American Film Festival is happening in 2 weeks, and I'm not even able to volunteer. They took me off the volunteer list because I am very vocal about my feelings for God, and found my Christianity again. And don't get me wrong, I'm not the perfect Christian in any way, shape, or form. I don't think anyone is, but I when I turned 50, God just spoke to me and said, "Hey, honey, you need to get your butt back here." So I did, and it's still a work in progress. But yeah, I'm very vocal about my feelings about what's been going on in the world and how things are happening and coming back to God. And they just took me off, and I was like, wow. So it's like that. But yeah, when I stepped away from the acting industry and I started speaking out more about God, that they definitely kicked me out. It was hard. It was sad. It hurt my heart, but you know. Hi, Amazing G. How are you? Good morning. It happens. You gotta just be strong. I know. See, that's terrible. But you find out who really is true. Definitely. Yeah. God is there, and he's answered. You know what is so crazy? I'll tell you this amazing thing that happened. So I've been estranged from my family for years, you guys. Good Friday, Easter weekend. Okay, Good Friday. I celebrated Good Friday, Easter weekend with God. And I prayed Friday, like crying, praying, because I haven't had any contact with my family. I lost my grandmother in October, and I was praying to God, please, I hope she forgave me, because we hadn't had a relationship in some time. I hadn't spoken to my sister in 10 plus years, seen my sister, anything. And I prayed to God. And literally a week to the day, my sister texts me out of the blue. I didn't even know the number. And she was like, I'm going to be in Austin this weekend. It was during the solar eclipse. I'm going to be in Austin. It'd be nice to see you. You don't have to see me if you don't want to, but I would like to see you. And I didn't know who it was, but I figured it out. It was my sister. And she's like, I'm going to be staying in a hotel in Hutto. And I was like, that's like on the other side of the earth to me. So, no, you can come stay here. And you know what is crazy? When I was telling you that my sister lives in Arizona, that's my sister that lives in Arizona. And we have been in touch, and we have picked up our relationship. And I said, sis, I said, God is speaking to you, and God answered my prayers, and he's speaking to you, whether you realize it or not. And this is God's work. God did this. And now my sister and I have a relationship again. How insane is that? So everything is God's will. So I believe, right? Isn't that great, Julia? I mean, it's a blessing. It totally is. 10 years we wasted for something so stupid. I mean, it's amazing. God is so good. And he does answer prayers. Yeah. It is. It's amazing. Yeah, I appreciate you guys so much. That's so cool. It's so hard to find people out there these days that believe. As you can see when you get shunned from the very people that you thought were your group. Yes, I poor Paul. I think his mom. I don't know how to read her. I know there's hope for Paul. Yeah, I know a lot of people say that prison, I mean, obviously it's not the rehabilitation that we want it to be. But a lot of people do find God in prison. And I know some people think it's fake, but I'm hoping that it's real, that when they find God, because I mean, they don't have anything else to do but sit there and think about what they did and find redemption. Yeah, we can't be the judge. It's between God and that person for sure. Yeah, it's so easy for people to say, like, what a monster, what a horrible person. And it, yes, we do have free will and we have choices, obviously. God gives us that. Um, but again, God works in mysterious ways and he has a plan and it's weird, but there's no rhyme or reason to it. Gosh, I bet if we talked about God on the Law and Crime channel, it would be an uproar. They like to do a lot of cussing. I hope I hate to say this, but I hope Sherry goes to the Law and Crime channel today, not this channel, because I don't want to have to. Jesus loves everybody. It's just people don't understand he still loves them, but they are going to be judged. There's a line. God has a line. We all are going to be judged. We all still have to suffer consequences. I always joke around and say, when God judges me, I'm going to be living in a little tiny shack in heaven because he's going to be like, okay, honey, you did this, this, and this. You're forgiven, but you're going to get this little shack. You're still in heaven, but you're going because even though he forgives you, he ain't forgotten. You're still getting punished, but you get to come in, but you got to mow grass. Oh, oh, Julia, we're gonna get through the gate. Don't worry, we're getting there. We believe. If we're saved, but we all are gonna, yes, we all are gonna suffer for the poor choices we made, for sure. But that's a small price to pay for what Jesus paid. I mean, honestly. Oh, Selena, honey. Uh, Selena, I'm the worst. I'm terrible. I'm so. You say you try not to judge. I'm the worst. I look at people all the time. I'm like, honey, that's not. I'm terrible. I have to ask God to forgive me every day. Like in the moment, I'm like, God forgive me, but I'm about to just be like, girl, that ain't right. What are you wearing? What is going on? What is happening to your hair? I'm the worst, so don't eat. It's okay. I'm judging and asking forgiveness at the same time. God's probably like, honey, you are so confused with yourself. Get your stuff together. I'm that person that's like, is my face showing what my mind is thinking? I need to stop.
On May 30, 2024, it's the matter of State versus Christopher Greger, case 21-1881. Court Smart's operated by our court clerk, Sue Hall. Our official court reporter is present. She is the official record. The Court Smart recording is not available for release. May I please ask counsel to place your appearances on record.
Your Honor, Christine Lento appearing on behalf of the state.
Assistant Prosecutor Jamie Sharp, proceed.
Good morning, Your Honor. Mario Bellucci on behalf of Mr. Greger. Good morning, Ms. Lento. Good morning, Ms. Strong.
And Andrew Grant, on behalf of the record. Good morning, everyone. Good morning, Your Honor.
And Mr. Greger is seated to my left.
Thank you, everyone. Mr. Greger again appears appropriately attired in a gray suit and tie. Courtroom 14 is available for overflow, but as of right now, we still have ample space here. Anything from counsel before we bring the jury over?
No, thank you.
And you worked out issues with the exhibits to go into the jury room?
Yes.
Good. Ms. Ferranti, I believe, and the prosecution team went through all the exhibits, put them all in a box together, and I think we're.
Great. All right. Ms. Grimaldi and Sergeant.
I have to cover up long crime. I have to cover up long crime so I don't get copyrighted, y'all. Hey. Oh, that's not it. Okay. Sorry, I have to cover up long crime so I don't get. Oh, sorry to hear that, Gwen. Well, I'm in bed every day. I have had some pain and I'm going for a procedure next week. So sitting is very painful.
Very good. Thank you.
So I have to lay a lot. But I hope you recover very quickly because it stinks. It's one thing to be laying around by choice. It's a whole nother thing when you have to do it. Oh. I wonder which one is his girlfriend. Is she there? I wonder.
We're in the building, Your Honor. All right.
Well, we'll keep you in our prayers, Gwen, for sure.
Just give us a knock when you're ready to come out, okay?
There's power in prayer.
just. I gave it, yeah.
Oh, you did?
I
Okay.
gave him like a first one.
Okay, perfect.
Yeah, yeah, I gave it to everybody.
Okay. Yes, sir.
Thank you, everyone. Please be seated.
Okay, I'll be right back. I have to have some more coffee.
Yeah.
So just a reminder that when the jury comes out and I start my charge, then the courtroom is going to be locked. So if you're here for the duration, although I promise I won't be as long as the attorneys were in their summations. So. Well, I didn't say it in front of the jury.
Is it all right? Oh, I thought they were.
Thank you, everyone. Please be seated. Ladies and gentlemen, any concerns or issues you need to bring to my attention? All right, seeing none, I'm going to give you the final jury charge. There are subheadings before each section, so I'll read the subheading and then read the narrative after that. We've been working like crazy with the air conditioning. Hopefully it's better. But when 12 of you are cooped up in there, the temperature's going to rise. So it's a little chilly now. Hopefully they'll be comfortable for you. They've got a contractor here. I think there was someone even in there this morning. So, but of course, it's not even going to be more than low 70s out today. So you can imagine what happens when it's 90 degrees. And of course, the window doesn't open either, if you've noticed that. So if at any point you're uncomfortable in there, I'm sure you'll be uncomfortable. But if it gets too uncomfortable, then you definitely need to tell us and we'll do whatever it takes. I've even considered arranging having you escorted to another courtroom that may not be in use to use that jury room. So if the air conditioning stops in there, we have a plan for that. I have to discuss with the attorneys first, but we've been trying to come up with contingencies for you, whatever we can do to try and make you comfortable or less uncomfortable. We all appreciate your cooperation. General information. Ladies and gentlemen of the jury, the evidence has been presented and the attorneys have completed their summations. We now arrive at the time when you as jurors are to perform your final function in this case. At the outset, let me express my thanks and appreciation for your time and attention to this case. I'd also like to commend counsel for the professional manner in which they presented their
locking the door a
respective
fire
cases,
hazard?
and for the courtesy that they've shown to each of you. Before you retire to deliberate and reach your verdict, it's my obligation to instruct you on the principles of law applicable to this case. You shall consider my instructions in their entirety and not pick out any particular instruction and overemphasize it. Generally speaking, these instructions consist of 4 parts. The first part deals with the general principles of law that apply to a criminal case. The second part describes the evidence that you may consider in your deliberations. The third part is about those portions of the Criminal Code of New Jersey that you must apply to the facts you find in this case to determine whether the state has proven beyond a reasonable doubt that the defendant violated a specific criminal statute. Finally, the fourth part of the instructions tells you how to go about conducting your deliberations. You must accept and apply the law for this case as I give it to you in this charge. Any ideas you have about what the law is or what the law should be, or any statements by the attorneys as to what the law may be, must be disregarded by you if they are in conflict with my charge. Nature of the indictment. Now, beginning with the general principles of law that
Where are you
apply to
going,
a criminal
Selena?
case, the defendant stands before you on an indictment returned by a grand jury charging him with 2 counts: 1, endangering the welfare of a child, and 2, murder.
We're going to miss
The
you.
indictment is not evidence of the defendant's guilt on the charges. The indictment is a step in the procedure to bring the matter before the court and the jury for the jury's ultimate determination as to whether the defendant is guilty or not guilty of the charges stated in it. The defendant has pleaded not guilty to the charges. Presumption of innocence, burden of proof, reasonable doubt. The defendant on trial is presumed to be innocent, and unless each and every essential element of an offense charged is proven beyond a reasonable doubt, the defendant must be found not guilty of that charge. The burden of proving each element of a charge beyond a reasonable doubt rests upon the state, and that burden never shifts to the defendant. The defendant in a criminal case has no obligation or duty to prove his innocence or offer any proof relating to his innocence. The prosecution must prove its case by more than a mere preponderance of the evidence, yet not necessarily to an absolute certainty. The state has the burden of proving the defendant guilty beyond a reasonable doubt. Some of you may have served as jurors in civil cases, or you may have heard of the civil standard, where you were told that it is necessary to prove only that a fact is more likely true than not true. In criminal cases, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. A reasonable doubt is an honest and reasonable uncertainty in your minds about the guilt of the defendant after you have given full and impartial consideration to all of the evidence in the case. A reasonable doubt may arise from the evidence itself or from the lack of evidence. It is a doubt that a reasonable person hearing the same evidence would have. Proof beyond a reasonable doubt is proof, for example, that leaves you firmly convinced of the defendant's guilt. In this world, we know very few things with absolute certainty. In criminal cases, the law does not require proof that overcomes every possible doubt. If, based upon your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you are not firmly convinced of the defendant's guilt, you must give the defendant the benefit of the doubt and find him not guilty. Function of the court. The function of the judge is separate and distinct from the function of the jury. It is my responsibility to determine all questions of law arising during the trial and to instruct the jury as to the law which applies in this case. You must accept the law as given to you by me and apply it to the facts as you find them to be. During the course of the trial, I was required to make certain rulings on the admissibility of evidence, either in or outside of your presence. Those rulings involved questions of law. The comments of the attorneys on these matters were not evidence. In ruling, I have decided questions of law, and whatever the ruling may have been in a particular instance, you should understand that it is not an expression or opinion by me on the merits of the case. Neither should my rulings on any other aspect of the trial be taken as favoring one side or the other. Each matter was decided on its own merits. I may have sustained an objection or objections to some questions asked by counsel, which may have contained statements of fact. In fact, an attorney asks a question and inserts facts or comments or opinions into that question in no way proves the existence of those facts. You will only consider such facts which, in your judgment, have been proven by the testimony of the witnesses or from the exhibits admitted into evidence by the court. Judges questioning. I don't believe I asked the witnesses any questions, but the fact that I may have asked questions of a witness in this case must not influence you in any way in your deliberations. The fact that I asked such questions does not indicate that I hold an opinion one way or the other as to the testimony given by any witness. Any remarks made by me to counsel or by counsel to me or between counsel are not evidence and should not affect or play any part in your deliberations. Function of the jury. As I instructed you when we started this case, I explained to you that you are the judges of the facts, and as judges of the facts, you are to determine the credibility of the various witnesses as well as the weight to be attached to their testimony. You and you alone are the sole and exclusive judges of the evidence, of the credibility of the witnesses, and the weight to be attached to the testimony of each witness. Regardless of what counsel said or I may have said in recalling the evidence in this case, it is your recollection of the evidence that should guide you as judges of the facts. Arguments, statements, remarks, openings, and summations of counsel are not evidence and must not be treated as evidence. Although the attorneys may point out what they think is important in this case, you must rely solely upon your understanding and recollection of the evidence that was admitted during the trial. Whether or not beyond a reasonable doubt is for you to determine based upon all of the evidence presented during the trial. Any comments by counsel are not controlling. It is your sworn duty to arrive at a just conclusion after considering all of the evidence which was presented during the course of the trial. Now I will move on to the second part of the instructions and discuss the evidence that you may consider in judging the facts of this case. When I use the evidence, testimony of the witnesses that you have heard and seen from this witness box, any evidence and the exhibits that evidence. Any exhibit that has not been admitted into evidence cannot be given to you in the jury room, even though it may have been marked for identification. Only those items admitted into evidence can be given to you. As I indicated to you yesterday, everything, every piece of paper, every tangible document is marked for identification, but only certain ones have been admitted into evidence. So for instance, if a witness testified about something that was marked for identification, the testimony is the evidence, not the exhibit itself. Any testimony that I may have had occasion to strike is not evidence and shall not enter into your deliberations. It must be disregarded by you. This means that even though you may remember the testimony, you are not to use it in your discussions or deliberations. Further, if I gave a limiting instruction as to how to use certain evidence, that evidence must be considered by you for that purpose only. You may not consider it for any other purpose. As jurors, it is your duty to weigh the evidence calmly and without passion, prejudice, or sympathy. Any influence caused by these emotions has the potential to deprive both the state and the defendant of what you promised them, a fair and impartial trial by fair and impartial jurors. Also, speculation, conjecture, and other forms of guessing play no role in your performance of your duties. As jurors,
Lucy.
your oath requires that you not be affected or influenced by any personal likes or dislikes, opinions, prejudices, sympathies, or biases, including implicit or unconscious bias. During your deliberations, if you think you are being affected by unconscious bias in your evaluation, think about the evidence again with the video you saw at the beginning of jury selection and with this instruction in mind. Direct and circumstantial evidence. As I instructed you at the beginning of this case, evidence may be either direct or circumstantial. Direct evidence means evidence that directly proves a fact without an inference, and which in itself, if true, conclusively establishes that fact. On the other hand, circumstantial evidence means evidence that proves a fact from which an inference of the existence of another fact may be drawn. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts established by the evidence. Whether or not inferences should be drawn is for you to decide, using your own common sense, knowledge, and everyday experience. Ask yourselves,
Hi,
is it
Barb. Welcome
probable,
back.
logical, and reasonable? It is not necessary that all facts be proven by direct evidence. They may be proven by direct evidence, circumstantial evidence, or a combination of direct evidence and circumstantial evidence. All are acceptable means of proof. In many cases, circumstantial evidence may be more certain, satisfying, and persuasive than direct evidence. However, direct and circumstantial evidence should be scrutinized and evaluated carefully. A verdict of guilty may be based upon direct evidence alone, circumstantial evidence alone, or a combination of direct evidence and circumstantial evidence, provided, of course, that it convinces you of a defendant's guilt beyond a reasonable doubt. The reverse is also true. A defendant may be found not guilty by reason of direct evidence, circumstantial evidence, a combination of the two, or a lack of evidence, if it raises in your mind a reasonable doubt as to the defendant's guilt. Credibility of the witnesses. As the judges of the facts, you are to determine the credibility of the witnesses, and in determining whether a witness is worthy of belief and therefore credible, you may take the following factors into consideration: the appearance and demeanor of the witness, the manner in which he or she may have testified, the witness's interest in the outcome of the trial, if any, his or her means of obtaining knowledge of the facts, the witness's power of discernment, meaning his or her judgment, understanding, his or her ability to reason, observe, recollect, and relate, the possible bias, if any, in favor of the side for whom the witness testified, the extent to which, if at all, each witness is either corroborated
So
or
he's
contradicted,
bad. He's pursing those
supported
lips.
or discredited by other evidence, whether the witness testified with an intent to deceive you, the reasonableness or unreasonableness of the testimony the witness has given, whether the witness made any inconsistent or contradictory statement, and any and all other matters in the evidence which serve to support or discredit his or her testimony. Through this analysis, as the judges of the facts, you weigh the testimony of each witness and then determine the weight to give to it. Through that process, you may accept all of it, a portion of it, or none of it. Written statements of defendant. There is, for your consideration in this case, various written electronic statements allegedly made by the defendant. It is your function to determine whether or not the statements were actually made by the defendant, and if made, whether the statements or any portion of them are credible. In considering whether or not a statement is credible, you should take into consideration the circumstances and facts as to how the statement was made, as well as all other evidence
Hi,
in the case
Rosalie. Yes,
relating
it
to this
is.
issue. If, after consideration of these
He's
factors,
giving jury
you
instructions
determine
right
that the
now.
statement was not actually made, or that the statement is not credible, then you must disregard the statement completely. If you find that the statement and that part or the statement is credible, you may give what weight you think appropriate to the portion of the statement you find to be truthful and credible. Oral statements of defendant. There is, for your consideration in this case, various oral statements allegedly made by the defendant. It is your function to determine whether or not the statements were actually made by the defendant, and if made, whether the statements or any portion of them are credible. In considering whether or not an oral statement was actually made by the defendant, and if made, whether it is credible, you should receive, weigh, and consider this evidence with caution, based upon the generally recognized risk of misunderstanding by the hearer, or the ability of the hearer to recall accurately the words used by the defendant. The specific words used and the ability to remember them are important to the correct understanding of any oral communication, because the presence or absence or change of a single word may change substantially the true meaning of even the shortest sentence. You should therefore receive, weigh, and consider such evidence with caution. In considering whether or not the statement is credible, you should take into account the circumstances and facts as to how the statement was made, as well as all other evidence in this case relating to this issue. If, after your consideration of all these factors, you determine that the statement was not actually made, or that the statement is not credible, then you must disregard the statement completely. If you find that the statement was made and that all or part of the statement is credible, you may give what weight you think appropriate to the portion of the statement you find to be truthful and credible. Redacted, recorded statement of defendant. There is, for your consideration in this case, a recorded statement allegedly made by the defendant. It is your function to determine whether or not the statement was actually made, and if made, whether the statement or any portion of it is credible. You may consider all the circumstances surrounding the statement in making that determination with the following caution. I instruct you that in this case, certain portions of the recorded statement have not been provided to you. They were redacted or blacked out. You may only consider those portions of the statement which have been admitted in evidence, and must not speculate as to the contents of the omission or the reason or reasons for the omissions. Oral statements of Corey Michelow. There is for your consideration in this case various oral statements allegedly made by Corey to Dr. Nancy Deacon of IV Pediatrics. It is your function to determine whether or not the statements were actually made by Corey, and if made, whether the statements or any portion of them are credible. Normally, our rules of evidence would not allow statements by one witness about what another witness said. Exceptions to that rule, which allow those statements to be admissible for your consideration, but you are to give it or them the weight you deem appropriate. For instance, a statement made in good faith by a person about the person's then existing state of mind, emotion, sensation, or physical condition, including mental feeling, pain, or bodily health, can be admissible. Likewise, a statement that was made in good faith for the purpose of or is reasonably pertinent to a medical diagnosis or treatment and describes medical history, past or present symptoms or sensations, their inception or their general cause, is admissible for your consideration. In considering whether or not an oral statement was actually made by Corey, and if made, whether it or they were credible, you should receive, weigh, and consider this evidence with caution based upon the generally recognized risk of misunderstanding by the hearer, or the ability of the hearer to recall accurately the words used by Corey. The specific words used and the ability to remember them are important to a correct understanding of any oral communication, because the presence or absence or change of even a single word may substantially change the true meaning of even the shortest sentence. And consider such evidence with caution. In considering whether or not the statement or statements are credible, you should take into consideration the circumstances and facts as to how the statement or statements were made, as well as all other evidence in this case relating to the issue, including any prodding or suggestive questioning by Dr. Deacon in her questioning of Corey. If after consideration of all these factors, you determine Corey did not make the statement or that the statement is not credible, then you must disregard the statement completely. If you find that the statement was made and that part or all of the statement is credible, you may give what weight you think appropriate to the portion of the statement you find to be truthful and credible. Defendant's election not to testify. As you know, Christopher Greger elected not to testify at trial. It is his constitutional right to remain silent. You must not consider for any purpose or in any manner in arriving at that the defendant, that fact should not enter into your deliberations or discussions in any manner at any time. Christopher Greger is entitled to have the jury consider all evidence presented at trial. He is presumed innocent whether or not he chooses to testify. Multiple charges. There are two offenses charged in the indictment: endangering the welfare of a child and murder. They are separate offenses by separate counts in the indictment. In your determination of whether the state has proven the defendant guilty of the crimes charged in the indictment beyond a reasonable doubt, the defendant is entitled to have each count considered separately by the evidence which is relevant and material to that particular charge, based upon the law as I am giving it to you in this final jury charge. The state has introduced evidence which it contends supports the charge of endangering the welfare of a child as set forth in count 1 of the indictment, allegedly occurring on March 20, 2021. Included among that evidence is a video from the gym at the Atlantic Heights apartment complex. You may consider this video as evidence of the charge in count 1 and give it what weight you deem appropriate, whether that be great, slight, or none at all. However, you cannot consider evidence in support of count 1, including the video, to make your determination as to whether the state has proven the allegation in count 2, murder, except as expressly set forth in this instruction. As to count 2 of the indictment, murder, evidence of other wrongs, crimes, or acts committed on a different occasion is normally not permitted under our rules of evidence. Our rules specifically exclude evidence that a defendant has committed other crimes, wrongs, or acts when it is offered only to show that he has a disposition or tendency to do wrong and therefore must be guilty of the charged offenses. Before you can give any weight to the evidence of what allegedly occurred on March 20, 2021, you must be satisfied that the defendant committed the other crime, wrong, or act. If you are not so satisfied, you may not consider it for any purpose. However, our rules do permit evidence of other crimes, wrongs, or acts when the evidence is used for specific narrow purposes. In this case, the state has introduced the Treadmill video to demonstrate the defendant's motive, intent, or absence of mistake or accident regarding the murder of Corey, allegedly occurring on April 2, 2021. In other words, the state contends evidence of defendant's conduct on March 20, 2021, the date of the alleged endangering offense, demonstrates the defendant's motive, intent, or absence of mistake or accident on April 2, 2021, the date of the alleged murder. Whether this evidence does in fact demonstrate the defendant's motive, intent, or absence of mistake or accident regarding the alleged murder of Corey is for you to decide. You may decide that the evidence does not demonstrate defendant's motive, intent, or absence of mistake or accident regarding the alleged murder of Corey and is not helpful to you at all. In that case, you must disregard the evidence in your consideration of count 2, murder. On the other hand, you may decide that the evidence does demonstrate defendant's motive, intent, or absence of mistake or accident regarding the alleged murder of Corey and use it only for that specific and limited purpose. However, you may not use the evidence of what occurred on March 20, 2021 to decide that the defendant has a tendency to commit crimes or that he is a bad person. That is, you may not decide that just because the defendant allegedly committed other crimes, wrongs, or acts, he must be guilty of the murder charge. I have admitted the evidence of the defendant's conduct on March 20, 2021 to be considered in connection with the murder charge only to help you decide the specific question of defendant's motive, intent, or absence of mistake or accident regarding the alleged murder of Corey. You may not consider it for any other purpose and may not find the defendant guilty of murder simply because the state has offered evidence that he allegedly committed other crimes, wrongs, or acts on a prior date. Expert testimony. As a general rule, witnesses may only testify as to facts known by them. This rule ordinarily does not permit the opinion of a witness to be received as evidence. However, an exception to this rule exists in the case of an expert witness, who may give his or her opinion as to any matter in which he or she is versed, which is material to the case. In legal terminology, an expert witness is a witness who has some special knowledge, skill, experience, or training that is not possessed by the ordinary juror, and who thus may be able to provide assistance to the jury in understanding the evidence presented and in determining the facts in the case. In this case, the state and defendant have called experts to testify. The state and the defendant called Sergeant Raymond Coles, an expert in digital forensic examination and analysis. The state called Dr. Thomas Andrew, a forensic pathologist, and Dr. Anat Feingold, an infectious disease specialist. Defendant called Dr. Michael Bodden, a forensic pathologist. You are not bound by such experts' opinions, but you should consider each opinion and give it the weight to which you deem it is entitled, whether that be great or slight, or you may reject it. In examining each opinion, you may consider the reasons given for it, if any, and you may also consider the qualifications and credibility of the expert. It is always within the special function of the jury to determine whether the facts on which an answer or testimony of an expert is based actually exist. The value or weight of the opinion of the expert is dependent upon and no greater than the facts on which it is based. In other words, the probative value of the opinion will depend upon whether, from all the evidence in this case, you find that those facts are true. You may, in fact, determine from the evidence in this case that the facts which form the basis of the opinion are true, are not true, or are true in part only. And in light of such findings, you should decide what effect such determination has upon the weight to be given to the opinion of the expert. Your acceptance or rejection of the expert opinion will depend, therefore, to some extent on your findings as to the truth of the facts relied upon. The ultimate determination of whether or not the state has proven the defendant's guilt beyond a reasonable doubt is to be made only by the jury. Deleted internet history and/or text messages. There's been some testimony in this case from which you may infer that the defendant deleted text messages and/or internet history from his phone. The question of whether the defendant deleted anything from his phone is another question of fact for your determination. If you find that the defendant, fearing that an accusation or arrest would be made against him, on the charge or charges involved in the indictment, deleted contents from his phone, then you may consider saying, in connection with all other evidence in this case, as an indication or proof of consciousness of guilt. Deleted internet history and or text messages may only be considered as evidence of consciousness of guilt if you should determine that the defendant's purpose in deleting content was to evade accusation or arrest for the offense or offenses charged in the indictment. There has been some testimony in this case from which you may infer that the defendant deleted some items from his phone. Although he is not required to do so, the defense may provide an explanation for the deletions. If you find that the deletions are not helpful to you in this case, or if you find any explanation by the defense is credible, you should not draw any inference of the defendant's consciousness of guilt from the deleted content. If, on the other hand, after consideration of all the evidence, you find that the defendant, fearing that an accusation or arrest would be made against him on a charge or charge involved in the indictment, deleted items from his phone, then you may consider saying, in connection with all other evidence in this case, as an indication or proof of consciousness of guilt. It is for you, as judges of the facts, to decide whether or not evidence of the defendant allegedly deleting items from his phone shows a consciousness of guilt and the weight to be given to such evidence in light of all other evidence in this case. Internet searches. You have heard testimony and evidence that was admitted that a phone owned by and subscribed to by the defendant was utilized to search the internet using certain internet search terms, and that this occurred on or after April 2, 2021. The question of whether the defendant made these searches is another question of fact for your determination. If you find the defendant, fearing that an accusation or arrest would be made against him on the charge or charges involved in the indictment, made those internet searches, then you may consider saying, in connection with all other evidence in this case, as an indication or proof of consciousness of guilt. Internet searches may only be considered as evidence of consciousness of guilt if you determine that the defendant's purpose in making those searches was to evade accusation or arrest for the offense or offenses charged in the indictment. There has been some testimony in this case from which you may infer that the defendant made certain internet searches from his phone. Although he is not required to do so, the defense may provide an explanation as to these internet searches. If you find that the internet searches are not helpful to you, or if you find any explanation by the defendant is credible, you should not draw any inferences of the defendant's consciousness of guilt from the defendant's internet searches. If, after consideration of all the evidence, you find that the defendant, fearing an accusation or arrest would be made against him on a charge or charges involved in the indictment, made those internet searches, then you may consider saying, in connection with all other evidence, as an indication or proof of consciousness of guilt. It is for you, as the judges of the facts, to decide whether or not the evidence of the defendant making certain internet searches shows a consciousness of guilt, and the weight to be given to such evidence in light of all the other evidence in the case. Flight. There's been some testimony in this case from which you may infer that the defendant fled shortly after the alleged commission of the crime. The defendant denies that his acts constituted flight. The question of whether the defendant fled after the commission of the crime is another question of fact for your determination. Mere departure from a place where a crime has been committed does not constitute flight. If you find the defendant, fearing that an accusation or arrest would be made against him on the charge involved in the indictment, took refuge in flight for the purpose of evading the accusation or arrest on that charge, then you may consider such flight in connection with all other evidence in the case as an indication or proof of consciousness of guilt. Flight may be only considered as consciousness of guilt if you should determine that the defendant's purpose in leaving was to evade accusation or arrest for the offense charged in the indictment. There's been some testimony in this case from which you may infer that the defendant fled shortly after the commission of the crime. Although not required to do so, the defense may provide an explanation for these actions. If you find that the defendant's explanation is credible, you should not draw any inference of the defendant's consciousness of guilt from the defendant's departure. If, after consideration of all the evidence, you find that the defendant, fearing an accusation or arrest will be made against him on a charge involving the indictment, took refuge in flight for the purpose of evading the accusation or arrest, then you may consider such evidence, such flight, in connection with all other evidence in the case as an indication or proof of consciousness of guilt. Again, it is for you, as judges of the facts, to decide whether or not evidence of flight shows consciousness of guilt and the weight to be given to such evidence in light of all other evidence in the case. Now, I will instruct you on the third part of the instructions as to those portions of the criminal code that you must apply to the facts as you determine whether the state has proven beyond a reasonable doubt that the defendant violated a specific criminal statute or statutes. The statute read together with the indictment identifies the elements the state must prove beyond a reasonable doubt to establish the guilt of the defendant on each of the counts in the indictment. Count 1, endangering the welfare of a child, abuse or neglect. New Jersey Statute 2C:24-4, subsection A2. Count 1 of the indictment charged the defendant, Christopher Greger, with endangering the welfare of a child. Count 1 of the indictment reads as follows. The grand jurors of the state of New Jersey, in and for the county of Ocean, upon their oaths, present that Christopher Greger, on or about March 20, 2021, in the township of Barnegat, county of Ocean, and within the jurisdiction of this court, having the legal duty for the care of, or having assumed responsibility for the care of Corey, born May 1, 2014, knowingly did cause harm to Corey, making Corey an abused or neglected child, as defined in revised statutes 9:6-1, 9:6-3, in Public Law 1974, Chapter 119, Section 1, also known as 9:6-8.21. Contrary to the provisions of New Jersey Statute 2C:24-4A2, and against the peace of this state, the government, and dignity of the same. The statute upon which this charge is based reads in pertinent part as follows. Any person having a legal duty for the care of a child.
So they
has
are
assumed
judging the treadmill video.
responsibility for
That's
the
why it's
care
in
of a
there.
child, who causes the child harm that would make the child an
Hi,
abused or
Pat.
neglected child is guilty of a crime. To find the defendant guilty of this crime, the state must prove beyond a reasonable doubt these elements. 1, that Corey was a child. 2, that defendant knowingly caused the child harm that would make the child abused or neglected. 3, that the defendant knew that such conduct would cause the child harm that would make the child abused or neglected. 4, that the defendant had a legal duty for the care of the child or had assumed responsibility for the care of the child.
That makes a lot more sense now, you guys.
The first element the state must prove beyond a reasonable doubt is that Corey was a child. A child means any person under the age of 18 years at the time of the offense. The state must only prove the age of Corey at the time of the offense beyond a reasonable doubt. It does not have to prove that the defendant knew or reasonably should have known that Corey was under the age of 18. The second element the state must prove beyond a reasonable doubt is that the defendant knowingly caused the child harm that would make the child abused or neglected. Various statutes are going to be in the jury instructions for you. New Jersey Statutes 9:6-1 and 9:6-3. Cruelty to a child shall consist in any of the following acts. A, inflicting unnecessarily severe corporal punishment upon a child. B, inflicting upon a child unnecessary suffering or pain, either mental or physical. C, any willful act of omission or commission whereby unnecessary pain and suffering, whether mental or physical, is caused or permitted to be inflicted on a child. D, or exposing a child to unnecessary hardship, fatigue, or mental or physical strains that may tend to injure the health or physical or moral well-being of such child. New Jersey Statutes 9:6-8.21 and 9:6-3. An abused or neglected child means 1, that the defendant inflicted or allowed to be inflicted upon such child physical injury by other than accidental means, which causes or creates a substantial risk of death or serious or protracted disfigurement, or protracted impairment of physical or emotional health, or protracted loss or impairment of the function of any bodily organ. 2, that the defendant created or allowed to be created a substantial or ongoing risk of physical injury to such child by other than accidental means, which would be likely to result in death or serious or protracted disfigurement or protracted loss or impairment of the function of a bodily organ. 3, a child whose physical, mental, or emotional condition has been impaired or is in imminent danger of becoming impaired as the result of the failure of the defendant to exercise a minimum degree of care in providing the child with proper supervision or guardianship by unreasonably inflicting or allowing to be inflicted harm or substantial risk thereof, including the infliction of excessive corporal punishment, or by any other acts of a similarly serious nature requiring the aid of the court. A person acts knowingly with respect to the nature of his conduct or the attendant circumstances if he is aware that his conduct is of that nature or that such circumstances exist, or the person is aware of a high probability of their existence. A person acts knowingly with respect to a result of the conduct if he is aware that it is practically certain that such conduct will cause such a result. Knowing with knowledge or equivalent terms have the same meaning. Knowledge is a condition of the mind. It cannot be seen. It can only be determined from inferences from defendant's conduct, words, or acts. A state of mind is rarely susceptible of direct proof, but must ordinarily be inferred from the facts. Therefore, it is not necessary that the state produce witnesses to testify that an accused said that he had a certain state of mind when he did a particular thing. It is within your power to find that such proof has been furnished beyond a reasonable doubt.
Yes, I saw it yesterday.
Which may arise from the nature of his acts and conduct, and from all he said and did at the particular time and place, and from all the surrounding circumstances established by the evidence. The third element the state must prove beyond a reasonable doubt is that the defendant knew that his conduct would cause the child harm that would make the child abused or neglected. I previously defined the concept of knowing for you just a moment ago. The fourth element the state must prove beyond a reasonable doubt is that the defendant had a legal duty to care for the child or assumed a responsibility to care for the child. A person having a legal duty to care for a child
Lots of similar injuries.
or who has assumed responsibility for the care of a child includes a natural
for
parent,
Dominic
adoptive parent,
Corey.
resource family parent, step parent, or any other person who has assumed responsibility for the care, custody, or control of a child, or upon whom there is a legal duty for such care. A person who has assumed responsibility for the care of a child includes any person who assumes a general and ongoing responsibility for the child, and who establishes a continuing or regular supervisory or caretaker relationship with the child. A general and ongoing responsibility for the care of a child may be legal or formal, or it may arise from informal arrangements. It may be based not only upon a parental relationship or legal custody, but also on a less structured relationship, such as cohabitation with the parent of a child. A person who assumes temporary, brief, or occasional caretaking functions, such as an irregular or infrequent babysitter, would not meet the standards of general and ongoing responsibility for the care of a child. A person who supervises a child on a regular or continuing basis over extended periods of time and engages in matters that are generally committed to the child's parents would meet this standard of general and ongoing responsibility for the care of a child. In determining the nature of the relationship between the defendant and the child, you should consider these factors: the disparity in ages or maturity, the importance of the activity or activities the child supervises, let me rephrase that, the importance of the activity or activities the adult supervises to the child, the extension of the supervising relationship beyond guidance and advice expected given the adult's supervising role, and the degree of dependence and trust the child places in the adult. If the state has proven every element of the offense beyond a reasonable doubt, then you must find the defendant guilty of endangering the welfare of a child. If the state has failed to prove any of the elements beyond a reasonable doubt, then you must find the defendant not guilty. Count 2, murder and aggravated manslaughter, reckless manslaughter. So count 2 is the murder count. I've added to the jury charge aggravated manslaughter and reckless manslaughter. The fact that I have added that is not an expression of opinion by me as to whether or not you should find the defendant guilty or not guilty of those two charges. They're lesser included offenses. The decision as to not guilty or guilty is solely yours. I have no opinion, and if I did, you'd have to disregard it because you are the sole judges of the facts. New Jersey statutes 2C:11-3A1 and 2, 2C:11-4A and B1. Count 2 of the indictment charges the defendant Christopher Greger with murder. Count 2 of the indictment reads as follows. The grand jurors of the state of New Jersey in and for the county of Ocean, upon their oaths, present that Christopher Greger, on or about April 2, 2021, in the township of Barnegat, county of Ocean, and within the jurisdiction of this court, did purposely or knowingly cause the death of, or purposely or knowingly caused serious bodily injury resulting in the death of another, specifically Corey, contrary to the provisions of New Jersey statute 2C:11-3A, and against the peace of this state, the government, and dignity of the same. A person is guilty of murder if he, 1, caused the victim's death, or serious bodily injury that then resulted in death, and 2, the defendant did so purposely or knowingly. In order to find the defendant guilty of murder, the state is required to prove each of the following elements beyond a reasonable doubt. 1, that the defendant caused Corey's death or serious bodily injury that then resulted in Corey's death, and 2, that the defendant did so purposely and knowingly. One of the elements the state must prove beyond a reasonable doubt is the defendant acted purposely or knowingly. A person acts purposely when it is the person's conscious object to cause death or serious bodily injury resulting in death. A person acts knowingly when the person is aware that it is practically certain that his conduct will cause death or serious bodily injury resulting in death. The nature of the purpose or knowledge with which the defendant acted towards Corey is a question of fact for you, the jury, to decide. Purpose and knowledge are conditions of the mind, which cannot be seen and can only be determined by inferences from conduct, words, or acts. It is not necessary the state to produce a witness or witnesses who could testify that the defendant stated, for example, that his purpose was to cause death or serious bodily injury resulting in death, or that he knew his conduct would cause death or serious bodily injury resulting in death. It is within your power to find that proof of purpose or knowledge has been furnished beyond a reasonable doubt by inferences, which may arise from the nature of the acts and the surrounding circumstances. Such things as the place where the acts occurred, the location, the number and nature of wounds inflicted, and all that was done or said by the defendant preceding, connected with, and immediately succeeding the events leading to the death of Corey are among the circumstances to be considered. Although the state must prove the defendant acted either purposely or knowingly, the state is not required to prove a motive. If the state has proved the essential elements of the offense beyond a reasonable doubt, the defendant must be found guilty of that offense, regardless of the defendant's motive or lack of motive. If the state, however, has proved a motive, you may consider that insofar as it gives meaning to other circumstances. On the other hand, you may consider the absence of motive in weighing whether or not the defendant is guilty of the crime charged. The other element the state must prove beyond a reasonable doubt is that the defendant caused Corey's death or serious bodily injury resulting in death. As I previously advised you, in order to convict the defendant of murder, the state must prove beyond a reasonable doubt that the defendant either purposely or knowingly caused the victim's death or serious bodily injury resulting in death. In that regard, serious bodily injury means bodily injury that creates a substantial risk of death. A substantial risk of death exists where it is highly probable that the injury will result in death. In order for you to find the defendant guilty of purposeful, serious bodily injury murder, the state must prove beyond a reasonable doubt that it was defendant's conscious object to cause serious bodily injury that then resulted in the victim's death. That the defendant knew that the injury created a substantial risk of death and that it was highly probable that death would result. In order for you to find the defendant guilty of knowing serious bodily injury murder, the state must prove beyond a reasonable doubt that the defendant was aware that it was practically certain that his conduct would cause serious bodily injury that then resulted in the victim's death. That the defendant knew that the injury created a substantial risk of death and that it was highly probable that death would result. Causation has a special meaning under our law. To establish causation, the state must prove two elements beyond a reasonable doubt. First, that but for the defendant's conduct, Corey would not have died. Second, Corey's death must have been within the design or contemplation of the defendant. If not, it must involve the same kind of injury or harm as that designed or contemplated, and must also not be too remote, too accidental in its occurrence, or too dependent upon another's volitional act to have a just bearing on the defendant's liability or on the gravity of his offense. In other words, the state must prove beyond a reasonable doubt that Corey's death was not so unexpected or unusual that it would be unjust to find the defendant guilty of murder. Here, the state alleges Corey died of blunt impact injuries of the chest and abdomen, with laceration of the heart, left pulmonary contusion, and laceration and contusion of the liver, and the manner of death was homicide. In contrast, the defense alleges Corey died of Staphylococcus aureus pneumonia, with resulting sepsis and seizures, and the manner of death was natural. All jurors do not have to agree unanimously concerning which form of murder is present, as long as all believe that it is one form of murder or another. However, for a defendant to be guilty of murder, all jurors must agree that the defendant either purposely or knowingly caused death or serious bodily injury resulting in death of Corey. If you determine that the state has proven beyond a reasonable doubt that the defendant purposely or knowingly caused death or serious bodily injury resulting in death, you must find the defendant guilty of murder. If, on the other hand, you determine that the state has not proven beyond a reasonable doubt that the defendant acted purposely or knowingly in causing the death or serious bodily injury resulting in death, you must find the defendant not guilty of murder, and then go on to consider whether the defendant should be convicted of the crimes of aggravated manslaughter or reckless manslaughter. A person is guilty of aggravated manslaughter if he recklessly causes the death of another under circumstances manifesting extreme indifference to the value of human life. In order to find the defendant guilty of aggravated manslaughter, the state is required to prove each of the following elements beyond a reasonable doubt. 1, that the defendant caused Corey's death, and 2, that the defendant did so recklessly, and 3, that the defendant did so under circumstances manifesting extreme indifference to human life. One element the state must prove beyond a reasonable doubt is defendant acted recklessly. A person who causes another's death does so recklessly when he is aware of and consciously disregards a substantial and unjustifiable risk that death will result from his conduct. The risk must be of such a nature and degree that, considering the nature and purpose of defendant's conduct and the circumstances known to defendant, his disregard of that risk is a gross deviation from the standard of conduct that a reasonable person would follow in the same situation. In other words, you must find that the defendant was aware of and consciously disregarded the risk of causing death. If you find the defendant was aware of and disregarded the risk of causing death, you must determine whether the risk that he disregarded was substantial and unjustifiable. In doing so, you must consider the nature and purpose of defendant's conduct and the circumstances known to defendant. And you must determine whether, in light of those factors, defendant's disregard of that risk was a gross deviation from the conduct a reasonable person would have observed in defendant's situation. Another element the state must prove beyond a reasonable doubt is the defendant acted under circumstances manifesting extreme indifference to human life. The phrase, under circumstances manifesting extreme indifference to human life, does not focus on defendant's state of mind, but rather under the circumstances under which you find he acted. If, in light of all the evidence, you find that the defendant's conduct resulted in a probability as opposed to a mere possibility of death, then you may find that he acted under circumstances manifesting extreme indifference to human life. On the other hand, if you find that his conduct resulted only in a possibility of death, then you must acquit him of aggravated manslaughter and go on to consider the offense of reckless manslaughter, which I will explain to you shortly. The final element the state must prove beyond a reasonable doubt is the defendant caused Corey's death. Again, causation has a special meaning under our law. To establish causation, the state must prove two elements, each beyond a reasonable doubt. First, that but for Corey's, strike that. First, that but for defendant's conduct, Corey would not have died. Second, Corey's death must have been within the risk of which the defendant was aware. If not, it must involve the same kind of injury or harm as the probable result of the defendant's conduct, and must also not be too remote, too accidental in its occurrence, or too dependent upon another's volitional act to have a just bearing on the defendant's liability or on the gravity of his conduct. In other words, the state must prove beyond a reasonable doubt that Corey's death was not so unexpected or unusual that it would be unjust to find the defendant guilty of aggravated manslaughter. Here, the state alleges Corey died of blunt impact injuries of the chest and abdomen, with laceration of the heart, left pulmonary contusion, and laceration and contusion of the liver, and the manner of death was homicide. In contrast, the defense alleges Corey died of Staphylococcus aureus pneumonia, with resulting sepsis and seizures, and the manner of death was natural. If, after consideration of all the evidence, you are convinced beyond a reasonable doubt that defendant acted recklessly, caused Corey's death under circumstances manifesting extreme indifference to human life, then your verdict must be guilty of aggravated manslaughter. If, however, after consideration of all the evidence, you are not convinced beyond a reasonable doubt that the defendant recklessly caused Corey's death under circumstances manifesting extreme indifference to human life, you must find the defendant not guilty of aggravated manslaughter, and then go on to consider whether the defendant should be convicted of reckless manslaughter. Excuse me. A defendant is guilty of reckless manslaughter if he recklessly causes the death of another person. In order for you to find the defendant guilty of reckless manslaughter, the state is required to prove each of the following elements beyond a reasonable doubt. One, that the defendant caused Corey's death, and two, that the defendant did so recklessly. One element the state must prove beyond a reasonable doubt is that the defendant acted recklessly. A person who causes another's death does so recklessly when he is aware of and consciously disregards a substantial and unjustifiable risk that death will result from his conduct. The risk must be of such a nature and degree that, considering the nature and purpose of defendant's conduct and the circumstances known to defendant, his disregard of that risk is a gross deviation from the standard of conduct that a reasonable person would follow in the same situation. In other words, you must find the defendant was aware of and consciously disregarded the risk of causing death. If you find the defendant was aware of and disregarded the risk of causing death, you must determine whether that risk that he disregarded was substantial and unjustifiable. In doing so, you must consider the nature and purpose of defendant's conduct and the circumstances known to defendant. And you must determine whether, in light of those factors, defendant's disregard of that risk was a gross deviation from the conduct a reasonable person would have observed in defendant's situation. The other element the state must prove beyond a reasonable doubt is that the defendant caused Corey's death. Again, causation has a special meaning under our law. To establish causation, the state must prove two elements, each beyond a reasonable doubt. First, that but for the defendant's conduct, the victim would not have died. Second, Corey's death must have been within the risk of which the defendant was aware. If not, it must involve the same kind of injury or harm as the probable result of the defendant's conduct, and must also not be too remote, too accidental in its occurrence, or too dependent upon another's volitional act to have a just bearing on the defendant's liability or on the gravity of his offense. In other words, the state must prove beyond a reasonable doubt that Corey's death was not so unexpected or unusual that it would be unjust to find the defendant guilty of reckless manslaughter. Here, again, the state alleges Corey died of blunt impact injuries of the chest and abdomen, with laceration of the heart, left pulmonary contusion, and laceration and contusion of the liver, and the manner of death was homicide. In contrast, the defense alleges Corey died of Staphylococcus aureus pneumonia with resulting sepsis and seizures, and the manner of death was natural. If, after consideration of all the evidence, you are convinced beyond a reasonable doubt that the defendant acted recklessly and caused Corey's death, then your verdict must be guilty of reckless manslaughter. If, however, after consideration of all the evidence, you are not convinced beyond a reasonable doubt that the defendant recklessly caused Corey's death, you must find the defendant not guilty of reckless manslaughter. Deliberations. I will now give you some information on the final part of these instructions regarding how to conduct your deliberations. There is nothing different in a way a jury is to consider proof in a criminal case from that in which all reasonable persons treat any questions depending upon evidence presented to them. You are expected to use your own good common sense. Consider the evidence for only those purposes for which it has been admitted and give it a reasonable and fair construction in light of your knowledge as to how people behave. It is the quality of the evidence, not simply the number of witnesses, that control. As I said before, any exhibit that has not been
Hi,
marked into
Susan.
evidence
We're going to
cannot be
go
given
over
to you
it.
in the jury
You'll
room,
see.
even though it may have been marked for identification. Only those items marked into evidence can be given to you. Very shortly, you'll go into the jury room to start your deliberations. I remind you that during your deliberations, and in fact, any time that you are in the jury deliberation room, you must not have any cell phone, pager, or other communication or electronic device with you. You are to apply the law as I have instructed you to the facts as you find them to be, for the purpose of arriving at a fair and correct verdict. The verdict must represent the considered judgment of each juror and must be unanimous as to each charge. That means all of you must agree if the defendant is guilty or not guilty on each charge. It is your duty as jurors to consult with one another and to deliberate with a view towards reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views or change your opinion if you are convinced it is erroneous, but do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You are not partisans, you are judges of the facts. Unanimous verdict. You may return a verdict on each crime charged, a verdict of either not guilty or
Hi,
guilty. Your verdict,
Peregrine. How are
whatever it
you?
may
Welcome.
be as to each crime charged, must be unanimous.
We're going
Each
to
of
talk
the
about it,
12
Susan.
members
I'm
of the
going to
deliberating
be
jury must agree as to
hold
the
out
verdict.
juror. You guys are going to be whatever you want to
Written
be.
copy of the instructions.
I'm going
As
to be
you
bad
obviously
person.
can tell, I have been reading these legal instructions to you. I'm going to give you 2 written copies of the instructions a few minutes after you get into the jury room for your use during deliberations. And you're allowed to write on them or highlight them or mark them up. Be aware that you must consider these instructions in their entirety and that I am available to assist you in understanding these instructions if you need any assistance. Also, please do not rely on the subheadings in these written instructions. They do not add anything to the explanations that I have given at great length here today, and their only purpose is to help you, me, and the parties find appropriate topics covered in these instructions. Alternates. In the next few moments, the clerk will place slips in a old-fashioned style lottery drum bearing each of your numbers. After thorough mixing, they'll be withdrawn the numbers of those who will be eliminated from the jury box, leaving only 12. Those persons eliminated will serve as alternate jurors. They'll be kept separate and under supervision of the court during the time the jury is deliberating. This is to ensure the availability of jurors should any juror then deliberating be unable to continue for whatever reason before a verdict is reached. As such, each one of those eliminated will be selected by lot, and placed within at such time, I meant to say, in other words, if one of you can't continue, at such time, one of those eliminated will be selected by lot and placed within the jury room, which, after being given additional appropriate instructions, will begin to deliberate again. At the present time, juror number 1 is the foreperson. If she is eliminated by lot, juror number 2 will become the foreperson. Whoever that may be, that person is charged with the duty to maintain reasonable decorum in the jury room, to give everyone an opportunity to be heard on all matters which must be discussed and evaluated, and to take whatever ballots are necessary to determine whether the jury has arrived at a unanimous verdict, and may be called upon by the clerk of the court to announce the verdict probably be called upon by me actually to announce the verdict. To do as the foreperson is give us the answer of not guilty or guilty. I will read the jury verdict sheet, which I'm going to go over in a minute, and you just give us the jury's unanimous answer. I'm not going to ask you to read a whole long paragraph. So there's no reason to
Yeah,
be
Peregrine, we don't
alarmed.
know when the verdict will come in. It could
To
probably
assist
come
you
in
in arriving at
today
the verdict,
or
I
tomorrow.
prepared
It
a
just
verdict
depends on
sheet
how
for
long the
you.
jury
You
deliberates.
can have one copy of this verdict sheet in the jury room with you, and only one. Don't write on it or make any notes on it other than your conclusions as to not guilty or guilty. The verdict form itself is not evidence. The form is to be used only by you in reporting your verdict. In order to explain it to you, I'm going to have Corporal Bennett hand out 15 copies right now. We're going to go over it together, but immediately upon the end of that, you're going to turn in all
Peregrine,
15
am I
copies.
saying your
and you're
name
going to have
right?
one copy in the
Peregrine?
jury room. So based upon the instructions, we short one? Oh, God, good.
Also,
So
keep
based
in
upon
mind,
the
one of the
instructions
jurors
I've
has a
given you,
wedding to go
question
to
one,
this
how do you
afternoon.
find is to count one, endangering the welfare of a child? The jury foreperson would check the unanimous answer of the jurors of either not guilty or guilty. You then go on to question two. How do you find is to count two, murder? The jury foreperson would then check the unanimous answer of the jurors as to not guilty or guilty. Only if your answer to count two is not guilty would you move on to question three. If you found guilty on two, you would stop your deliberations and you would return the verdict. But if you found not guilty on two, you would then move on to question three. Three, how do you find as to the charge of aggravated manslaughter? The foreperson would check the unanimous answer of not guilty or guilty. Only if you found not guilty as to three would you move on to four. How do you find as to the charge of reckless manslaughter? Foreperson would check the unanimous answer of not guilty or guilty. And again, that's a court exhibit. It's marked as C14. So you're going to have the one with the exhibit tab. Madam foreperson, please keep that in a safe place. You can make notes on what you're going to have in there. Plenty of notepads, highlighters, pens, big pads, small pads. All that's your personal property. At the end of the day, if you're still deliberating on recess, I'm going to have you come back out. I'm going to instruct you to stop your deliberations. I'm going to hand the foreperson a key. You're going to put all of the evidence and all of your notes in that black metal filing cabinet. You're going to lock it up and come back out here. You're going to tell me on the record that it's locked and the key's going to be turned over to me. I'll keep the key in a locked compartment overnight. And that way the room can be cleaned, hopefully, and the evidence won't be touched or disturbed. We're not permitted to see your notes. Your notes are confidential, so don't leave them out or anything like that. In fact, if you want to throw out some notes, I'd say just throw them in the evidence cabinet, and then after the
Well, they have a lot to
deliberations are over
consider.
and you reach a
So
verdict,
now
at
that they've
that point,
added these
we
extra
would shred
possibilities.
your notes. Jury's questions. If during your deliberations you have a question or feel that you need further assistance or instructions from me, or if you wish to have certain testimony read or played back, or video or audio exhibit played back, write your question or request on a sheet of paper and give it to the sheriff's officer who will be standing outside the door. Actually, slide it under the door and knock. Give it that, and the officer will pick it up, who in turn will give it to me. That officer and all the
Yeah, see,
officers
Julie, you probably already know, even on a minor case,
such as
it takes a
keeping the
while
jury together in a
decide.
private place for the purposes of deliberations and ensuring that no one speaks to you except by order of the court. You are not to discuss with or ask the officer about trial matters or procedures. And please be aware that the officer and officers have also been instructed not to communicate with you or to enter the jury room without your consent, except to communicate on my behalf regarding administrative matters, such as information about breaks or meals, or otherwise to ensure your comfort. If the officer must enter the deliberation room, the officer will knock first and complete his or her responsibilities without delay. When the officer enters the room, please stop your deliberations and do not resume until the officer has left and closed the door.
Oh, Peregrine,
If you send out a note
Paul
or
is from
request,
another trial from a
once I
while back,
receive
Paul
that, I'm
Ferguson.
going to go over with the lawyers on the record, and we'll try to discuss and answer as quickly as possible. But please, I ask you to be patient, because if you're deliberating for a substantial period of time, I'm not going to make everyone just sit here. I'm going to probably tell the lawyers they can go somewhere else, work on their computers, return phone calls, and those kind of things. So it may take me some time to call everyone back here. So I've had cases in the past where there's a knock on the door and 30 seconds later they're saying, what's
You
going
were on
on?
the
How come
Christopher
you're not
Greger
coming out
trial.
yet? So I'm going to work as quickly as possible, but you may be in there for as long as you like. Could be hours. So I just don't make everyone sit here. I want you to appreciate that. In addition, please do not send out if you send out a note, do not disclose where you stand on deliberations. Do not tell us, for example, that you're 10-2 or 8-4 or anything else on a given charge. If you reach a unanimous verdict on each charge, the foreperson should write a note saying, quote, "We have reached a verdict," close quote, and not what the verdict is. Knock on the door, slide it under the door. The sheriff's officer will then pick it up, advise me you've reached the verdict, and then we'll bring you back in as soon as possible. But as you know, if you haven't noticed, we've had cameras and media here. So they're going to want some time to set back up. So it may take me several minutes to get everything organized to bring you back in. A couple of issues about notes.
I think it just depends on the state,
Generally speaking, notes should come from the foreperson. If you go in there, I don't want you to send me out
what
8
they
notes right
allow,
away with all these questions. That's the idea of deliberations. It is your
because the
collective
judge mentions
recollection of the
every day
evidence that
before
controls
court
it.
that he's
So
properly
to the extent
dressed.
you initially have questions, you should be discussing those questions with your fellow jurors. That's part of the process of deliberating. If after some time,
I mean, he is
collectively,
innocent until
you feel
proven
you have a
guilty. So
question,
even though he's
that's
being
when the
held because
foreperson
he's a
should be
flight
writing a
risk,
note, "We, the jury, have a question about such
they
and
do
such,"
want him to be
whatever that may
properly
be. Or
dressed
we, the
for
jury,
court.
would like to hear an instruction again. You know, you have a copy of it. You may want me to read it. That sometimes happens. Or you may have some other question. So generally, individual jurors should not be writing a note to me unless it's something about you personal. You have a commitment, you have to leave by a certain time, or you have some other problem, or you're not feeling well, or something like that.
Let's go, Judge.
Oh, so it's about 10:34. It's up to you as to breaks. So if you feel you want a lunch break, absolutely, you're entitled to that. We bring you out here, I have to instruct you in the court. You must now cease your deliberations. Don't discuss the case. Don't do research. You can go to lunch and then come back. You just feel like it's getting too hot in there, or you're getting cooped up, you want some fresh air. Just let us know that. We want to take a break for 15 minutes, go outside, go do things, whatever. We'll arrange that for you. We'll make sure sheriff's officers escort you outside so no one else comes up to you and tries to speak to you. But whatever we can do for your comfort. And then obviously, if you're deliberating in the afternoon, you reach a point, you may tell us, listen, we're done for the day. You're not obligated to stay here to a certain time. So if at 3 o'clock in the afternoon, you're like, listen, we're exhausted, we want to go home and come back tomorrow, then simply tell us that. If you want to stay later, you can certainly tell us that too. So you generally should give us some guidance. So feel free to send a note saying, we're comfortable right now, we want to continue to deliberate it. We're uncomfortable, we need such and such, and we'll address that. Each note I mark as a court exhibit, and I go over with the attorney so they're aware of that. I've now come to the end of my charge.
Thank goodness.
I'd ask to see the attorneys at sidebar.
Okay. They're never going to be able to send notes if they don't get put in the jury room. Okay. So we have 4 different counts they get to consider. Okay. So let's start with, so now this makes sense why the treadmill video was in, right? So I've been saying this whole time that we didn't need that the jury, that treadmill video is ingrained in their mind this whole time. And I thought it was in there just to show a pattern of his behavior. But it's actually a charge. So there is a reason then that the treadmill video is in there. They are actually charging him with abuse. So it's not actually something that they were using to taint or show prejudice towards him. The count 2 of murder. So they have to prove beyond a reasonable doubt that he knowingly and with purpose killed Corey, right? That carries a 30 to life sentence. I am going to be the bad guy here and say, I do not believe that they proved beyond a reasonable doubt that he killed Corey with purpose and knowingly killed him, because otherwise he wouldn't have taken him to the hospital. He wouldn't have, he would have, there would be more, I guess, showing injuries to him. So I feel like, I don't think they have beyond a reasonable doubt evidence. Like there wasn't solid evidence for that to show. But I'm going to tell you guys, if they charge him with not murder and the other charges, aggravated manslaughter or reckless manslaughter, you're going to be very disappointed, because the aggravated manslaughter sentence is only 10 to 30 years. And the reckless is 5 to 10 years in New Jersey. And the prosecution has to prove beyond a reasonable doubt that he did knowingly act recklessly with disregard and risk of death and gross deviation, and was aware that he was going to cause death with his behavior. So the aggravated manslaughter shows that he was aware that his actions would cause death. So you guys can tell me what you think about
We
that.
found one or two typos, so we're going to correct those, print it out again, and then give you 2 copies. So that's going to take a few minutes. The attorneys are going to put the evidence in a box, so the evidence is going to go in there. I think in the summations, one of the attorneys said, you can go play the video as many times as you want in the jury room. You can't do that. First, you don't have a video player, but secondly, our rules require that any playbacks of video or audio and any readbacks of testimony occur in open court. So if you do want to see the audio visual exhibit, that would be a note you send to me, and then we play it here for you. And I don't care if you say you want to play 10 times, 25 times, you're entitled to that. So don't hesitate to say that. If you have an issue where you want to go up to close to the screen or something like that, whatever assists you. During the section on deliberations, I apparently said the word or rather than and. So I'm going to read you that paragraph again with the correct word. It is your duty as jurors to consult with one another and deliberate with a view towards reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourselves, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of reaching a verdict. You are not partisans, you are judges of the facts. All right, anything else from counsel?
No, Your Honor.
All right, ladies and gentlemen, so if you go in to the jury room and help yourself, I tried to bring some things, absolutely. I tried to bring some things in for you today.
Alter.
Yeah. Oh, we got to pick all, that's right, yes, we got to pick all. I always forget this, we have swearing officers too. But what I did is I brought extra bagels so we can take them back with the alternates over to jury assembly and give the jury assembly people some things too. So this is the part I hate the most because you've been wonderful. You've all been attentive. You've put up with our unique and challenging scheduling issues, which you really
I'll
did.
say.
So, but this is a necessity. As you know, we lost one person, and it's a credit to all of you. I think the lawyers will agree with me that 15 of you have managed to start in April and we're on the verge of the end of May. So
He's
but
about
it's a
to
necessary
excuse some
process.
jurors.
So I apologize in advance for it. Madam Clerk is going to spin the wheel, the drum, and we're going to pick out 3 numbers, not names.
And who knows if the one that has that wedding to go to is going to get picked.
Juror number 13. Juror number 11. Juror number 4.
All right, so again, I apologize. So respectfully, if I could ask you to come out of the jury box. If I could ask everybody to slide over in the front row. If you could have a seat in the front row. So the 3 of you can go back to jury assembly in a moment. You can have your phones. And then if there's any notes or questions, we bring you over here each time,
13.
as well as when there's a verdict, we bring you over here each time to watch. So again, I apologize, but feel free to do whatever you can do over in jury assembly. You can take your phones and have a seat.
Your Honor, I think I might be able to use 11. Would you be okay with that?
Whatever you prefer. I mean, there's TV and jury assembly, right? So whatever you prefer.
No, this way. Oh,
You get stuff in the jury room? Well, you can go in there if you want. After, yeah, you can go in there after we're done. But
Just come sit.
yeah, just come sit for a minute. You can go in there and get your stuff because it's going to be a few minutes before you get the exhibits and
Some bagels.
the typos correct and all that. Yeah, exactly.
Right here.
So you have the oath. Yes. So next, we're going to swear the officers in who are going to prevent anyone from disturbing you or bothering you, be there for your aid. There's going to be an officer outside that door at all times. Officers, would you please raise your right hands? Madam Clerk.
Do you solemnly swear that you will do the best of your ability to keep every person on the street together in a private place, and that you will not allow any person to speak to them except by order of the court?
Sergeant Dugan.
I do.
Corporal Bennett.
I do.
Officer Kennedy.
I do.
Officer Smith.
I do.
If you could go in the jury room, and the officers want to go in the jury room, briefly get your stuff or grab a bagel. But we also have bagels going over to jury assembly.
Bagels for everyone.
Thank you so much for your
Sorry,
patience.
guys, I don't have bagels.
Yeah, we should put it in a box. That way they have something to put it into. We have the extra box.
Okay, so
Judge, do you want me to send a flash drive?
you guys all agree that you don't think it's murder, right? So I guess we all agree we don't think it's murder. So again, like I said yesterday, the reason they threw those other lesser charges in,
You use your phone, sir? Juror number 12?
Yes.
All right, counsel, you want any specific instruction on that, or?
Judge, stays fine with that, Judge. No.
I think out of an abundance of caution, we should probably give it.
So, juror number 12, you can clearly use your phone for the hearing aid, but you can't use your phone for any research or to look anything up, all right? You understand that instruction, sir? Thank you very much. Officer Bennett will get it for you.
I think we should just, that way it doesn't get lost.
yeah, so you think it's murder, Susan? Okay, so the differentiation between the murder, the aggravated manslaughter, and the reckless. Okay, so murder, it has to be intentional. He purposefully and knowingly killed Corey. He had to basically get up that day and know he was going to kill that child. So they had to prove beyond a reasonable doubt that he purposefully and with intent killed Corey. Which I don't believe he purposefully, willfully, knowingly killed Corey. I believe he abused Corey. I don't believe they proved beyond a reasonable doubt that he knowingly and purposefully killed him. I think that he did abuse him, and his abuse went too far. I believe he wanted to punish Corey as a way to punish his mother and show his dominance or what have you.
Jury's in the jury room. Alternates are on the way back.
No, thank you, Your
There
Honor.
you go.
All right, thank you. I'm just going to correct those typos we found, and we'll get this copied and bring it out.
Thank you, Judge.
But also with the aggravated manslaughter, they have to prove beyond a reasonable doubt that he acted with disregard for risk of death and was aware that his actions would cause death. So they have to prove that beyond a reasonable doubt as well. And that is a 10 to 30 years sentence. For reckless manslaughter, which is only a 5 to 10 year sentence, they have to prove beyond a reasonable doubt that his conduct was reckless and that he was aware and had disregard for Corey's well-being and life. So they kind of are similar, but one has a lesser sentence than the other. Yeah, I think a lot of people agree it's murder, but do we agree that, do you guys agree that the prosecution beyond a reasonable doubt? So it has to be proven beyond a reasonable doubt that he did murder. So, yeah, so his searches, right? So, okay, but those came after Corey died. So he fled the scene, right? He did take Corey to the hospital because he was like, holy crap. I think it was panic mode at that moment. It was like, what did I do? I went too far. I got to take him to the hospital. So he takes him to the hospital. Corey dies. He flips out. He freaks out. He leaves. And so then he does the searches. What happens? What will happen next? So then he does those searches. So I mean, his actions after obviously shows that he's concerned that it's going to get pinned on him, right? But he didn't look up anything prior to. You know, most of these cases we have some searches prior to, like what will happen if they take too much Benadryl, or what will happen if they get to hit too hard here or there. But a lot of these searches were after, so he knew what he did to him before. That's true. He did kill him. But is it murder or is it manslaughter? Hi, Conchita. Welcome. Or it could be deflection, Conchita. He could be. Hi, Claudette. Welcome. Yeah, it's going to be a hard choice in that jury room, because since they've added these extra possibilities, and like I said, prosecution does that when they know that they don't have a full solid case. They give the jury options to choose. So you can't go in full swinging, with murder one, basically. It's either murder or nothing. If they had to do that, and since they have the treadmill, the count one, the endangering and abuse with the treadmill video, of course they're going to get him on that. And then you have count two, murder, and then it's nothing else. They had to throw in those others to give the jury options, because I think it's kind of a catch-22 for the prosecution. Did they prove murder beyond a reasonable doubt? And you guys, let me know your thoughts, because I really want to. Murder is 30 to life. Aggravated manslaughter is 10 to 30 years. Reckless is 5 to 10 years. So this guy could still see the light of day. He's only 31, right? Someone said he's young. He could get out. And that's crazy talk. Yeah, but there's a possibility. I mean, he is going to go to jail, but he could still get out. And he's young. They could find him guilty on all counts. Yeah, that would be up to the judge. So apparently the jury does not decide the sentence, because he didn't give them that. And unless the jury knows, obviously I was able to look up. So here we know, we have knowledge the jury doesn't, unless they looked it up. So again, obviously all these breaks in time that the jury has had, I feel like they know some stuff that they're not saying. But obviously the judge is going to be the one who hands down the sentence. But we have knowledge of what the sentences are for each charge. So they could find him guilty on one, or all, or none. Yeah, some places the jury gets to decide, which is, I see that on some states do that, which is a lot of responsibility. So not only do you have to decide their fate, you have to decide how long they spend in prison, which is a huge responsibility. Yeah, the defense did say it was not Breonna's fault, but they also tore her down terribly. So who knows when the jury's going to actually get to start deliberating. I wonder if they're already talking about it, even though they don't have the corrected paperwork and stuff.
Fox is the evidence in the case?
Yes, Your Honor.
Yes, Your Honor. Corporal Bennett, would you please provide the evidence to the jury?
Oh, now they're getting the evidence.
10:51 a.m.
Oh yeah, for sure. We don't see everything. I mean, there's that, I know a lot of YouTubers out there do the whole Freedom of Information Act. So you can get stuff. I don't usually do that. I never have done that actually. I thought about doing it for the Preston Lord case. There's like 1,400 pages in the police report for the Preston Lord case in Arizona. But a lot of YouTubers out there do get information. They can get police reports. You can get all kinds of stuff. But I want to hear it kind of at the same time the jury's hearing it. So I can actually be sort of what I say, the alternate point of view. But then again, at the same time, I also get to hear stuff outside the jury that the jury doesn't get to hear. We all do when we're watching these trials. So I don't know if anyone has paid attention. I haven't really paid attention, to be quite honest with you, with the Trump thing, but the jury is deliberating for the Trump trial right now. Oh, the hush money. Hush money. And Daniel Garcia was found guilty yesterday. I don't know when they're going to sentence him. And I guess Karen Reed, I guess they're not having trial today for her again. So if you guys were in the jury, if we're in the jury room, we're talking about Christopher Greger. We're looking at murder. We're looking at aggravated manslaughter or reckless manslaughter. I know a lot of jury go back in there and they say, okay, let's get a vote. A lot of them do the vote first. How many vote guilty? How many vote not guilty? I think that's kind of where they first go. Yeah, I heard something about De Niro going nuts, but you know, he's a famous. I think people should just do their job and act and stay out of politics, but whatever. How many would be going for? So, I mean, I don't feel like he intentionally killed Corey. I think it was. Oh, that's true, Susan. Did he rape her? Hi, Joni. How are you? Welcome. You say guilty beyond a reasonable doubt for murder, or what? Which charge? Oh, thank you, Rosalie. I appreciate it. So, what are your thoughts, Joni? We haven't heard from you yet. So, what's your guilty beyond a reasonable doubt? Which charge? For murder, aggravated manslaughter, or reckless manslaughter? Which charge do you think, Gwen? Then the aggravated manslaughter or the? I didn't hear the rape either. I want to hear more about that. So they didn't date. That she, how did? Oh, she said it wasn't consensual. Okay, that's interesting. I need to research more on that then. That would match his personality, actually. Did you see the post on the Justice for Corey? I shared it on my Facebook. It's so sad. Yeah, I don't know what the laws are in New Jersey. I mean, I'm from Alabama, y'all, so. So on the Justice for Corey, she said, one day Corey asked me why his dad didn't love him. How do you answer a 6-year-old that asked that? All I could say to him was, I love you enough for both of us, buddy. Can't wait for you to rot in hell, Christopher. And it has a adorable picture of Corey with his little thumbs up and his winter coat on a fence. I just can't believe that this child was perfectly fine until his father came into his life. Hi, Keezy. Is it Kezi or Keezy? Welcome to the chat. Welcome, everybody who's joined the alternate point of view. Liver is pretty tough, I guess. I mean, I don't know much about the insides, but I looked up a picture. It's weird. The body is weird how all that stuff is crammed in there. You got to do some damage to get there. So I don't know. I think the prosecution did a good job of explaining that the laceration on the heart was not like a blatant laceration. And I also felt better about how she explained the CPR was not 49 minutes continuously. Obviously, they did get a pulse and they had enough time to go get a CT scan. And were able to show that they did pediatric CPR, not like adult CPR on him. So a lot of things were explained that were not explained during testimony quite clearly. Also, because there were so many breaks. Thank you, Susan. So many breaks in the trial. Even I forgot a lot of things. Also because I'm watching so many other trials too. But think about it. The jury was out so many days. They had so many breaks. I think those closing arguments were very, very important to piece it all back together. So she did a great job. Yeah, it was awesome the way she was able to bring it back. Because y'all, I don't know about you guys, but my memory is not what it used to be. So it was very relevant for her to bring all that back, because I certainly did not remember. Yeah, we have a good group in here. I really like it. Once it gets bigger, I'm going to have to start having moderators. So anybody who wants to be a moderator at some point in time when we do more lives, let me know. But right now we got a good thing going. Nothing but good vibes in here. I like it. Yeah, she knocked that out right away, right in the beginning. So that was good. I thought about it a lot. I was talking to a friend of mine last night, and I thought about it a lot. What the way that defense attorney was laying into Brianna, and I was just like, I was talking to my sister actually about it, and I said, I don't know what anyone expected of her. She had her child his whole life, and then within 3 months, she lost her child. What do you expect someone to do who has lost the most important thing in her world? I mean, how can you blame her for going down the wrong path? I mean, who is to judge that? So I felt so awful for her to have that continuously just beat down. No one is perfect. So I think that was really cruel of him to continuously beat her down for that. I can't imagine. I mean, I can't imagine actually, because people have been people have been through some stuff. So to have your child taken for no reason, especially to people who don't even know him, that's horrible. So yeah, well, they're finally deliberating. Technically, they finally got the evidence. I'm just curious if they're going to pick what they're going to pick. Are they going to pick which I know a lot of people are like it's murder, but I'm curious if they're going to come back with manslaughter. You're so funny. You have to clean for your grandchildren to come. They're just going to mess it up anyway. It's okay. Yeah, I have to look that up, Susan. I don't did she know him though? She's having a really hard time. I mean, obviously. I can't imagine. I was telling my uh I honestly, yeah, as I was talking to my sister last night, I was telling her I couldn't, like, I wouldn't be able to survive. I couldn't be. As someone said, she had a daughter now. Honestly, if I didn't have any more, I couldn't. I just don't know. I say that. I say I couldn't. I couldn't. My son was in the Navy, and they had that shooting on his base, and I had to watch it all unfold on the news, and I was freaking out. And one of his friends actually is the one who was shot on the base in Pensacola, and I was freaking out. I couldn't imagine. I was just like, if my son is shot, if he dies, I don't know what I'll do. So I couldn't. Yeah, of course I mean, I would definitely be in there wanting to see him rot. Hmm. Yeah, he's clearly not a good person. I just can't imagine that he's working with children. He comes from an affluent family, obviously, but that doesn't mean anything, you know. Usually, I mean, you know what's crazy is Kezi is people like that, they just want to show dominance. It's money. It's people who have money and power or whatever. I mean, maybe Brianna doesn't come from the right side of the tracks. I don't know. I mean, it's clear that Christopher did not want Corey, but the family, whether they wanted him or not, they just wanted to show that they could do what they could do. I mean, yeah, and Gwen, you're right. And Rosalie, also revenge. Yeah, it's people just want to show their dominance. And what's crazy is that the Child Protective Services was totally involved in this the entire time. Yes, he has a record. Yeah, he looks like a choir boy now with his little suit on, but actually he's been making some pretty weird facial expressions, and he's been mouthing some stuff, and the jury is seeing that he's actually doing it like facing the jury. So whatever we're seeing, they're seeing. So I don't think he's getting any sympathy from anybody. But he's going to answer for this on this earth and in the afterlife for sure. But I think he definitely didn't want Corey. I think he just did all of this out of spite. But I think, I can't believe that girl is with him, that Laura girl they keep mentioning. I can't believe she's still with him. And I think they mentioned that at some point they were trying to work it out. Like, did the defense attorney say in his closing that they were actually like looking for places together, and they were sort of together trying to work out their differences in relationship? I mean, I've been there with my son's sperm donor. I totally didn't want to be a single parent. I understand. I wanted to try to work it out, but he was horrible. I mean, horrible. But, you know, I can see where she was coming from. She wanted to try to give the father a chance. So, yeah, today he looked like his face, like it never changed. He is definitely guilty of abuse. An abuse that caused his child to die. But my question is he guilty of murder or manslaughter? And which manslaughter? Ew, how did she have a child with him in prison? I remember Ted Bundy and everybody thought he was so good looking. I did not think he was good looking. He did have a staunch supporter. I didn't know she had a child with him though. I didn't know she married him. Every single child case that I cover, every single one, they all are 100% preventable. Every single one of these situations are 100% preventable because in every single one of them, Child Protective Services is involved. And it's so sad that nothing is done. I mean, look at Harmony Montgomery. Her father got custody, and he horrifically killed that little girl. I don't know if he's a friend or not. I don't know if he's biased. I will just say that for defendants, they are allowed to have more rope than the prosecution just because they are defending someone. So they are allowed to get more leniency. Yeah, now I will say, so I do compare Brian Koberger to Ted Bundy, because now Ted Bundy did kill all those sorority nurses, the nurses in Florida, in separate rooms. He did stab all of them, rape and stab all of them. So I am curious. So he got away with that, different women in different rooms, and he was alone. So I'm curious if possibly Brian Koberger used the same MO, but the Idaho 4, they were together. I think the boyfriend and girlfriend were in the same room. Yeah, that's what I'm thinking about the Karen Reed trial. Kind of weird. But I don't understand the whole Brian Koberger situation. So that I can only compare it to Ted Bundy, because he got away with killing people in the same house, and he was alone. It's very interesting. Where are you from, Peregrine? And y'all know Susan Smith is up for parole in November. Do you remember Susan Smith? I remember it quite vividly. She thinks she'd make a great stepmom, you guys. That's kind of scary. She actually turned out pretty. I mean, she wasn't pretty in the 90s, but of course the 90s hairstyle was kind of, looking back, not great. I don't know what we Americans are doing, Peregrine. We're yeah, she definitely has no remorse. It's pretty disgusting. But she said she'll make a great stepmom, Gwen. Come on. Hi, KM. Welcome to the chat. You know what's crazy is I didn't even see that. Someone pointed that out to me in one of my comments in my YouTube channel, and I think he was like trying to hold him down with that bite or something. I don't know. It was awful. It was awful. Because I had only seen the video one time because I really couldn't watch it again. And when someone said that, I went back and watched it and I was like, oh my gosh. It was horrible. But I've only seen the stills again and in the prosecution closing because I really that video makes me sick. I don't know what kind of person. So that biting of his head really does show how cruel he can be. I think that just adds icing to the cake of the lengths that guy would go to hurt that boy. It's terrible. Yeah, that's what the guy said. He wrote her a letter or was on the phone or something like that with her. So she's had I think guards have been fired for having sex with her in prison. She's living her best life in prison. Susan Smith is. She's like Diane Downs. Yeah, I don't know if you guys are old enough to remember Diane Downs, but I remember. I don't remember it. Obviously, I was like a kid, but I grew up hearing of the story because Farrah Fawcett. I saw the movie about her when Farrah Fawcett played her. Yes, that's how they actually caught him. Yeah, that was before forensics was really getting into play with the tooth marks and stuff like that. I did an internship when I was in college for criminal justice. I got to do an internship with the police department, and I got to learn how to do fingerprint before. We were doing fingerprints into CODIS and all that stuff, but I had to actually do it where you had to compare fingerprints to a fingerprint on a piece of paper under a microscope and compare each line. Oh my gosh, that was hard. But yeah. Yes. Diane Downs, that chick, she had no remorse. Yes. The one was in Texas, the one that drowned all of her kids. Yeah, and I'm going to be doing the Lindsay Clancy case when that comes up. Yeah, the judge in the Paul Ferguson trial was very good. That mom just seemed completely out of touch with reality. Andrea Yates. That's right, Susan. That's right. You know what's very common among all of the moms? So I've done videos in the past about these moms. Andrea Yates, and I thought Susan Smith, but now I can discount that because she absolutely has zero remorse. And Diane Downs also no remorse. Andrea Yates and Lindsay Clancy, I kind of believe, but Andrea Yates, I feel like really did suffer postpartum depression because she was just popping out kids left and right, and she was asking for help, and she was she was in trouble, and I think her husband didn't pay attention, and she kept giving him warning signs and saying that she was not doing well, but postpartum depression is a real thing. And I think people who don't listen to that, don't realize how serious it is. So, yeah, I don't think she was in her right state of mind. But I thought Susan Smith might have been a postpartum depression type of person, but yeah, he was not, he didn't understand how mentally ill she was. And I think she actually called and asked, like told her mom, like, was she needed help. Andrea Yates did. And Diane Downs, she was just selfish. She was just not a good person. And Susan Smith was also like dating some guy, which is crazy because I'm from Alabama and I remember her wearing an Auburn sweatshirt on television. Like she was wearing that as a signal to the guy she was seeing because I think he was from Auburn. And I'm a huge Auburn fan, y'all, because you're either Auburn or Alabama. In Alabama, you can't be on the fence. And she wore that Auburn shirt, and it really ticked me off because when I found out why she was wearing it, it was to show the guy that she had done what she'd done for him. Yeah, I had postpartum. It's absolutely awful. So I can totally relate to the postpartum depression. And it's a real deal Holyfield kind of thing. Like, so I think Lindsay Clancy had it. She suffered from it for sure. But they're gonna nail her to the wall because hers, like what she did. Yeah, I'm gonna do the Lindsay Clancy case because man, hers is unique because also the same thing with Andrea Yates, right? Like she drowned every single one of her children. That takes time. So you have to be in a zone for a hot minute, right, to do that. Lindsay Clancy, the same thing. Like she used those exercise bands. Man, that's awful. It's absolutely awful. So, but she also tried to kill herself because I think if you're really suffering postpartum depression, because I know the feeling, like you just want to die. Like you don't want to be here. So it's not just about not having the kids. It's you don't want to be here either. So it's sad. And then I'm also looking at the case, well, because I'm an Auburn fan. I can't remember her name now right off the top of my head, but the one who tried to have her husband killed. They're Auburn graduates. I think he was a golfer at Auburn, and she was like some sorority chick or something from Auburn. But they would go on vacations in the Bahamas or something, I think, and she tried to pay to have her husband killed. It was her boyfriend. She had a boyfriend in the Bahamas or something. Oh my gosh. It's crazy. That kind of stuff just doesn't happen in Alabama. So I'm definitely keeping an eye on that one. But I can't remember her name now. Dang it. But there's stuff happening. Too much stuff. Are there any other trials or things that y'all are keeping up with or want me to hone in on? Hi, Pat. Welcome. So I don't know about y'all, but I have followed Betty Broderick since I was a kid. Okay. Betty Broderick, if y'all don't know who she is, if you remember her, she, obviously lost her mind. She's not regretful at all. She does not care. I think she is paralyzed, Lindsay Clancy. But Betty Broderick is still in prison. She was given a 30 to life sentence, and she's still in prison. But yet they released the guy who shot Robert Kennedy from prison. They've released so many other people from prison and won't release Betty Broderick. And you know what she told me is she said that it was because she thinks Dan Broderick still has the people, the law people in his pocket, that his family still has everybody in his pocket. Oh, Lindsay Shriver. That's right. That's right. 2 Lindsays. Lindsay Clancy, Lindsay Shriver. That's right. And she's in Georgia. Georgia. They lived in Georgia. Yeah, I think she's still in the Bahamas or Bermuda or somewhere. Because she's not allowed to come back to the States. Yeah, Carly Gregg. I looked her up. She's just a child. I'm going to keep an eye out for the Carly Gregg. I don't know if they're going to allow the media. I mean, because she's only 14, but they might. Oh, yeah, she did. She did. She carried that hate in her heart, and she still has hate in her heart. I've talked to her. We have emailed each other back and forth for a while, and she still has hate in her heart. And the reason she has not gotten parole is because she still has hate in her heart. She does not believe she did anything wrong. So and it's sad because she could be out and have spent time with her grandkids and stuff, but she does not believe that she's done anything wrong. No, I don't think the Gregors are from this area. Oh, I would hope I would be on my merry way too, but the way he went about it was like, I've talked to her, so he literally traded her in for a younger version of her, and he hired Linda with 0 experience. Like, she was just a pretty face, and he hired her and specifically cheated on her. Hi, Jen. And like literally just replaced her. I mean, Betty put him through college, like 2 degrees, a doctor. He's a doctor and a lawyer. And she raised all of their children and was a stay-at-home mom and literally gave up her career for him to be what he became. And then he just threw her to the wayside when he got, you know, where he was. And I mean, people change though. They were together since college. People change. She just couldn't accept it. And she still to this day can't accept it. So it's terrible that she still holds that rage. But and she couldn't move on. And the crazy thing is she had a boyfriend. At the time. And that's who found him, actually, the boyfriend, her boyfriend. Wonder how long they're going to deliberate. Okay, so remember the Alex Murdaugh trial, they deliberated for like, technically it was only 45 minutes it took them to come up with a verdict, but it took 3 hours, of course, for them to get back into the courtroom. But it was 45 minutes to get that decision. I mean, yeah, I could totally understand her anger. I mean, heck yeah, I'd be mad as heck too. I mean, if I put you through school and raised all your kids and did all that, and then you just trade me in, I mean, I'd be hard pressed. I mean, I ain't gonna lie. I'd be. She went too far though. She really did. I mean, I don't think the Gregors live where this judge is at. But I mean, New Jersey is not that big, y'all. So I mean, I can tell you, so like my relatives live in Jersey, and I can't remember who all is from New Jersey on here, but Jersey is very, very like, it's definitely who you know up there. And if you're not in the clique, you're not in the clique. So and my relatives are definitely not in the clique. Because my little nephew up there, he's not in the group of boys that pick on him all the time, because he's not involved in like all the video games and all that kind of stuff. So I think actually yesterday my cousin texted me and she was telling me that one of the boys like threatened him online, and they had to like file a police report, or actually the school did, because the school heard about it before they did. And it's just wild up there. So Jersey is kind of crazy. You got to be in the clique, and they're definitely not in it. So I think it's some wild behavior up there. And definitely if you like, the parents know, they have a lot of pull. It's very ritzy up there. They live in Rumson, so it's lots of money up there. These people are living in like mega mansions and stuff right by the beach. So I think where he was picked up was by the beach, by ocean. So they kept saying. I feel like I've been up there. Yeah, I could see that, Susan. Yeah, he was I think he was upset that he didn't get to testify. I think he was ticked off, especially when he heard the prosecution's closing arguments. I think he was mad that he didn't get to testify because he wanted to. I think it was a regretful decision. Because last week, remember, it sounded like he was going to get to testify, or he was going to. Yeah. I mean, yesterday he was doing a lot of mouthing, a lot when the prosecution was doing their closing arguments, he was doing a lot of shaking his head, a lot of mouthing, a lot of no, a lot of whatever he was trying to say. And I think it was because he didn't get to testify, because I think he wanted to have his say. He's a very narcissistic person, obviously. But he wanted his say. I mean, if you guys didn't see the TikTok murder trial, I only saw bits and pieces of it, but that guy did testify in his own defense. And wow. His testimony, when the prosecution got up and cross-examined him, he blew his lid, like lost it. I mean, lost it. So if you have somebody that has anger issues, that is not somebody you want to get up and testify in their own defense. So I think the defense attorney advised better when he changed his mind about testifying yesterday. Or was it yesterday? Day before? Yeah. I mean, you have somebody that's abusing a child. He's not going to win any medals. Oh, the Vander Aert trial? Yeah. We were just talking about that earlier. Yeah, his testimony wouldn't have been good for him. Yeah, he would have messed up. That TikTok guy. Yeah, Shonda. She's ugh. That was pretty awful. It was awful. So sad. I'm just, thankful that he's with God now, because man, the hell he was living through with that woman. Oh, are you kidding me, Jen? I watch so many trials every day. Yeah, they are emotionally draining, Jen. You're right. I had it one time. Like I said, I had this channel before, and I had to delete it and restart it. But I was watching. There was a time when there were so many trials going on with children that people wanted me to cover, and I was like, I can't, because I can't take in all of this stuff with these kids. Yeah, so it's tough. There's so much. It's hard to believe that there's so many people in this world that can do such awful things. But when I had the channel before, I had done videos on the Shonda trial, and I had done it on the uncle. I reposted that video with the uncle who killed his niece with the incest. She was pregnant. That was horrible. And then it was just too many trials. I did the baby Dominic trial, where the father met the baby mama and the baby and stabbed them to death in a park. It was horrible. I'll see you later, Peregrine. Are you leaving? Hi, Lynn. Welcome to the chat. Yeah, well, I mean, no one noticed that he wasn't in school, Jen, because I mean, people are homeschooling. Nobody notices anymore. A lot of people are homeschooling. I mean, look at our society right now. A lot of people are opting for homeschooling, so it's a common thing. So no one's going to pay attention to anything anymore. And yeah, Lynn, I think they added those lesser charges, like I said, because I feel like they don't think they have the murder all buttoned up and nice and tight in a little bow. So they had to add those lesser charges. And I think we're probably going to get manslaughter. I just don't know which one. But if you weren't here earlier, so murder is 30 to life. The aggravated manslaughter is 10 to 30 years. And reckless is only 5 to 10 years. So we're just really trying to figure out. A lot of people feel like he did murder. Some of us feel like it was manslaughter. We just don't know which manslaughter. Because some of us feel like he didn't intentionally kill Corey, but we do feel like he obviously killed Corey, but didn't mean to go so far on that particular day. But his actions did cause Corey's death. But is it aggravated manslaughter or is it reckless manslaughter? But the jury, of course, does not know what the sentencing terms are. They're not going to be putting down the sentence. The judge will do that. So yeah. Yeah, right. The father just said he didn't want to take care of him anymore. So yeah, there is no checks and balances, right, for these kids today. Yeah, and a lot of people are opting for homeschooling or private school. I mean, I sent my son, he was in a private military school. So, I mean, I knew where he was at all times. And then he joined the military. So yeah, I didn't, and I sent him to private military school because I traveled for work so much. And I was basically, I don't want to say single parent. I had a man, but like, you know, he worked all the time too. So it was just better for him to go to private military school because he had too much downtime and I didn't want him playing video games and all that stuff. So I worked my butt off to send him to military school. And, he needed structure and I couldn't give him structure because I traveled all the time. So nowadays people are doing a lot of homeschooling. Yeah, that's true. That's what her son Paul said. Yeah. And I think she has a daughter, from what I understood in the trial. She actually has a daughter that is fine. I think they're all a little bit on the spectrum, though. Even she's on the spectrum a little bit, but she's very, very smart. That's true too, Jen. I mean, that's a good argument. Yeah, I think, you know what's crazy? So this is just my opinion. I feel like we're failing as a country. We're doing too much for we're sending money, like we're just like dollar bills to everybody else when we have so much here that we need to do for our own. Like we need to be helping our children, helping our education, helping our veterans, helping our elderly. There's so much right here at home that's not happening. And they always say, well, we don't have the funding, we don't have the money. I mean, I know so many people that work in the education system, and they don't have the money for so many things, and it just bothers me that they always fall back on the whole. We don't have money to pay teachers. We don't have money for this, that, and the other. And we do have the money, but we're sending it somewhere else. So I feel like we're making excuses. Yeah, he definitely. Well, he didn't. Yeah. Yeah, we're ignoring everything that's going on in our own backyard, you know. I think that's crazy. Well, like she said, he was more concerned about Chris than he was about Corey. So he's definitely full of himself. He thinks he's like the best looking guy in the room, he's the best everything. I mean, he's very, very cocky. And even Brianna said that in one of the messages. She said, stop being cocky. I noticed that. So he's definitely full of himself. I don't think he's going to get away with anything. I just saw the bird move. I think it's tired of sitting on top of that flag too. How long has the jury been out? Has anyone been? I know. You know what I haven't heard is anyone. Have you guys heard anyone talking about what the jurors are looking like? Because I have not heard that. I haven't been. I've been watching so many other trials. I haven't heard any kind of behind the scenes. What jurors' faces are looking like, or how their reactions are, or anything like that. Sometimes Law and Crime or Court TV does that, but I haven't seen that. So, hi, Lynn. Yeah, that's why I was wondering. I haven't heard, because sometimes how they do commentary and they talk about the jurors are definitely paying attention to this. They were sitting up straight, or whatever. I haven't heard any of that, so I'm kind of curious. It's just this case has been so choppy, so it's kind of hard to tell. I just know if we're feeling this way, the jury has to be feeling the same way. So they have to be feeling as frustrated as we are. I have not seen that interview. That's what I was curious about. I have not seen her interview at all. I've actually, unfortunately, haven't been able to see anything extra because I've been watching so many other different trials. Yeah, I should watch that. Oh, darn it. Gosh, I thought something was happening. Oh, yeah, they never showed the juries during these televised trials. Let's see, I can put, we can look up her interview and I'll put it on, and then I can put this bird on my other computer while we wait. Since we're on verdict watch, I can put this. Let me look up Brianna's interview.
Bree Mitchell called Child Protective Services 100 times. 100 times. Because her little boy kept coming home bruised and beaten when he visited his dad's. 100 times. And then there was this one last time, and it was a biggie. It was an emergency order seeking full custody. Emergency to the Department of Child Protection in New Jersey. Emergency. He can't go to his dad's tomorrow at 9 a.m. It can't go on. It can't. And the judge said, no. And so Bree loaded that little boy into the car, and she took that little boy to his dad's.
Hi, Jenny.
9 hours later, that
South
little boy,
Africa.
Corey Mitchell, was dead.
That's my
And there's the
favorite
result right
accent
there.
in the
His dad's a
world,
mugshot.
just so you know.
Charged with murder. How does this happen? How does this happen? Bree Mitchell is live with me now. Bree, I am so incredibly sorry that we are meeting under these circumstances. It's unbelievable that this can happen in this day and age. Why, after 100 calls and an emergency desperate plea, were you denied the opportunity to keep your child alive?
I don't know if it was incompetence on DCPMP's side, or they just didn't believe me, but I collected evidence. There was a video of it happening, so I honestly do not know how it was not clear as day that he was being abused. It makes no sense to me, and I don't think it ever will.
I can't show the video right now because it hasn't been released, but I'm going to describe it for our viewers. It's at a gym where the allegations are and the video purports to show. his dad putting him on a treadmill and continuously upping the speed, even though Corey can't keep up and keeps falling off the back. He's grabbed by his shirt and put back on the moving treadmill. He struggles constantly to gain his footing. At one point, his father, Christopher Gregor, appears to bite the top of his head. Even despite all of this, the court said this: they do not find that Corey is in danger of imminent and irreparable harm. Therefore, the court does not find a temporary modification of the parties' custody and parenting time arrangement appropriate at this time. This was the day before Corey died. And then after Corey died, the judge said, the video was viewed by the court really speaks for itself in illustrating that this defendant did abuse this child. I think when you watch the video, it is fair to say that anyone who would do this to a child does pose a significant risk to the community. Is that the same judge, or is that a different judge based on now the murder allegation?
It was two different judges.
Have they spoken? Has there been any consensus among law enforcement and authorities that they completely failed you, and that because of that, your beautiful little 6-year-old boy, Corey, is no longer with us?
No one's going to admit that they thought the abuse was going on before, because that just shows they were wrong. But now that he passed away, all of a sudden, everyone is like, how didn't we know? You did know. You were just ignorant, I guess you can say.
Can I ask you, Bree, as the litigation moves forward in Corey's father's murder case, are you also launching civil litigation against the authorities who ignored your 100 different calls and attempts to keep that child away from him?
Absolutely. They need to be held accountable. This happens too often. I've heard other stories from other parents of the same thing, and something has to give, something has to change. I don't know why this is allowed to happen.
It's unfathomable to us as well. And I hope you'll keep us abreast of your efforts to find justice, not only for yourself, but also against the person who is alleged to have done this horrific thing to his own flesh and blood, his own baby boy. Bree, again, I'm sorry we're speaking under these circumstances, and I wish you all the strength in the world as you move forward.
Thank you so much. I appreciate it.
Bree Michelot joining us live. I would like to just show some pictures of Corey, 6 years old, and so precious. So many more people should have protected that little boy and did not do it.
Oh, hold on. Sorry.
Thank you for watching. Go to newsnationnow.com to find News Nation on your television provider. And don't forget to click the red subscribe button below to get more of News Nation's fact-driven, unbiased coverage.
The ability to review evidence by the jury during deliberations is subject to the court's discretion and proper instructions as to use. However, our Supreme Court in Burr indicated that video testimony or video exhibits present certain issues because playing back exhibits reveals more than a sterile readback of a transcript. A video playback enables jurors not only to recall specific testimony, but also make credibility assessments. Video testimony is often very powerful. In this case, the Burr case deals with video testimony, such as a custodial interrogation of someone, but the case expresses concerns about the dangers associated with unfettered access by a jury to video evidence. It provides a series of factors. The first is that the court should ask if a readback of a statement would suffice. That's not applicable here. This video has no audio, so there's no statements on it. If the jury persists in its request for the video, the court must take into consideration fairness to the defendant. Second, the court must then determine whether a readback of an entire portion of direct or cross-examination is necessary. Here, there really is no direct or cross-examination. Again, it's a silent video. Third, the trial judge should deny the playback if there demonstrates prejudice. And fourth, the playback, quote, must occur in open court, close quote. Generally, the standard in New Jersey, from my understanding, is that any video evidence has to be played in open court. I'm aware, however, that prevents the jury from being able to deliberate or discuss amongst themselves things they see simultaneously with the video. In light of that, does counsel have any positions I'd like to place on the record?
No, Judge, thank you.
All right. So if we could go get the alternates. All right. So let's bring them in, and then counsel agreed on the record that for the purposes of this, we can put the alternates back in their seats, correct?
Yes, Judge.
All right. And we'll bring the jury out.
Oh, they're gonna watch the
Is
video.
everything working okay?
Welcome, Erna.
It's working, right?
I don't know if you heard me earlier,
Yes.
but South African accent is literally my favorite accent in the whole
Folks,
wide
we'll have to go
world.
back to your seats for this, okay?
Oh my gosh. So I did not know that when she asked for
Sure.
emergency
I'll see if I'll give you
custody,
a couple
that they
instructions
had
before.
the video of the treadmill. Where did they get that treadmill video? Does anyone have any idea? How did she get that? Holy moly, you guys. And she didn't get custody? That's insanity. I am stunned.
Thank you, everyone. Please be seated. Ladies and gentlemen, we've agreed that the alternates can go back to their regular seats for the purpose of this so they can have a good view and be able to see everything. We have your note, quote, we need to view treadmill video, please. That exhibit has 4 parts, A, B, C, and D. I think 2 of them, is it B and C, actually have portions of the treadmill on there. One is going in, coming in, and the other one, the last one, D, is leaving. You just want to see the aspects of the treadmill, correct?
It's just the treadmill itself.
I need to see all of them.
I want to see him coming in and him leaving.
All right, counsel, any objection? We play all those?
None.
During the trial, we had fast forwarded through several minutes of just inconsequential video. So that's all we can do. That's what we did during the trial. That's all we can do now, right?
Yes.
All right. Anything further about that?
No, Your Honor.
All right. One of the jurors said about going up close. Any objections if the jurors do that?
No, Judge. No,
Yeah,
Can you
he
do
mentioned
that on
something about
this TV?
March
Yeah.
29th.
All right, because that
There
way,
must be another video.
this way, you're not being filmed over there as opposed to if you go across the middle of the courtroom. So feel free to move about. The other issue is though, just so you understand, everything I do has rules and case law I have to follow and those kind of things. So I think in a perfect world, somebody would say, it'd be great to review it in there so you could discuss it.
Yeah.
I'm bound by these rules in New Jersey that says video playbacks have to occur in open court. So your deliberations have to occur in a jury room. So the best you can, you have to, right, hold your thoughts and then go in there and make some deliberations about it, if that's possible for you.
Your Honor,
Huh?
can we ask the question at any time?
They want to, I know, but you still have to watch.
How about that, counsel? Any request, if there's a request to pause it, is that possible?
I don't
No,
have
because
an
then you'll be on
objection to
camera.
that, and just leave it up to Ms. Shrano. She's the one operating.
Any objection by the state?
No, Judge.
Your Honor, I'm
Try to
clarifying
pause
that
it.
The alternate should be viewing it as well.
Yes,
correct?
everybody should view it, right. In case we have to be replaced,
Play
in
over
case you have to be
there.
placed into the jury, you
Yeah.
want to see
Hi,
what,
Terry.
whatever question the jury had. The only thing we can't do, for instance, is if it wasn't played in slow motion or in fast forward as part of the trial, we then can't slow it down for you. It was stopped and it also was given still photographs, so we can stop it for you.
Oh my gosh. They are.
All right, so whereupon let the record reflect, the state is
You beat him on the
playing.
arm too? Oh my goodness.
18, is that it? 18?
They just shouldn't discuss it out.
They shouldn't be, I'm sorry, let me see.
Welcome to the
Because
chat.
I don't get you thinking a lot right now, but I don't think that the jury should be able to discuss amongst themselves as they're out here in public.
I just kind of tried to say
We're
that.
not going to.
They know they're not going to. So I explained that. All right, so it's 18, A, B, C, and D, right?
Yes, and I'll make that reference every time I change it for the record.
Whereupon Ms.
Judge,
Strong
can
is
I-
going
can
to
I
play the
just-
exhibit.
Can I just stay seated when I do that? and
Yes, of
interact?
course.
Yeah, the South African accent is like literally
S18A
beautiful.
is playing now. Hopefully.
Oh, I can't do the slowed down version, Jen.
Nope. It's not playing.
I don't know, y'all. You would think that they have seen enough of this, right?
Go back out.
I sent him a message.
I mean,
Oh, okay.
It's not your equipment. It's mine. Saying software decoding.
I'm shocked that they want to see this again. Like, really.
Touch it for a second.
But it's been a hot minute since they've seen it. Think about it. Think about all the day breaks that they've had, the time off that they've had since they've originally seen this video, because they haven't seen this video since the beginning. Yeah, it's crazy, Terry. They want to see this video again. I mean, so maybe they haven't been watching anything in between all the breaks. I don't know. I would say the Australian accent is my second favorite accent, but it's actually close to a Southern accent. That's why I like it. As many times as he's worn that jacket, I can't believe they haven't steamed out those wrinkles on that one side. Yeah, it's crazy. Why did they want to see this video again? It's such an awful video, y'all. But maybe it's because they have not shown this video since the beginning of the trial, if I recollect. I might be wrong. And there has been a long time. Y'all, we're almost in June. Is it? Okay. That's where the wrinkles are from. There aren't, but somebody has to give him that suit to wear. His that's up to his attorneys. He don't get that suit in jail.
It's okay.
What? That sounded real country. Good Lord, have mercy on my soul.
Oh, you know what? I don't need the mouse. I will figure it out.
See, they hadn't played that video in so long, they got to look it up. Yeah, but you know they've seen that video, Gwen. They're full of the caca if they say they hadn't seen it. Jenny.
Here we go.
Psychopaths can sleep just fine. Or sociopaths. I don't know what the difference is. I got to look that up.
You want to start again?
Look at that poor boy. He knows. All right, look for little nuances, y'all. He just flung that door open. He is, Terry. Yeah, I keep looking at his face, Kathy. Welcome. When he watches this video to see if I can get a read on him.
Say for the record what you're playing.
S18B, and I'll ask Mr. Galucci
Ew.
if we need to fast forward any of these, what he agrees on.
How did Brianna get this video when she went to get emergency custody? Does anybody know that? Is it in her interview, Jen? Hi, Kelly. Welcome to the chat. Oh, sorry, Jen. How did Brianna get this video for the emergency custody order? Look at that poor baby. Yeah, she said in that interview with Banfield that the judge had this video when she asked for emergency custody and she was still denied custody. So I'm curious how she got it. I don't think they should be allowed treadmills in prison. Those are expensive. No, they mentioned something about the 29th, but they didn't show that one. Yeah, because this is not the first time that this has happened to him. My sister and I talked about this last night. He knew exactly what to do. Oh, there's the two. Okay.
Your Honor, S18B just concluded. I'll fast forward to the appropriate part of S18C. Wrong way again. I know.
Ah. Well, technically, kids aren't supposed to be in the gym at apartment complexes. I do know that. Even with a parent. So that could, you could have a point there, Gwen. Again, Gwen with the good points. Yeah, when he's biting him, that's what it looks like he's doing, is trying to put pressure on him. Yes, most apartment complexes have cameras. Now, if they're working or not is a whole nother story. But luckily, these were. So what do you guys want to bet they ask him to pause it when he bites him on the head? Because that's been up for debate, that there was no mark on his head. Was there a mark? I thought they kept saying that no doctor found an actual bruise on his head. Well, that was what the defense said. Yeah, I think the defense kept saying that. Oh, hi, Pat. Yeah, there's so much scattered evidence in this case. I'm having a hard time keeping up. Hi, Silencing Whispers, aka Voices for the Voiceless. Welcome to the chat. Hi, Renee. Welcome. Now we got to see how long he suffered. Yeah. Oh no, I'm not laughing at the. I'm talking about how long Silencing Whispers' name is. Right. Okay. Under the scalp. What's your name? Silencing Whispers. We also got to see how long he ran. Or you don't have to tell us your name if you don't want to. Oh, Francesca, that's pretty. Welcome to our lovely chat. Yeah, 30 to life would be nice. I didn't either until she did the still shots. Hi, Kirsten. How are you? Hallo. Willkommen. Dankeschön. Oh, he's going fast. Look how fast he's going. Oh, my gracious day. Oh, oh. Ah. Hi, Lucy. Welcome back. I don't know if they are. I thought they were going to ask to pause it at that point, but they didn't. Oh, my gosh. Hi, Lakeisha. Welcome. Kirsten, they're rewatching the video. I think because they haven't seen the full video since the beginning of the trial. So the jury has asked to see the video again. And everything they ask for has to be done in the presence of the courtroom. I know, Renee, it's absolutely awful. Yeah, almost 15 minutes. And look, he just ignores him while he walks out. He just totally walks out and leaves him.
Judge, I'm going to stop S18C now.
Thank you.
Zero expression. Like,
I'm playing S18D now.
look at him. Look at the, like,
I'm stopping S18D now.
his parents aren't in the room. I don't see them.
No.
So it's 12:27. Do you need a lunch break or you just want to keep going?
Are you guys on break for lunch? 12:30, 12:22? You need to talk a little bit now.
So, all right, so a couple things. Right, so why don't you send us out a note saying you want to stay for X amount of time, or we want to go to lunch? And then also, if you have any other questions or anything else, you should send me out a note too. Anything else from council?
No, Your Honor. No, Judge, thank you.
Okay, so they don't want to take a break, so that's a good sign that they want to go talk about this while it's fresh.
Just gonna leave you guys waiting home.
That's a good sign. So maybe they will come up with something. Oh, it is so painful to watch. I can't. It's
Very good, thank you.
I'm gonna restart it, so.
I was not would restart, yeah.
Alright, yeah.
All right, so 12:28 PM, the jury's back in the jury room and the alternates are being taken out of the courtroom. Anything from counsel?
No, Judge, thank you.
No, Your Honor.
All right. Madam Clerk, can you hang on to the notes for me?
okay. So I'm
All right, so
thinking
I'll step off. I ask you to stay close.
yeah,
So we get a note
I
about
think
what they want to do for a month.
Yes, Judge, thank you.
Thank you.
All rise.
I think they're going to come up with a verdict pretty soon. What do you guys think? Do you think they're going to take a lunch or a verdict? That was my dog. Oh, Renee, they're on a delay. We're on a delay. Yeah, we learned that. We've learned that over the past couple of days that we are delayed, or I can't. Anyway, we're on a different time. Yeah, I think I think they may come back with a verdict and just skip lunch. Do you think? I think we're gonna get a verdict. I'm surprised they didn't. Remember, they asked if they could pause the video, but they didn't ask to pause. I'm surprised. Yeah, but we learned, remember, Gwen, that Law and Crime has a 30-minute delay or something, so we don't get it in actual real time. So, because I thought I was going crazy yesterday with the time. Thank you, Kirsten. What part of Germany? Deutschland. What part of Deutschland? Oh, I lived in Germany for 6 years. I was in Stuttgart and Frankfurt. I think so too, Julia. I hope so. Fingers crossed. Ich sprechen Sie Deutsch? Kleine, but came back to the States and grew out of it. Ich liebe. It's so beautiful. I was a kid, so I loved it. Yeah. I'm gonna look for that Brianna interview. What did you say it was called, Jen? Truth with Brianna?
Hi, Kelly Hall coming to you live, loud and local from my back of my art gallery in New Zealand. And today we're just going over some truths from the past that need to be cleared up. You know, this is a hot case. It's coming out of New Jersey, and it's about Corey
I used to
Ditchlow.
live in North Carolina too.
But I have to. What happened last night was I showed a lot of evidence. I slowed down that. I slowed down the treadmill thing to show what he did to him on the floor, and I got a few letters from YouTube and a bit of back and forth. He puts his hands. YouTube stopped it twice and went and looked at it. After I uploaded that video, it went straight to 5,100 views and I don't know, really, really fast.
Is this an
fast.
Aussie accent or
it
an English accent?
Flatlined, and YouTube said they're going to remove it because it involves CA. You know what CA is? And I was like, yeah, I'm trying to tell that to the public because this is in trial. It's not just they're going him for endangerment on the treadmill, but it's more than that, and it's more than the murder charge as well. Obviously, murder's the worst, right? But I wanted to show that there's an amount of time off the treadmill on that floor where he actually does some internal injuries and his hands go inside him. And YouTube agreed with me. They're like, yeah, we can see that in the video. You can't play that to the public. I'm like, it's on hundreds of channels. It's on every news channel. But I'm the only one that slowed it down. They said you can't. The only way you could have that up is for education. And I'm like, well, I'm trying to. A couple of friends of Brianna's reached out to me and said, we're trying to get hold of you. What's your email? I don't want any emails or phone calls. Not interested in it. But I do want to help. So I did that video called New Charges or New Lawsuits. And we went through the New Jersey laws of assault and battery, right? Which I think they're entitled to go after. And I think, anyway, a few years ago, 3 years ago, a younger Brianna and Cara had lost her year and 2-month-year-old, which has involved her ex-partner. And they were both involved in DCFS. And then in New Jersey, it's called DC. They've got a DCF, but it's called DCP&P.
That's a really
so
long
I'm just going to
name.
play bits of this. The problem is when they recorded it, their phones had a funny connection, and I tried 3 times last night to record this, and my computer just won't do it. There's something up with the way they recorded this. But anyway, I'll try and get it right.
Both of us have had involvement with DCFS, and both of us actually put forward I put forward 3 emergency motions. I don't know how many you put forward, Bree.
Yeah, it
Before
was
the
one.
court-
Yeah.
Before the court, proof.
Right. So I've just got to pause it there and move it forward. Right. So Brianna, pretty much, I've watched this over and over, and it just seems 100% truthful to me. The way she's recollecting, the speed of how she's telling the story, everything seems right, 100%. So you're going to learn
not
something
heard that,
valuable here
Kathy.
today.
Here's Bree.
Hi, I'm Bree Michelo. I'm 24 years old. I'm Corey's mother, and when he passed, he was 6 years old.
Hi, I'm Carol.
Okay. So I haven't really talked about the very beginning of my story. This is going to be the first time I really do talk about what happened when Corey was conceived. I'm not going to go into many details because of investigations and whatnot. But
Oh,
so
hold on,
when
guys.
Corey
Sorry.
was conceived, it was not consensual. It was sexual assault. I was 16 when I got pregnant, and Christopher was 21.
Sorry, guys. We're back.
You have to sit down. Sorry. I'll explain. All right, ladies and gentlemen, I know you sent a note to go to lunch. I just have to tell you, you must stop your deliberations at this time and not recommence your deliberations until such time as you go back in the jury room. As always, please report back to jury assembly, and then we'll come and get you. So all of you can report back to jury assembly. And then any objection, if we just have the 3 alternates stay over there at that point and just bring the 12 back to go in the jury room?
No objection, Judge.
No objection, Your Honor.
All right, and then is an hour acceptable?
Yeah.
All right, so it's, we'll say 1:45. It's almost 12:45 by the time you get out the door. So obviously you can't discuss the case amongst yourselves when you're at lunch, but you shouldn't discuss with the alternates either. You can talk to them, you can all go to lunch together. I know one of the alternates made a request about watching the video again or something like that. So if an alternate was substituted in, there's a series of instructions I would have to give you at that point, but
I
then
see
you'd
you
be part of the
silencing
jury, you could make
whispers.
that request to your fellow jurors, and then we could do that again. But only the 12 deliberating jurors at this point can make requests. Anything else from counsel?
No, Your Honor.
No, Judge, thank
All
you.
right. Thanks so much. Please try and avoid any spectators or anyone like that. And same thing for any spectators. If you find yourself in the same restaurant, please try not to go close to the jurors. Don't make comments about the case or your opinions. The jury has to decide the case based upon the evidence in the courtroom only. Thank you so much.
Thank you, Kathy. Okay, so they are going to go to lunch. All right, so let's go back to
Anything in the room?
that video.
And we'll keep that room locked so we don't have to lock anything up now. That's only the end of the day.
John, just grab a bottle of water out of there, cold one, please.
Well, I have to say the good news is they're taking their time. They're not rushing this.
Anything from counsel?
No, Judge.
All right. See you in an hour.
Judge.
Thank you.
Please exit.
Yeah. Your Honor, I'm just gonna put this back in the jury room.
Sure.
after that, I got pregnant. I told him about it, and immediately he wanted me to have an abortion. So after that, I just tried to stay away from him. I didn't want him to be involved because I didn't want him to try to force me to have an abortion because I wanted Corey. I didn't believe in abortion. And like I said, I stayed away from him for a long time. He knew I was pregnant. He knew he was the father. He didn't come around much for 5 years. And
oh, did I?
He did once in a while, but it was very briefly, just here and there.
But I'm the only one that slowed it down. They said you can't. The only way you could have that up is for education. And I'm like, well, I'm trying to. A couple of friends of Brianna's reached out to me and said, we're trying to get hold of you. What's your email? I don't want any emails or phone
Sorry, guys,
calls.
I'm restarting
Not
it.
interested in it. But I do want to help. So I did that video called New Charges or New Lawsuits. And we went through the New Jersey laws of assault and battery, right? Which I think they're entitled to go after. And I think, anyway.
Oh, thanks, Kirsten. I have to check that out because I'm definitely no psychologist.
A few years ago, 3 years ago, a younger Brianna and Cara had lost her year and 2 month-year-old, which has involved her ex-partner. And they were both involved in DCFS. And then in New Jersey, it's called DC. They've got a DCF, but it's called DCP&P. So I'm just going to play bits of this. The problem is when they recorded it, their phones had a funny connection. And I tried 3 times last night to record this, and my computer just won't do it. There's something up with the way they recorded this. But anyway, I'll try and get it right.
Both of us have had involvement with DCFS, and both of us actually I put forward 3 emergency motions. I don't know how many you put forward, Bree.
Yeah, it was one. Yeah.
Before the court proved.
Right. So I've just got to pause it there and move it forward. Right. So Brianna, pretty much, I've watched this over and over, and it just seems 100% truthful to me. The way she's recollecting, the speed of how she's telling the story, everything seems right, 100%. So you're going to learn something valuable here today.
Here's Bree.
Hi. I'm Bree Michello. I'm 24 years old. I'm Corey's mother, and when he passed, he was 6 years old.
Hi, I'm Carol.
Okay. So I haven't really talked about the very beginning of my story. This is going to be the first time I really do talk about what happened when Corey was conceived. I'm not going to go into many details because of investigations and whatnot. But so when Corey was conceived, it was not consensual. It was sexual assault. I was 16 when I got pregnant, and Christopher was 21. After that, I got pregnant. I told him about it, and immediately he wanted me to have an abortion. So after that, I just tried to stay away from him. I didn't want him to be involved because I didn't want him to try to force me to have an abortion because I wanted Corey. I didn't believe in abortion. And like I said, I stayed away from him for a long time. He knew I was pregnant. He knew he was the father. He didn't come around much for 5 years. And he did once in a while, but it was very briefly, just here and there for 5 years. And then when Corey was 5 years old, I went and applied for government assistance. I didn't know that doing that made them go and file for child support themselves. It was them against Christopher at first for child support. I didn't know that was going to happen. If I did, I wouldn't have done it. I wouldn't have applied. but they asked me who his father was, and I told them. And so they went ahead and filed for child support. And that's how he came around.
Right, so let's break that down. She meets Chris Gregor at 16. He rapes her. I just don't want this video to get cut off like that one yesterday. Yesterday's video is so important. So I've got to spell those words out. She wants to keep the baby, her choice, you know. I won't get into the abortion debate because abortion is not a belief system. I know close family that got raped by a extremely bad person, and they couldn't keep it because it's more to do with extremely bad stuff. So they had the abortion right away. So it's not a belief structure. I'm not going to get into it. We'll go past that. We'll move on. So she's being a hero. She's being brave, and she wanted to keep Corey, right? And then, so he knows from day one that he's got her pregnant. He knows. She told him, I'm pregnant, I'm keeping it, right? So she's fought back the whole time. So for 4 or 5 years, this guy who's already assaulted her, so this sexual assault, which I want to see him charged for in this trial. I want to see him charged for that sexual assault and added on during this trial. This prosecutor's she's been let down by the state of New Jersey from the get-go, from the start, right? The police work for the government. The DCFS and the DCP, they're government departments. So they've all let her down. She filed an emergency motion. Judge Bradshaw watches the video of him on the treadmill. So the first time, she's going to say in a second, there's more than one treadmill, right? He did it the first time on the treadmill. He comes home with marks on his face and a burn mark down his body where Chris had already hurt him on the treadmill. DCPP, tell him not to let him on the treadmill again. What? I'll let her talk about it. Now, what happens, her connection breaks up here, so you're just going to have to box through.
For a while, he just paid the child support. And I guess at some point, his family found out that he took a DNA test and Corey was his child. And I believe that his parents forced him to go to court and get visitation. So once the visitation started immediately, that's when Corey started coming home with his bruises. The first incident he came
silencing
home,
whispers.
I think it was the second visit with him, and
Take him back in.
he came home with a busted lip. Christopher dropped him off by the driveway, and Corey walked up, and then once he came inside, Chris sped off, and then Corey came inside, and I could see that he had a busted lip and he had some blood on his shirt. And I asked Corey what happened. At first, he was hesitant. He didn't want to tell me. And I asked Christopher. He didn't answer me, so I decided.
I have to come in there. So he smacked the kid in the face because Corey's going to tell her that in a second. So he actually smacked him in the face and invented the soccer ball story, right, for his dad, for David Gregor.
What?
And so Chris drops him off with a bloody lip and blood on his top and speeds off. He flees, right? So now we've got him fleeing again as well. He went through Tennessee, big long drive after he dropped Corey at the hospital. This should come into trial, right? This statement here, because she's telling it exactly how it is in her voice. This is her recollection of what happened. Dropped off Corey with a bloody lip, blood on his shirt, and sped off. He fled, right? So we've got a serial fleer who's comfortable to drop an abused child back off with the mother. Yeah.
To take Corey to the police station, which he was afraid to tell them what happened, but they ended up calling DCPMP. And they came out and they did their investigation and they talked to everyone. And Corey didn't tell them what it was, but he told me and my sister that Christopher smacked him in the mouth because he had cursed. And
what?
Chris told them that he accidentally kicked Corey in the mouth while he was going to kick a soccer ball. But of course, Corey had a different story.
So where's the training of the DCPNP or the DCFS? Where's the training involved here? She's called the police. She's done the right thing, right? And a couple of the people in the comments said she didn't do anything. He didn't know till he's 5, but now we know that's all BS. It's not true. She's done everything she can for this child. So, we've got the police have let her down on the first call, right? They've called DCPMP. They've come investigated, talked to everyone, and someone's swept all this shit under the rug. Someone swept it under the rug. Who's done that? David. David Gregor, the father, the Homeland Security guy. He's done all this, hasn't he? He's done this to that child, and he doesn't want to see the tape he doesn't want to see Corey mistreated. People get mistreated at a restaurant. If somebody's having and something goes wrong at a restaurant, you get mistreated, or you get mistreated at a bus stop when somebody yells out some abuse for no reason at all, or somebody gets, a bit of road rage. That's mistreated.
Huh.
When he used that mistreated in the trial, David Gregor, it's severity softening. There's a scientific term for it in deception, severity softening. He's trying to use a lesser word than what really happened to that child. Murder, physical abuse, CA.
And that case got closed because they felt like it was unsubstantiated. And then
Now, before she goes and then so and then changes the timeline. Before she moves on from that timeline, unsubstantiated. Which part of a bloody... They're playing her word against his word, right? That's not good enough. The kid had the bloody lip and the thing. She went to police. If he had a bloody lip, if the child had a bloody lip and thing on the shirt and he didn't speed off, there wouldn't be a police call, right?
after that, the next time Corey came home and it looked like he had like rug burn all up and down his arm, all up and down his torso. And he looked like he had a handprint on his face. And I asked Corey what that was about. And he told me that his dad thought he was too fat. And he made him run on the treadmill.
I was wondering where the too fat came in.
Chris about it, and he said the same thing, that he thought Corey was too fat and I needed to stop feeding him fast food. So then I called DCPMP, and I guess they thought it was okay for him to do that, but they did tell him that he can't go on, you can't put him on the treadmill anymore.
Right. So it's just bad recording. But let's take the time to go through that. So here's our second call to DCPMP and dealing with them. Problem is, we're not going back to the police again. So here's our first breakdown of because the DCPMP turn up in those sheriff's clothes. I've seen it on that Jeremy DeWitt videos. They turn up at his house and they wear clothes that look like police, right? So it's misleading. So when he turned up with, he's obviously slapped him in the face. We've seen what he does to him in the gym. He slapped him in the face and he's made him collapse on the treadmill a first time. This is the first treadmill event, not the treadmill event this trial's about. So there's two treadmill events. Why isn't that coming into trial? This video needs to come into trial. Sorry, I'll do the two that way. Okay, so they told him not to go on the treadmill again. So we've had one call to the. I've got zero tolerance, right, for any of this abuse to her, to the child, right. I've just got zero tolerance for it, and the DC PMP seem to have tolerance for it. Where's the hard line? Treating these people like shit in New Jersey.
And obviously he did again. And after that, I have calls with DCPMP every week. There was different incidences where Corey would have a busted lip, black eyes, bruises all over his body. And then I'm going to fast forward to.
I know you're going to say, well, why didn't she just stop him going there? Who isn't standing up for her? Well, she's tried, right? And they haven't done anything about it. So this is such strong evidence for a civil trial against the government, right? I think $75 million is a starting point for what happened to her.
Yes, Lucy, they did throw dead fish.
Because
so yeah,
this Mario Gallucci and
now I can see
David
why.
Greger and Carolyn Greger and Chris Greger are doing everything they can in this trial to sweep it under the rug.
What awful people.
But no way, it's a hot case and it's gone worldwide. And there's people like me that take the time to slow down and listen to every word. And I've done this in every story that I've talked about. And there's bad actors that people think are good actors. And in every trial, I've seen it in every trial, there's bad people in the background. This one's a wee bit more obvious, but she hasn't had a chance to tell her story. It didn't happen on the stand because they're focused on the actual crime of murder, right? They're trying to get him for that murder. That's what they're not focused on. The biggest story here, which is Brianna's story and Corey's story.
Yeah, Corey.
He died for this story because that police and that DCPMP did not use a hard line. They did not find out how he was born. That'd be the first question. Kid turns up with a bloody lip. How was he born? You're quite young.
Yeah, she's only 24.
Right.
She's
She's
just
gone
a
with
baby.
the busted lip at, 5? So she would have been 21. They would know he was 5. So he's born was 16. How was he born? All right. You need to tell us what's going on in this. Go right back to the start. You've got the time and money to do it. USA is meant to be the greatest nation in the world. You know, it is the biggest, I think, is it Apple's the biggest company in the world? Or is old Elon Musk now the biggest company in the world? I don't know. I know that Apple's like $3 trillion or something. You can't look after one child. You can't even care for one child.
He was, Jenny. It's horrible.
March 20th, when to the gym. He had a gym in his complex. And what he did to Corey was caught on surveillance camera. I didn't know this until after Corey passed away. No one told me about it. So Christopher made Corey get on the treadmill, and then he sped it up as fast as he could, and Corey couldn't keep up with it. So he fell and hit his chest. I've never seen the video because I can't. I don't want to see that. I don't want that memory stuck in my head. But the way I'm just telling everyone the way it was described to me. So he fell and hit his chest 6 or 7 times. And then Chris walked over to Corey and picked him up by the back of his shirt. And sorry.
Right. So that's not what happened. What happened, because I've gone through the video 4 or 5 times, slowed it down into the seconds. He speeds up Corey had already run, I don't know how many miles he'd already run. He's fit. He's actually doing really well on the treadmill, but he's not clipped into a leash at all. There's no leash to turn that thing off if anything happens. Chris speeds it up to purposely make him fall off. Now, He hits the floor. He gets behind him and locks his arms. He does something weird with his arms and his fists up behind his back. And then from there until the treadmill, there is, what did I count? About 4 or 5 instances of assault. Just goes on and on. The way he keeps moving, the way he re-grabs him, he grabs him by his skin up under each breast and pulls him up in the air. But before he does that, he puts his, it's almost like in those superhero movies where they put them hands inside them. He gets his hands and pushes them down inside his rib cage, down in through towards his butt. His hands actually go inside Corey and travel through his organs in that video, which needs to be played in court. Again, there needs to be if they don't do it in this trial, there needs to be another trial, civil trial,
gosh.
and play that video and pause it and get that David Gregor on the stand to watch this, because they won't watch it and they need to watch it. I understand if Brianna doesn't watch it, but people that are responsible for that child and had a duty of care. Who has a duty of care for Corey? The police. She took them there first, right? So the police have a duty of care. They failed. DCFS or DCPMP or both of them. They failed, right? Time and time again. I don't know how many times she's called them. It says like 100 in the comments. But this is within a year, right? Within a year and a half, all this goes on. And no one's helping her because she's under a strict regime to take him back. They keep telling them to take him back. So I think the DCPMP killed that boy with law and the police. They didn't stop it.
I agree.
You can't just hand the kid off to DCPMP and go and work on another case when he's turning up with a bloody lip and a red face. You know, that first bloody lip's enough to stop all this. Because she took him in. She took him into the police.
Yeah.
And he sped off. Right?
Yeah, that attorney's terrible. He's not a good person either.
So.
Oh, yeah. So then he puts his hands inside his body, pushes down on all his organs before he picks him up off the floor. Then he picks him up with his hands underneath there and his shirt, because his shirt doesn't raise all the way up. And then he forces him down. Then he bites into his head, and he does 4 different bites in the same motion. It's one motion going through. So good luck to Mario Gallucci to defend this, because it's on that video. If you slow it down by the millisecond. He does a bite, his teeth get wider apart, bites down, pushes down, and he pushes down 4 times until his knees are touching the treadmill. He's unable to run, so there's no running on the treadmill, right? This is a completely different assault and battery. It is. And this is, so she doesn't even know this. You know, 3 years after, this was recorded 3 years ago, and 3 years after the,
oh my God,
3 years ago, she was 24, 3 years after his death, right?
Golly.
2 years after his death. She doesn't know all this has happened as he's going onto the treadmill.
So he picked him up by the back of the shirt and placed him back on the treadmill, and Corey's like feet were dangling, and then he bit him on the top of the head, and I don't know the ending. I don't know exactly what happened at the end, but that's how it was described to me. After that happened,
he does this really unusual biting thing. It goes down deeper, 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 and deeper. And it looks like he's either strangling him or he's really damaging his skin. He spends a lot of time with his fingers underneath the skin, like internally inside his Corey's body. And then there's the 5 different coming off the treadmill falls on top of that. When the treadmill stops, and that's in my new charges video. I just put it up yesterday, but YouTube so we've done 3 emails with YouTube. They've had 2 different lots of people review the video. They've said it's CA, but because of my talking to what's happening and explaining it for the world, they've left it up. They said, and I said, it's on every other news channel. And they said, not like this, because I've slowed it down and actually shown the abuse. So YouTube, call YouTube into the courtroom to testify to my video. They've reviewed it and said, because you've put so anyone that doesn't have a YouTube account that clicks on it cannot watch it. They've restricted it to only people with a YouTube premium subscription. They've cancelled all advertising on it, so I don't make $1 on it at all. And yeah, at 1 a.m. this morning, so I put it up yesterday, and the first like 20 minutes went to 5,000 views. So it'll probably be on 100,000. It would have gone viral, right? And then they re-released it at 1 o'clock this morning. I woke up this morning at 6 a.m. and there was an email from YouTube saying we've released it. We're leaving it up because it's educational. But no one under 18 can watch it. Only people with YouTube subscription and anyone that shares it. So you have to go to my new charges, new lawsuits video that I uploaded yesterday and look at what I'm talking about to what she's talking about now.
I like I said, I didn't know about the video, but then when I saw when Corey came back home, he lifted his hair up and showed me this bump on his forehead. And I was like, oh my God, Corey, what is that from? And he told me that his dad made him run on the treadmill. And so I called DCPMP, I made a report. They went and I guess checked their surveillance camera, but they didn't tell me that. But what they did tell me was to take him to his pediatrician for a child abuse exam, which I did. And at this exam, they, went over his whole body and marked every bruise that he had, which it looked like he had got beaten with a bat. It was so bad. So
when he comes off the treadmill, I've already said this, but I'm going to say it again, and he's on the ground off the treadmill the very first time, Chris puts his hands inside his body down and pushes through his butt to the floor. His hands go inside him and crushing his organs. A lot more than just his liver. It's in that video.
Sounds terrible.
New charges, new lawsuits video on my thing. Look at it, share it, talk about it. Share it right through New Jersey. I want to see something happen. So I've been told that you do have a state senate in New Jersey.
Yes.
It's where this has to go. Has to go there because your laws aren't good enough. You're not protecting this child. You let him die.
We're doing it all over the country, man.
So
it's happening everywhere.
While we were at the doctor's office, the doctor was asking Corey what happens, and he was very reluctant about it. And when she asked him the first time, he just said it was like from but you could see his eyes were like darting around the room, and he didn't want to look, so we knew he was lying. Oh my God. And so she asked him again, and I got upset, and he got upset, and he told her what he put him on the treadmill and that he was abusing him. So then the doctor told me to take him to the hospital for blood work and x-rays, and I did. And they took an x-ray because he had a really big bruise on his chest, and nothing was broken, thankfully. But they told me that the next day that me and Chris were to meet and go to the doctor. He was a child abuse expert, and the next day was Chris's day, so he was with him, and Chris was supposed to bring him, but he didn't end up doing that. And so I dropped Corey off at his house around 9 a.m. and Corey was healthy. He was breathing, he was walking, he was talking. I dropped him off, he walked inside, and then everything, he didn't show up for the appointment at 12 p.m. And then he called me at 3:30 and he said, I'm taking Corey to the hospital. He's been sleeping a lot. He's not eating. His legs hurt and he's throwing up. But I don't think that was true. I don't think he was throwing up or anything. But he hung up on, well, he asked me for Corey's insurance card, hung up on me, and I'm trying to think. I'm sorry. And then he hung up on me. And then I texted him a few times saying, what hospital are you at? I'm going to meet you there. I need to be with Corey. I called him a lot. He didn't answer me. And after, I would say about like 20-30 minutes, I called the police and I told them what was going on, that he had called me and said Corey was sick. He was taking him to the hospital and now he's not answering me. So then the police went to his house and called him and he wouldn't answer. And, you know, all this is going on and I'm freaking out, but I'm not thinking like it was that serious. I just thought he was sick and, you know, throwing up maybe. And I just, because he was fine earlier in the morning. And then I get a knock on my door and it's the cops. And I just figured like, oh, they're here. They're going to tell me where Corey is. And yeah, that's when they told me that Corey passed away.
Oh my gosh. Oh my gosh. Oh.
I just don't think people realize how precious other people are, and animals. Let's talk about animals. I was watching this clip of this YouTuber attacking her dog. Now, if you ever get a pet for the first time, and I'm not a fan of pets, I think I love animals, so I've trained a lot of animals. Like I've had 10 acres and a big art gallery where tourists would come in. Highland cow, my pet pig that could count to 10. I've had massive newspaper stories. I've got a really good history behind me with animals. We had a German Shepherd growing up named Duke. But one thing you need to learn about, let's just talk about animals for a minute, is if you bring on a pet, don't ever hit them. I've seen this YouTuber hitting a dog. Or a cat. If your kid hits a cat, say you tell your kid off for messing with the cat. If you actually pick that cat up gently and bring it up to your face after one of your kids has whacked it, all of its mouth and its side of its nose will be swollen. You know, if somebody's smacking their dog on the nose, if you actually stopped time, brought that dog up, all of the nose, all the blood would be swollen and bruised around there. So what he did to that kid was extreme to the extreme, right? You know, New Jersey needs to bring back a special, in my opinion, a specialized death sentence, just especially for Chris Greger. And then I'd like to see some sentences for David Greger. I'd like to, the people, each name from that DCPMP and the police, right? From the first through that whole middle section where it just went to custody, and that made her think she had to take that child back to him, right? Because she was 23, your brain, you should really know, but she said she had some stuff go on earlier in her life. She's already gone through enough trauma, right? And now she's got the trauma of losing her child. She's under 25, so her frontal lobe hasn't fully developed to about around 25. And then you should really know right from wrong. So everything is going against Brianna. The police have gone against her, the DCFS, the DCPMP. The laws that allowed Chris, and how did that happen? David Greger, right? That Homeland Security guard, that lifetime police cop. He's done this, in my opinion, and I'm allowed an opinion. This is my true crime television, and I'm sure of it from watching him testify in that trial. I'm sure of it. And swept it under the rug and let that son of his kill him.
And it just didn't make sense because he was okay 6 hours before this. And then after they told me that, I was like, he killed Corey. I can't believe he did it. And after that, I asked them where Chris was. And like, what's going on? Because I knew what he did to Corey, but I didn't think he was just not even gonna come tell me that Corey passed away. So, they told me they didn't know where he was and they were looking for him. And, they eventually found him in Tennessee. And, I found out later that he just dropped Corey off at the hospital while Corey was dying and he didn't have anyone with him. So, yeah, so he ran to Tennessee, and I guess he got a lawyer before he came back to New Jersey. So when he came back to New Jersey, he didn't have to answer any questions the cops had for him. He pleaded the Fifth Amendment. And to this day, he still hasn't answered one question about what happened to Corey that day.
Wow.
And since then, he was charged with child abuse for the surveillance video that the police had. They retrieved after Corey passed away.
Hi, Elizabeth. Welcome.
So he's been charged with child abuse, but not Corey's death.
Wow.
And I found out that Corey passed away from a heart contusion, which is a bruise to the heart. There's only a few ways that happens, and one way is falling from a 2-story building and falling on the ground, and then another is a car accident, and then another is blunt force trauma. And we know that Corey wasn't in a car accident. We know he didn't fall. So the only thing left is that Chris hit him. But unfortunately, right now, the medical examiner is coming back with undetermined regarding his manner of death. So as of right now, he hasn't been charged with murder, which he should be. And yeah, I mean, that's where we're at right now.
Complete risk to any other children. And what is it he does for work? Because that's also important.
He was a teacher. He got fired because he
Are
was
other chats
arrested
saying that? That's horrible.
marijuana possession a couple years ago.
Hold on. Sorry.
And then at the time of Corey's death, I think he was a real estate agent, which he no longer has a license for, I believe, because he can't be around children. And when you're a real estate agent, children come with their parents to see a house, and he can't do that. So I think they revoked his license.
That's good. So he.
It's 1:51 p.m. We're back on the record. All jurors are present. Court staff has gone to escort those jurors over. We're just going to bring over the 12 deliberating jurors, have them go in the jury room, and then the 3 alternates are going to stay in jury assembly.
Okay, after watching her, I think she makes a point where she says she didn't believe that Corey was throwing up. That's something I didn't even think about. He was probably making that up. What is he smiling? Is he smiling? And I wonder if because they said he defecated himself. I wonder if he did because he was knocked out, like he was unconscious, right? Like he didn't have any control of his bodily functions, right? Yeah, the guy we were just listening to, he just mentioned that David Greger is the one who came up with the story about the soccer ball, that's how he got the lip injury. Yeah, and David Greger is the one that sent him away on the hiking excursion or retreat or whatever you want to call it. That's where he was before he got arrested, and they told him that they brought him back. Right, I know, Kathy. I don't. What the heck is he smiling about? The way that guy was explaining what he was doing to him in the video is just like, "Hi, Miss America, welcome." I don't know. It's so crazy. I'm so glad you found your way back, Jenny. I did not know they were talking like that about Brianna. I think that's absolutely horrific. Like I've said before, no one can judge.
Before going to the jury room to tell them to recommence their deliberations. They don't need to get seated in the box.
No one has the right to judge someone. I mean, my God, if your child was taken away from you after you've had your child his whole life, and in a matter of months, you lost your child to the person who argued you, because on YouTube you're not allowed to say, and I'm very bad about not being able to say the words that I'm so used to saying in normal conversation. But if you lost your child to the very person that did such a horrific thing to you.
Yeah, I'm just going to have a pause in the courtroom for a minute and then go straight to back.
I mean, my gosh, what do you expect? What? They do? Are you serious? I can't believe that. That's awful. My God, she lost her child. That's horrific. People are so mean. It's so easy to be keyboard warriors, you know, because I get that a lot on my I know I say what I want on my channel for the most part. I can't like they say unalived and all kinds of crap. That's not even a word. I don't understand that.
At this time, please recommence your deliberations.
Probably why I'm not monetized yet.
Thank you, and set a notification.
Because it's so hard for me not to say the words. But
Okay, I'll ask you. Okay.
I just can't imagine people
Thank you, sorry.
saying ugly things about someone who lost their child. Thank you so much, Jenny. I appreciate you guys so much. Really, I do. It's amazing. I didn't know there were. I honestly was losing my faith.
The jury's back in the jury room.
People being nice, because I get a lot of hate on TikTok and stuff like that when I talk about when I make any comments about you know, it costs $0 to be kind and respectful. And for some reason the keyboard warriors out there feel the need to be ugly. So, but whatever. Can't win them all. Like that person that said I was unprofessional for not wearing makeup. Look, people, I had to get up at like 7 something in the morning to get this thing started. I'm not putting on makeup. I'm so sorry for your luck. They're back deliberating, Kirsten. They are back from lunch and deliberating. He was there earlier, but he's not coming back and forth for all of the stuff. Thank you, Jen. I appreciate it. I don't usually wear makeup that much anyway, so I did yesterday for you guys. I got myself all dolled up. Just kidding. I wasn't that dolled up. Yeah, they don't come back and forth for all the questions and whatnot. Oh, thank you, Jenny. You're so sweet. You guys are so sweet. You really are. You guys are just trying to make me feel like I have a big head now. I'm gonna start feeling like I can't fit in the room. Oh my gosh. You guys are great, really. I hope you guys keep watching the channel and keep checking it out. I hope we keep finding trials we can do lives on. I like doing lives. It gives me something to do because I'm off all week long. I only work on the weekends. Ja, Kirsten. Danke. Das ist gut. Yeah, we've had several people come in and out. Our first live, we came up to like 200 people on our first live. It was pretty cool, but I think we don't do a lot of smack talking on here, so we've kind of chilled down. Are they doing sentencing today, Selena? The slow down video, is it on that guy's channel? Is that where it is? The one that we were just watching? I forgot what his channel name is. Oh yeah, we definitely don't. There's no need to attack anyone on here for sure. I mean, you know what? Everyone has an opinion. We all know what the saying is about that, but whatever. I mean, but we can have what I appreciate is good conversation and not I mean, we can have difference of opinion. Oh yeah, I watched that channel, Grizzly True Crime. I watched several other crime channels. But now that I have this one doing my own. Yeah, for sure. I love being able to have a good conversation, open to other people's opinions, of course, because I mean, we can't all think alike. My goodness, if we did, then what would be the point? But definitely not attacking other people for having a different opinion. True crime TV. Okay. Let's okay, before I look it up, I have to take a potty break. So if anyone needs to go take a potty break real quick, sorry, TMI. All right, real quick, and I'll be right back, and then we'll look it up. And for those of you who don't want to watch, I'll give a forewarning. We're gonna watch the slowed down video of the treadmill video. I'm just letting everyone know we're going to watch the slowed down video when we come back from a potty break. And if no one wants to watch it, you may not watch. I'm just going to forewarn everyone. If you don't want to watch it, you don't have to watch it. It will be very difficult to see. I personally don't know if I will want to watch it, but I will put it up. Okay. Be right back.
Human beings are capable of horrifying, spine-chilling.
Hi, Kelly Hall coming to you live, loud and local from my back of my art gallery in New Zealand. And today we're just going over some truths from the past that need to be cleared up. You know, this is a hot case. It's coming out of New Jersey, and it's about Corey Bichelo. But hi, Kaylee Hall coming to you live, loud and local from the back of my art gallery. I live rural. That's what you wear when you live rural. The old swan dry. Now, a message to Brianna and her friends and colleagues that reached out to me asking for information on new charges they could put on this case. So, first of all, you need some evidence, which I've got here, and we'll slow it down. You have to watch this to have the evidence, right? Well, your lawyer will have to. First of all, I would take it to the police and start over again. So, Chris has been charged with Christopher John Gregor has been charged with endangering a child, this Treadmill video, and murder. Right? So
I think we found it. So
now,
if
I'm
anyone
not
who
sure.
wants
I
to
know
watch
that
it,
murder is murder 1, right? So that will come with the maximum. And then endangering a child, there'll be different levels of it, which we can read through shortly to know where we're at. But there are other laws in New Jersey that you can.
And
You
yes,
would have
Jenny,
to
I've
just
heard
take the
Gisella's
video into police and show them
channel.
the video. So I'm going to play the video for you now, but I need to slow down the footage to show you the other crimes. So I looked up your endangering a child law, and that encompasses all child abuse, everything that happened to him around this event, but it doesn't encompass assault or battery. So because Corey is an individual human, he has the right, and probably still has, I don't know, I'm not a lawyer, he has the right to not be touched by anyone, either parent, right? Even a doctor. A doctor, if he went to the doctors could say, can I lift your top up? Can I put my hand on your chest? You need to have consent for anything, from a teacher, from a auntie for a hug. Everything needs to be consented. So this is to the extreme scale, and I think this is as close to murder on the day as you could get, in my personal opinion. So, but we're not going on personal opinion. So I'm going to let this play. Right, so I'm turning off the audio from the court. This is the court evidence. It's been put into evidence. So now I've got this running at half speed. Corey's been running for quite a while. You might want to, one thing you might want to know while this is going on is, how can I handle watching this over and over? It's rough. You can't ever unsee it. But I've had some therapy training. So I was a art therapist at the Cancer Society for stage 4 patients in their 70s, teaching them how to paint. A bit of a distraction for chemo, and quite a few of them have passed away. But it's I won an award for it. I won a medal with my name on the back. We're doing that, raising money for the Loss and Grief Centre for parents that have lost children, and I gained some therapy skills there. Basically, for anyone that's watching this, when the information or watching this hits you, you think of it hitting you like a shower of water and it washing off down a duck's back. Or you standing in the shower, that horrible information hits your head, and then you just think of it washing off your back like a shower of bad information, and you never let it sink in. Right, so here's your endangerment still, right? I'll use my cursor. He's pressed the button and it's gone up, and he's been running for ages. So that would cover the child abuse and that endangerment that he's already charged. But I'm not a lawyer, but that's what I think. So the next charges I think you can put on will be here in a second.
So for anyone tuning in, we are watching the slowed down version of the Treadmill video. If you don't want to watch it, you don't have to.
To be fair, if Corey was still alive, I think he's a superhero.
He is.
Checked each side of his head then.
Hi, you're back.
I'm going to slow this down. I haven't done this in any other video, but I'm going to take this down to 0.25, which is very, very slow. I've turned the audio off though, so it won't go rah, rah, rah.
Oh, he's really slowing it down.
So the police are likely for an assault charge, and there is a real high, we'll go through all the laws. I'm happy to do that for you. I'm working for you today. Yeah, let's just go through it. I just think there's multiple. For me personally, I would ask for multiple charges regardless. You're better off asking for way more than you can get. Way more. Pile it all on. So this is calculated. I hadn't thought about this until now, but the endangerment should finish there where you come off the endangerment is the act, right, of putting the child in danger, and it's endangerment. So we'll read through the law in a minute, but I think as soon as he fell off, I think that's an assault charge here, but there's plenty more. And I think because there's a series of actions that happen, I think, do you have, let me know in the comments if you have a Senate in New Jersey. Does New Jersey have its own Senate, or is it in New York? Or please let me know where your Senate is, because they need to see this to look at their laws. So he puts his hands on him. Because this is he's being charged, this isn't, there's no consent to do this. Corey would not consent to it, to him putting his hands on his shoulders. So I think that's a second assault charge, but I don't know, it could all be one assault charge. Hands on the shoulders. If there was a teacher doing that, they'd be fired just for putting the hands on the shoulders now. So he grabs his wrist. There's an assault charge, bruising his wrists. Puts his hands in behind his back and does something. So you probably need a forensic, you need this to be forensically assessed, right, by an expert, which isn't happening in the trial. But the judge said today in the trial that trials change, they change with what's brought in. I think a forensic, just what I'm doing the forensics now, but with an expert that testifies in trial, okay? All this will be free for you, Brianna. It won't cost anything. You just go in, you take this video, what I'm doing now, to the police and tell them to watch it. And your lawyer. And you need a really good lawyer. It'll be free to go and see the lawyer. So I need to talk to someone. I'm in a high profile case. I want to charge an assault charge. And we'll go over RAPE later too. So there's another, he's assaulting him under his, this is all hardcore bruising and damaging. Could easily break a bone in his arms there, but I don't think he did. But I have to show you as he gets off the treadmill when this is finished, he's not the same kid that went on the treadmill, which is, I think, a form of battery and mental abuse too, which I don't think that comes into the endangerment. I think it's another charge.
That he didn't break anything.
Well, he pushes him forwards there. He's bending. See how his knees, if he hasn't stretched, his shoulders are coming into his knees there, and it's sort of a bent back twist assault there. So I think there's a third or fourth assault there. The way he grabs him here, he puts his hands in and pushes down on the inside of his chest. Just there. Now, he's a fully grown adult that can push a lot of weight, right, and power and muscle. See how his muscles are flexing on his arms? He's putting all the pressure he can into that 6-year-old. I know this is tough, but you got to tough through it. Assault charge. He hasn't got an assault charge, and we'll get to it. This is really, really bad. This is really bad. Probably, I think this is the most painful one. That what's going on here, that downward pressure into that floor. Oh, sorry, I need to put my mouse. So here, there's really strong downward pressure into the floor through his butt. I'd shit myself. There. See, he really pushed him down into the floor. So, attempted murder, manslaughter. What else is it meant to do? It's not teaching him anything. Now, the way his legs lifted up off the ground, if he was holding onto the jersey, the jersey would have come up. So I think he's holding onto his skin. So there's another assault charge, in my opinion. I think he's holding onto the skin of his top, his body, that lifts him off the ground then. See how his top's not quite lifting up? So he must be holding under like his breast skin. And then I think he sticks his wrists under his, I think he sticks his wrists up under his chin. So all of this is off the treadmill, right? This is just a public daylight assault, right? Public daylight physical assault. So that isn't endangering a child on the treadmill. Treadmill's over here, okay? So there's a lot more going on here than just child abuse. Corey would have, if Corey survived this, he would have his own lawyer, not his mother's lawyer, because Corey would have a
See you later,
lawyer to
silencing.
protect him from both parents. It's just how it would work. But I don't know how it works in death, so. So he picks him straight up in the air, up off the ground, holding his skin and top and everything. To me, each of these, yeah, it's all in movements, but I think individual charges for me personally. So Corey's fighting for his own life here to try and pull him off. Of course he can't, but his hands, I can't go back in time, but his hands are trying to pull him off. So he's trying to defend himself against that attack. So that's a separate attack. This is not all one. Those movements there had nothing to do with him endangering him on the treadmill. And it's that bit there, even though it is child abuse, it's an assault. 2 charges. Child abuse, which comes under the endangerment, but assault, I'll show you in a minute. Anyway, we're going to look at some law pages. So Corey doesn't want to run. Like, he's making him go on there. He's forcing him down, and he puts his face down into his head. And he sort of gets his jaw ready and then bites in. Mike Tyson, who also got done for rape and assault, talked about how he wanted to kill people during a fight and that he just wanted to kill. Part of killing him was biting, and there's a lot of biting in crimes. And Brianna's team just told me that
Yeah, it is wide open.
in his autopsy, there's these big bite marks. So this is a separate assault away from, this is assault again. And why would you do that to him? I think you've gone past the endangering here. Like, the endangering, I think, is finished. And I think you're upper level before murder, right? So that isn't endangering a child. So this is a form of assault, I think. Physical. And I think, I don't know if it's sexual. It has to be some sort of murder fetish, right? There'll be studies on it that people will be able to, that'll explain what he's doing, because I don't know. This is the first bite, second bite, and then a third bite. So when you think of the levels of the bite, down to when he's on his knees and trying to fight off his father, which he can't. So he's a hero, right? That's an entirely different assault. Fourth bite down. Okay. And he's trying to pull him off. They're not even looking at the thing, and now he's trying to eat him. So, cannibal? There must be somebody out there, a lawyer, that can advise in the comment section. These videos are getting 10, 20,000, up to 90,000 views, right? There has to be some professionals out there that can help me, help Brianna. They've reached out to me. Now I'm reaching out to you. Help me. Please help. So I need to show you also how he finishes on the, oh, that's tough. I need to show you how he finishes on the treadmill. One thing you have to realize when this was played in court, it's over in a, the whole thing goes for about 12 minutes and about 4 or 5 different videos. But that segment there is less than a minute, I'd say, maybe 40 seconds. So, but you know how they forensically go through phones. I've forensically found this assault within the endangerment. Right, speed it up.
Yeah, the jury does not see it slowed down.
No, this is when all the falls happen. So this goes back to that endangerment charge. All that would fall within that because he hasn't got his hands on him. He's using it as a weapon. And fortunately, Chris's useless lawyer said that we accept all the bruises. Okay, so they accept the charge. He's trying to get him off the murder charge. So need more charges. Then there's some sort of verbal tirade here, which also would fall into that child abuse charge. Right, I need to pause here and slow this down. This is very, very important. This wasn't part, this is part of my investigation. I want to show you how this changed his life. You watch the way he steps back. See that? See that? See the way he's stumbling? He's gone. And then his father walked away from it. So he abandoned him there. See, his clothes are all fucked up. Everything's gone. Can't walk properly. And he's 6. He's 6. I know I would like 10 minutes alone with Chris, but I'm sure millions of other people do too. Right. Let's go to the law and help you out on that side. Okay. So this is Lento law firm in New Jersey.
Hey,
we have to
Jen.
focus on New Jersey law because every state's going to be different, right? First of all, the charge that he has got is endangering the welfare of children. That's his first charge. Endangering the welfare of child charges in New Jersey are incredibly serious. I just need to move my camera. Sorry, I'm doing this on the fly. Involves sexual acts that could negatively the child by a person responsible for the child. So this
Hi,
is
Joyce.
a
Welcome to
defense
the chat.
firm, which is why it's important to read this. Any person having a legal duty for the care of the child has assumed responsibility of care of the child. This is how it can be committed: molestation, abuse, creating, pornography, DYFS hearings, portray a child, statutory sexual assault, driving while intoxicated. So penalties for what he's up for is from 5 to 10 years in prison, maximum fine of 150,000. First degree felony is 10 to 20 years with fine up to 200,000. And then between 3 and 5 years in prison with third degree.
Okay, I know everybody's tired of looking at that bird, but I think the bird is actually a relief right now. So that was very hard to watch. And I know the jury does not get to see the slowed down version. So we are seeing something that the jury is not seeing, but I think the video in itself is pretty horrific, and we can all agree to that. So while the jury is out, I really would like to just say a prayer for the jury, for Brianna, for Corey, for all of us who are, obviously wanting justice for Corey. I definitely didn't get the biting, Jen, until someone pointed it out to me. So I want us to all say a prayer that God is with the jury. So if you guys don't mind, for us to have a moment to say a prayer for Corey and Brianna. Hi, Elizabeth. Welcome. Lord, please be with the jury in the jury room while they're deliberating, and give them the wisdom and the strength to make the right decision that is necessary for Corey and for Brianna to finally get peace. Please pray. We pray in your name that Christopher gets some sort of guilt or remorse, or understands what he did was wrong. Lord, we pray that Corey is with you in your loving arms, and we pray that you wrap your arms around Brianna and her family, and that you help make some sort of sense and understanding as to why you need Corey with you at such a young age. And we pray that he did not have to suffer too much. And we pray, Lord, that you give Brianna peace and give her family understanding and peace. And Lord, we pray that you help Christopher and his family find you. And pray, Lord, that Brianna does not hold hate and can give forgiveness. And Lord, we pray that you help this jury, even though this video is out there for the whole wide world to see, that we pray, Lord, that it is not something that it makes everyone sick, Lord. So we pray, Lord, that we can learn something from this, and we pray that we can help, hopefully, New Jersey and the state children protective services find a better way, not just in the state of New Jersey, but everywhere in the United States and the world, to help children. So, Lord, we pray that you give Christopher the justice he deserves, and we pray that you give Corey the justice he deserves, and we pray that you just give everyone peace. In your precious name we pray. Amen. So, I hope that the jury makes the right decision, you guys. I'm so sad after seeing that video. I don't know what to say. Oh. Well, thank you guys for being here for sure. I think they're going to come back pretty soon. I don't think it's going to be much longer, hopefully. Hi, Brandy. Welcome. Thank you, Silencing Whispers. Thank you, Kirsten. Yeah. I don't think he shed a tear, you know. I honestly, Kathy, I don't think Corey, I think he was so strong. He just kept getting back up and kept trying. And I don't think he cried at all. And he was so strong and so brave, and he really did try to shake it off. And he just did so well. Hey sis, I see you. That's my sister, Lindsay. Yeah, I know they said there was another video before that video on the 20th, but they also said something about the 29th, you guys. So I'm not sure what they're talking about. Maybe they'll release that after the trial is over. So we'll see. And I wonder what he was saying to him, you know, while he's on the treadmill. He probably was too scared. I imagine he was terrified. And like we talked about last night, Lindsay, he knew exactly what to do when he went into that gym, when he got on that treadmill. So it wasn't the first time. I love you, sis. It wasn't the first time he's been punished that way. So we know Christopher has been treating him that way from the beginning, I imagine. And probably his grandfather. I don't understand the too fat thing. What the heck? I was wondering where that phrase came from until we saw the Brianna interview. And now that, yeah, comes together. That's right, Selena, he is. Well, you know, I was thinking, watching that video in slow time, imagine if someone had walked into that gym, you know? He didn't have a care in the world if anyone walked in there. Right? Yeah, it's kind of a ironic statement. Doesn't make any sense. Well, as Brianna said, when she took him to the pediatrician and the pediatrician had her go to the emergency room, that the bruises on him looked like he had been beaten with a baseball bat. So how awful is that? And she has over 100 reports to the Child Protective Services. I mean, and clearly they had the video because they told him not to take him to the gym again. That was their decision. Just don't take him back to the gym. You abused your child in the gym, but just don't take him back. That just makes no sense. Yeah, you know, I wonder if anyone would have said anything if they had walked in. That they are. Even though I do tell my youngest he was put here to drive me absolutely insane. He's 24 now and he still tries to drive me absolutely insane. I'm pretty sure that's what his goal in life is to drive me insane. Hi, sugar baby. Welcome. We're getting all kinds of new people in here. This is great. They, you know what? You're right, Selena. More people will not act. Which is crazy. You know, that is it's very true. People don't do anything because one time, I think I've mentioned I have epilepsy. My boyfriend and I were, Nigeria. Awesome. Welcome. My boyfriend and I were leaving a store in the parking lot and I had a full-blown seizure in the parking lot and he had a bag in his hand and had me try to get me into the car, he said. And I look like I was like a dead body basically. And he's trying to put me in the car and no one even cared. He said that he's trying to put me in the car and no one thought, what is this guy doing with this woman, putting her in a vehicle? And no one thought that was weird. So yeah, no, nobody helps. Nope. Kindness. You know what's funny? My boyfriend and I were talking about that last night, talking about being kind. Like kindness doesn't cost you a penny. And then one of the guys at work that he works with said, "What does it cost to be a butthole?" And he was like, "Okay, touche, but still, it doesn't cost anything to be nice." Yeah, it was literally like I was a dead body. He said he was putting me in the car, trying to get me in the car, and I was like having a dang seizure, and nobody said a word. Nobody was like, "That's kind of odd, that guy like throwing this chick in a car." Like, nope, nobody said a thing. Well, I think it's sad, but there's a lot of Chris Gregors out there. As we've seen, Selena, with the Daniel Garcia, Adam Montgomery. Also, if you've been following the Soto case, that's a terrible one too. I'm waiting to see if they're going to do anything with the mother in that situation, because that one's really sad as well. it took forever for them to finally arrest the stepdad. Oh my gosh, Gwen, that's terrible. I'm sorry. Yeah, more often than not, people just keep going. So it's so sad how our society is just kind of just become numb to this kind of stuff. Like a lot of people, I bet, watch that video and don't think twice about it because we're so used to seeing such just so much tragedy that they probably don't even look at that video even and think anything of it. I hope it cost Chris his life for sure. I hope they do come back with, we'll see. I don't know. Like I said, the charges are, for those of you who have joined and didn't hear earlier. So I'll recap what charges are going for Chris. So we have obviously the abuse is count 1, endangering a child and abuse of a child. And that is for the Treadmill video. So there is a reason that Treadmill video is in there. I thought it was in there just to show a pattern of Christopher's behavior, but it's actually, he does have an abuse charge against him, and it is for the Treadmill video. The count 2 is for murder, and that is for purposefully and knowingly committing murder, and that is killing Corey beyond a reasonable doubt. But then they added the lesser charges of aggravated manslaughter, and that is acted recklessly, disregarded life, gross negligence, and was aware that his action was caused the death of Corey. Or they can consider reckless manslaughter, which his conduct caused the death, and he was aware that his acts would cause the death of Corey. So they have 3 different charges to decide on. Now, what the jury does not know is that these 3 different charges have 3 different sentence lengths. And the murder, of course, is 30 years to life. The aggravated manslaughter is 10 to 30 years. And reckless manslaughter is only 5 to 10 years. So that's what the jury does not know. We'll see which one they pick, or if they pick them all. I don't know. I don't know if they can pick them all. Actually, I didn't know if it was. I don't know if it's an and or. Is it if it's and or an or? Adam Montgomery didn't even show up for his trial. They made him show up for his sentencing, though. That's right. Yeah, Jen, that's what I'm worried about, is that I'm kind of worried about if they don't pick murder and they go with one of these manslaughter charges, he could get out with good behavior. Yeah, Erna, I'm worried if he gets the aggravated manslaughter one, which has the higher sentence of the manslaughter charges, that he could get out on parole on good behavior. So I don't know. But now keep in mind the child abuse charges, I don't know if the judge will give him credit for that. He might. But now the child abuse charges also, those that actually holds a pretty good amount of time. So, I mean, he could still get at least 30 years, at least. But he'll still be pretty young. I mean, he's only 31. I mean, I guess 50 or 60 years old. It's still pretty young. So I don't know. We'll see. Still, I mean, I don't know. I think that's what they're having trouble deciding on. I think they're pretty solid on that abuse, but yeah, Gwen, if you're writing people in prison and speaking the word, you're definitely doing something. I learned that I don't know if any of you know who Vadi Bakum is, but he's my favorite preacher. But I learned that, you know, how we used to send missionaries over, and we still do, but over to other countries to preach the word. We actually, in the United States, are the lowest. We're in more need of missionaries in the United States than anywhere else in the world. It's pretty sad. But that's what they say, because we've lost our way here more than anywhere else in the world. I actually have tickets to go see Vadi in Dallas this weekend, and I can't go. It's pretty disappointing. We don't have China on here today. I wonder where she's at. Kirby Ministries. Have not heard of that one, Kirby Ministries. Oh, Curb Ministries. Let me see. So, does anyone know why they're not doing the Karen Reed trial today or yesterday? Well, they took 2 days off. Oh, okay, cool. I'll have to look it up. Oh, there you are. Okay. Okay. I was wondering, I was like, usually you say something. We've been trying to pass the time watching some other videos. Someone mentioned earlier that Scott Peterson, right? The judge threw him a blow. He's not going to get some evidence looked at, but they are. I think Gwen mentioned he's going to have that. They are going to look at some duct tape evidence for him. We talked about. Have you guys been following the Delphi murders? Do you think they have the right guy for the two girls? Yeah, watching her interview broke my heart. She hadn't even seen the treadmill video, and she was tore up about that. She was just going based off what someone had told her about it, and it was really sad. Yeah, they say there might be someone else. I don't know if they have the right person. It's really hard to tell because they were just basing it off that little bit of recording. I honestly don't know. I don't believe the whole ritual thing that they're going for. I'm not really sure about that. Yeah, it's a huge mystery. I don't know. I need to see what evidence they have. Ah, okay. Yeah, everything's cuckoo for Cocoa Puffs right now, Jenny. So I have not watched any of the Daybell, Chad Daybell trial. Oh, hi, Joanne. Welcome. Thank you. You're so sweet. Oh, thank you, Kirsten. I'm really hoping the jury. I'm glad they're taking their time actually, because I kind of thought they would rush it because they've been, really kind of pulled back and forth so much. The guy that stabbed the 4 girls at the movie theater, is that what you're talking about? That was kind of out of the blue. Yeah, that was weird. Really? I didn't hear that part. I heard about the 4 girls. I was like, what the heck? That's really weird. We have just some absolute craziness going on. Oh, that's crazy. I I definitely. So I right now I just saw last night about something about a girl in LSU at LSU. I haven't caught up on. I just saw the caption. And then I want to do a story about Lake and Riley because I don't want her to be forgotten. That is so random. Oh yeah, we definitely have a good little group. Hi, Lynn. Oh, oh, they're having another hearing for Brian Koberger. Welcome to the chat. That's right. That's what they say. 2 or more. My other computer, for whatever reason, like has decided for the brightness to go down. I've tried to like make it go up and it won't, but. So Brian Koberger's having another hearing right now. They have DNA experts testifying today. Yeah, I'm on the fence about this guy, so I am definitely going to be keeping up with this trial because, and I don't think it's going to go to trial. They're talking about like 2025, 2026, y'all. So, I mean, he has waived his right to a speedy trial. So they're fighting to toss out that DNA that they say was found at the crime scene on that knife sheath. So we're going to find out if that gets put in. That will be interesting. If it gets thrown out, that's all they got. Brian Koberger. Selena. They're having a hearing today. I'm going to have to catch up on that. Literally the only evidence they have is that knife sheath. Everything else does not point anything to him. They have a video of a car similar to his in the area, but they can't guarantee it's his car. Yeah, they can't guarantee it's his car. They just have a picture, a video of a white car. There's literally nothing linking him. So I'm not sure. And like I said, in that case, I mean, I studied forensics and criminal justice. So there's what we call low cards theory. I don't know if they still use this, but it's when you have a crime scene, you go in to out. So you have to spread the crime scene out as far as possible. We'll have to look that one up, Kirsten. But they had so much cross-contamination, taking evidence out of the scene. It was just so much. And they were handing off evidence to other people. And some of those people had gloves, some of those people didn't. And then they put it all inside of a U-Haul truck or something. And all of that evidence was touching each other. It just, I don't know. It's kind of weird. And it was such a small police department handling a quadruple murder. Just strange. Yeah, where is John's other shoe? Wait, and they didn't go into the house. They didn't inspect anything in the house. And also, how the heck did the people sleep through the Alberts? How did they sleep through ambulances and fire trucks and all of that in their front yard? And Karen screaming her full head off, at the top of her lungs. How did they sleep through that? I don't understand it. Like they're like, oh yeah, we didn't wake up. You didn't wake up. She was screaming. There's with all the testimony, everybody's saying that they're trying to make her shut up, make her stop screaming because she is screaming and going to wake up the whole neighborhood. But yet they didn't wake up. You got fire trucks, you got police cars, you got EMS, you got all this stuff going on in your front yard, and you didn't wake up. Also, your dog didn't do anything. This dog that is supposed to be like not friendly, all this stuff, your dog didn't do anything. And somehow Jennifer McCabe busts up in their bedroom and their dog doesn't react, the one that's not friendly. I don't understand. None of that story makes any sense. I find it very hard to believe. But I also don't understand why they're covering for each other, but they're clearly lying. Somebody's lying about something. I don't know what it is, but something. I mean, and like every single one of them, okay, they all got new phones or new phone numbers, and they sold their house and they got rid of the dog. They had that dog for like 7 years, y'all. Who gets rid of their dog? That's just odd. I just think it's weird. I don't know. Right? I know. It's like everything that I don't remember. I don't recall. I can't, I don't know. I mean, he could. There's a lot of people, but I mean, it would depend. I mean, think about it. There's a lot of people that have been in prison and found out they were innocent, and they don't get anything but their freedom because the DA is not going to admit that they were wrong. They'll never admit that. And what's so sad is that they've put all their eggs in that basket. I mean, and the families for sure think he's guilty. That's what I hate about these situations is that, like with John O'Keefe, they've put all their eggs in the basket of Karen Read. That we're never going to know what actually happened to John O'Keefe. Oh, yes. He is. How was that? Do you think he actually did it, Erna? Oh man, the Central Park 5, that is a horrible, horrible situation. No, it's terrible. That's what I say in every video I post about that trial. Joanne, welcome to the chat. That John O'Keefe is totally forgotten. His family, everything is just completely on the back burner. It's all about, like, I'm not on either side. I just want justice for John, but he's never going to get justice. His family's never going to get it. It's so sad. They're never going to reinvestigate this case. If Karen gets found not guilty, they're never going to open it back up. That's the sad part. Yeah, I can't believe Oscar only spent 11 years and he got out. Yeah, I definitely feel for John O'Keefe. I mean, that poor family. I mean, my God, they lost. He's lost his brother-in-law, sister. He was taking care of his niece and nephew. I think. Yeah, it is. Yeah, I think. What it is sad because I can promise you, they're not going to reinvestigate John O'Keefe's death. Yeah, his brother and his sister-in-law. Yeah, they're there every day. And they're sitting right by Karen. I'm sure Brian Koberger will sue. His parents will probably definitely want him to sue. But he's staunch on his innocence. And he goes into court every day with a grin on his face. They're like really watching, but I mean, I can't tell if they think she's guilty or not. I mean, I'm kind of wondering how they feel about this whole situation. I mean, they have to know where they're from. I mean, it is a system, like they have to know that if she's found not guilty, they have to know that his death will never be reinvestigated or opened up again. Yeah. Super sad situation. I hate that. I wonder what time that one juror had to be at the wedding. Oh, that is Corey Richens. I got to catch up on that. She did an interview, I think, the other day, and I meant to watch it. I've been so many things I have to catch up on, you guys. But yes, she supposedly she's fighting that. She said she didn't do it. I don't know how many. Hi, Joanne. How do I send you for a copy? Oh, thank you, Joanne. I'm not monetized yet. Hopefully soon. I have to get more views, and then I'll do some memberships and super chats when I get big. I'm just a little old YouTuber right now. Did they? Oh gosh, I have to look that up. Oh man, I need to catch up on that. I think, oh gosh, who was it that's been through a couple of attorneys already? The other trial I'm gonna keeping up with is the woman who put her boyfriend in the suitcase. I'm having a brain fart right now. She's been through a ton of attorneys already. Darn it. She put her boyfriend in the suitcase. Boone. Thanks. Thank you, China. Sarah Boone. Yes. She can't keep a lawyer. Yes. I don't even know how he fit in that suitcase. Oh my goodness. But she videoed it. Yes. Oh my gosh. Yes. Yeah. But you know what else is that's Corey Richins isn't the first person to write a book about killing her husband. Well, Corey Richins wrote a child's book for her, the husband dying, but the other trial I watched was about a lady who killed her husband, and she wrote a book, and danged if they didn't use that book against her. It was an older lady. Her husband was a chef, and he taught at a school. I can't remember what state it was in, but I did watch that trial, and she killed her husband. Yeah. Yes, he was alive and he died in the suitcase. It was horrible. That's what she said. He was playing hide and seek. Whatever. She videoed that whole thing. And then she went upstairs and went to bed and left him in there. He was all squinched up in the suitcase. Oh, I mean, but she has been through so many attorneys. Oh my gosh. It is hilarious to watch people represent themselves in court. I mean, if y'all remember the parade driver, what crazy guy represented himself. Oh my Lord, bless that judge's heart. That guy was nutso, and he represented himself every day. It was like a circus show. It was nuts. I could not imagine. He was allowed to, like, because he was representing himself, he was allowed to question all the witnesses. That is so awful. Daryl Brooks, yes. China, you are on point today, girl. You were like, forget this work. I know all these names. Yes, that guy is cuckoo for Cocoa Puffs crazy. Whew. And that judge, I tell you what, she did everything but strap him down and make him look like Hannibal Lecter. I mean, I did see one case. Which case was it? China will probably know. I just have to put out a vague description and China will come up with the name. There was a case where somebody had to let their lawyer go. The Farrader trial. The wife, she had to let her attorneys go, and the judge in Florida was like, we are not postponing this trial any longer. And I guess they had to postpone it longer because she couldn't keep up she was firing her attorneys. That she does not, Tracy Ferreter, duh, how can I not remember her name? It's my name. She was trying to get her trial postponed, so she fired her attorney, hired another attorney, and that attorney said, there's no way I can be ready in time for trial. And the judge was like, I don't care, you're going to be ready, or because we're doing this trial. And then that lawyer came up and said, I'm not ready. So the judge had no choice, because we were supposed to actually be in trial for Tracy Ferreter right now. But that was the boy in the box trial. Yes. Tim already had his trial. But I covered that one on my last, when I had this channel before, I covered that trial. But I will definitely be covering Tracy Ferreter.
1 p.m. We're back on the record. We have a note from the jury, which is marked as Court Exhibit C-19 in evidence. Quote, we feel we'd like to hear Dr. Andrews' testimony again. Is that possible?
Oh.
End quote. Counsel, we have our court reporter ready to be able to read back that testimony. Any positions from the parties?
Y'all,
No,
pray
Judge, thank you.
jury, because they are really taking their
I
time.
believe the transcript excludes sidebars and any introductions.
Oh, thank you, Joanne. You are so sweet.
Acceptable to tell them that excludes sidebar conferences and just what they heard directly?
Absolutely.
All right. The three alternates should be on the way over momentarily. As soon as they come in, we'll bring the jury out.
That's right, Pat.
And I would remind counsel, obviously, when the court reporter is reading back, we can't say anything because the reporter is going to be tied up reading back, not taking down any of our statements.
Yeah, they want to hear Dr. Andrews' testimony. Hi, Shelley. Welcome.
Jury out.
Okay, so they want to hear Dr. Andrews' testimony. Yes. Good things come to those who wait, y'all. So we should be thankful that the jury has taken their time and they're actually.
Thank you, everyone. Please be seated. The 12 deliberating jurors and the three alternates are back in the courtroom.
Yes, China's the Sixth Amendment.
Indicate you'd feel you'd like to hear Dr. Andrews' testimony again.
Commandment, Sixth Commandment.
Yes, that is possible. We're going to do that for you.
Not yet, Mars. Welcome. They're asking to see
include
Dr. Andrews'
anything that happens
testimony.
Sidebar, so it would just be basically skipping over that in each case. So, Madam Court Reporter, Ms. Holst is going to read that back for us.
I think so, Kirsten.
Good afternoon, everybody.
He's been by her side every day.
This is the testimony of Dr. Andrew. This is examination by Ms. Lento. Question, good morning, doctor. Can you tell the jurors what type of doctor you are? Answer, I'm a forensic pathologist. Question, doctor, I am now going to show you what has been marked S49 for identification purposes. And do you recognize that? Answer, I do. Question, can you tell the jurors what that is? Answer, this is what appears to be the most recent iteration of my curriculum vitae, my qualifications. Question, and would that aid your testimony today? Answer, sure. Question, now, doctor, can you tell us what your fellow is in? Answer, I did a fellowship in forensic pathology after having completed a residency in anatomical pathology in a different institution. Question, and what about your fellow in pediatrics? Answer, I went to medical school at the University of Cincinnati in Cincinnati, Ohio, and then matched in a pediatrics residency program at Cincinnati Children's Hospital Medical Center. So I am initially trained as and practiced as a pediatrician in Cincinnati prior to changing directions and going back to the University of Cincinnati to do the residency in anatomical pathology, and then a subsequent fellowship in forensic pathology. Question, and how long were you a pediatric doctor for?
Welcome.
Answer, I started my training in 1982, and I left for my anatomical pathology training in 1988. I continued to work as a pediatric moonlighting at Children's Emergency Room and at an urgent care center in Cincinnati during the 3 years I did my anatomic pathology residency. But the last specifically pediatric work I did was in 91. Question, and where did you do your anatomic pathology residency at? Answer, that was at the University of Cincinnati College of Medicine from 88 to 91. Question, and can you tell the jurors about your fellow in forensic pathology? Answer, after I completed my training in
Kirsten, they want to
anatomical
hear the whole
pathology,
testimony.
I applied for a
This could
forensic
take a while.
pathology fellowship, that is a subspecialty training, with the Office of the Chief Medical Examiner in New York City. I interviewed and I got that position, and I did my fellowship there in 91, and then was invited to stay on staff as a city medical examiner for the city of New York. And I did that until early 97, and then was named acting deputy chief for Richmond County, which is one of the 5 boroughs. It's essentially Staten Island.
I don't know about
So I
y'all,
was
but my heart
acting
is just like
deputy
beating
chief
like
for that
crazy.
particular borough until I left New York to assume the role of chief medical examiner for the state of New Hampshire. Question, and how long were you chief medical examiner for the state of New Hampshire? Answer, 20 years. I served from September of 97 and retired from state service in October of 2017. Question, can you tell the jurors what board certifications you hold? Answer, I am boarded by the American Board of Pediatrics in Pediatrics and the American Board of Pathology in Anatomic Pathology and Forensic Pathology. Question, can you tell the jurors about some of your academic appointments?
Yeah, remember,
Answer, well,
all of
when
this
you are
happened in the
chief
beginning.
medical examiner or affiliated with the
So it's
medical
been a hot
examiner's
minute.
office, you get some anatomic academic appointments. And when I was in New York, I had an appointment at SUNY and an appointment at Bellevue. But when I went to New Hampshire, I had an appointment at Dartmouth Medical College and also did teach at the College of Pharmacy and Sciences and a physician assistant program affiliated with Franklin Pierce University. I don't have any of those positions anymore because I retired. The only academic position I currently hold is as an adjunct professor of forensic pathology for the medical school at Boston University. Question, are you currently a member of New Hampshire Child Fatality Review Committee? Answer, I'm currently not a member of that committee. However, I was there 20 years that I served as chief medical examiner.
Yeah,
Question,
think about it.
have
You
ever
don't want the
testified
last
as
thing
an
they
expert
ever
witness
heard was
in court
Dr.
before?
Bodden.
Answer, yes. Question, about how many times have you testified? Answer, it is in the low 3 figures. Question, and what type of cases have you testified in? Answer, well, in that my testimony has been exclusively in the area of forensic pathology. They have basically been involving issues regarding the interpretation of patterns and mechanisms of injury and cause and manner of death. These could be anything from natural deaths or accidental deaths, suicidal deaths, or homicidal deaths. Question, have you ever been published in the area of pathology or pediatrics? Answer, yes. Question, can you just give the jury some examples of those?
Because
Answer,
the video
well, most
probably
of
has
my
some
pediatric
sidebar
publications are in the area of child abuse
stuff
and
like
neglect
that.
and sudden unexpected infant death and the investigation of sudden unexpected death in infancy and childhood. I have other publications that are not necessarily germane to this proceeding, but other publications in various aspects of forensic pathology, gunshot wounds, drug deaths, that sort of thing. Question, and have you ever engaged in speaking engagements relating to those topics? Answer, yes. Question, and how about how many autopsies would you say have you performed during the course of your career? Answer, in the neighborhood of 6,000 or so. Question, and about how many pediatric autopsies have you performed during the course of your career? Answer, I don't log those separately, but they're probably in the range of 500 or so. Question, doctor, were you contacted by the Ocean County Prosecutor's Office in regard to the decedent Corey Michelot? Answer, yes. Question, and can you tell the jurors why you were contacted? Answer, I received initial contact from the Ocean County Prosecutor's Office in September of 2021. They asked me to review material related to the death of Corey Michelot with an eye toward rendering opinion. Are there reports in regard to your findings and opinions regarding this matter? Answer, I did. Question, if I may approach, doctor, I'm now showing you what has been marked as S50, S51, and S52. Do you recognize those? Answer, I do. Question, can you tell the jurors what those are? Answer, S51. Question, are those your reports in this matter? Answer, yes. Question, and would those reports aid in your testimony today?
Okay,
Answer,
right.
yes.
Back
Question,
Dr.
now,
Andrew's
did you perform the
testimony.
autopsy of Corey?
Jury wants to hear it.
No. Question, can you tell the
For
jurors
those of you
who
who
performed the
are
autopsy? Answer,
coming in or don't know.
Dr. Dante Ragassa. I believe Danta is his first name. Dante Ragassa of the Ocean County Medical Examiner's Office performed the autopsy examination on Corey. Question, and when was the autopsy performed?
Yeah,
Answer,
poor Dr.
autopsy was
Bodden.
performed in April of 2021. Let me see what the specific date was. on the 3rd of April, 2021. Question, and did you review the autopsy report authored by Dr. Ragasa? Answer, I did. Question, and what other materials did you review to formulate the basis for your opinion? Answer, in addition to the autopsy report, I saw the images that were generated in association with the autopsy, and I examined the histological slides, and we will talk about those momentarily.
He's
The
guilty,
slides
right,
that you look
Shelley?
at under the microscope. So I looked at that. And then I had medical records from 3 different hospital facilities, I believe Ocean County Medical Center, the Jersey Shore Medical Center, and South Ocean. I saw medical records from IV Pediatrics, which were Corey's pediatric care provider. Certainly I saw police documentation, law enforcement documentation. I saw some telephone records. I had access to the video of Corey on a treadmill. And subsequent to issuing my first report, I received additional materials. I did receive an expert report from an infectious disease specialist, Dr. Feingold, and a report from a defense pathologist expert, Dr. Bodden. Question, did you also review video from April 2nd, 2021 from the decedent's mother's phone occurring around 9:00 a.m.? Answer, indeed I did, yes. Question, and did you also review autopsy photos? Answer, yes. Question, do you have an opinion after you reviewed all of this material in regard to the decedent's cause of death? Answer, yes. Question, can you tell the jurors what that opinion is? Answer, I'm simply going to quote from my report because it is a mouthful, and we will break it down. The Corey died of blunt impact injuries of the chest and abdomen with laceration of the heart, left pulmonary contusion, and laceration and contusion of the liver. Question, and can you explain to the jurors when you say cause of death, what does that mean? Answer, cause of death is, it sounds simple enough, but it is something that's very specific. Cause of death is a disease or injury or a combination of those things that initiates what is ultimately a lethal train of events, and without which death would not have occurred. So there are many, many, many causes of death. Question, what about blunt force trauma? Can you explain to the jurors what that means? Answer, in forensic pathology, there are various kinds of external forces that can act on the body. There could be penetrating trauma, such as that from gunshot wounds or stab wounds, or there can be blunt impact injury. And in that situation, you have force applied to the body over a much broader area than, a single bullet or blade would cause. That blunt injury could be a small area or a large area, but it produces a different kind of injury than penetrating trauma does. And the kind of injuries
Welcome, Shelley, if I haven't welcomed you yet.
Impact could include contusions or bruising of the skin or internal organs, lacerations, tears of tissue because the result of the blunt force applied to it, or fracture of bone. Question, and what affects blunt force trauma and the impact on the body? Answer, well, impact can be anything from minor to life-threatening. If you get up in the middle of the night in a strange hotel room and hit your shin against a nightstand, that may cause a contusion, raise a contusion. But all that is bleeding under the surface of the skin, and that resolves over time, and that will be fine. If you were to fall against that nightstand, you might sustain a laceration of your scalp. That may require stitches, but likewise, you would recover from that. If you sustain any of these kind of blunt impact injuries with sufficient severity, it could conceivably bring about your death if they were severe enough. Question, after reviewing the materials in this case, did you formulate an opinion as to the decedent's manner of death? Answer, I did. Question, and can you tell the jurors what your opinion is? Answer, Corey's manner of death is homicide. While there are many, many, many causes of death, typically in forensic pathology, there are only 5 manners of death. And manner of death is simply a one-word description to describe how a death came about. And those 5 are natural, accident, suicide, homicide, or in rare instances, undetermined. In Corey's case, in that these injuries could not have been inflicted by himself with any kind of intent, it is certainly not suicide. These injuries, given their pattern and distribution, are consistent with having been inflicted by another person. Therefore, any death that is related to the action of another person is, from a medical examiner's standpoint, from an epidemiological or public health standpoint, homicide. Now, that doesn't have any legal significance, but that is the way that a medical examiner certifies it. So Corey's death was at the hands of another person, so therefore, it is a homicide. Question, does the case histology impact the determination of manner of death? Answer, well, it can in certain instances. If you have a gunshot wound to the head with a perforation of the skull and the brain, histology or examining tissue under the microscope doesn't add a whole lot. But in a case like this, Certainly, the examination of tissues under the microscope was helpful in reaching my conclusions. Question, did you make any findings regarding Corey's medical records from Southern Ocean Medical Center on April 2, 2021? Answer, and I'm going to ask you to clarify that a little bit because I'm not entirely certain what the question is. Question, did you review the medical records from Southern Ocean Medical Center on April 2, 2021? Answer, yes, I reviewed those records from April 2nd. Question, and can you tell the jurors if that helped to formulate your opinion as to cause and manner of death? Answer, it did, yes. Question, and can you explain why? Answer, well, Corey presented to Southern Ocean at around 3 o'clock. At that point, he was already in serious medical condition. He was ashen, gray, in a shock-like state, and was fairly medically unstable. There was an attempt to make an assessment as to what might have been going on with him by doing a CT scan, and he got worse in the CT scanner to the point where he underwent cardiac arrest. Question, and doctor, did you review any blood work in that hospital? Answer, question, and did that impact your conclusions? Answer, yes. Question, what about any post-mortem CT scans? Answer, he had a post-mortem CT scan. I don't find those of particular value, certainly compared to an autopsy, as to determining cause or manner of death. But I did see there was a post-mortem CT scan, and I looked at its result. Question, did you review the medical records from Jersey Shore Medical Center the evening of April 1st of 2021? Answer, I did. Question, and can you tell the jurors about that? Answer, well, that particular visit was at the end of a sequence of events wherein Corey initially was seen by his pediatrician, and there was some concerns about these bruises that Corey had as to whether or not this represented some mistreatment or child abuse. So Corey was referred to the emergency room, and I believe Corey and his mom went to one, but then they went to Jersey Shore after that. At that examination, he had a physical done, and they documented the various bruises that he had on different parts of his body, none of which were life-threatening. His clinical status at the time was perfectly stable. He was normal. He was conversational. He spoke with the doctor, gave a history, made some disclosures. They also did some blood work and an x-ray of his chest, and all of that was completely normal. Question, do you review the findings from Dr. Agassa's autopsy performed on April 3rd of 2021? Answer, I did. Question, can you tell the jurors what Dr. Agassa's findings were? Answer, so Dr. Agassa received, well, the body was taken to the medical examiner's office, I believe, the night before. But Dr. Agassa performed his examination on the 3rd and documented all the bruises or contusions that were on various aspects of Corey's body. Those were the primary external findings that he had, but an autopsy is a very detailed surgical examination of not only the external aspect of the body, but the internal aspect as well. There is a large, Y-shaped incision made from the shoulders to the middle of the chest, down the center of the body, allowing the pathologist to take a systemic examination of each of the organ systems. It was during that internal examination that Dr. Agassa saw and documented several abnormalities. There was a large contusion in one of Corey's lungs. I believe it was the left lung. The examination of Corey's heart externally didn't show anything, but the internal examination of the heart, after the heart was opened to reveal the chambers of the heart, a laceration or tear in the tissue was revealed near the apex or the tip of the heart on the inside wall of the heart. Below the diaphragm is that flat muscle that divides your chest organs from your abdominal organs. Below the diaphragm on the right side where the liver lives, there were 2 injuries that he documented. There was a laceration or tear in the liver tissue on the right edge, the right lateral aspect of the liver. And there was also a contusion or bleeding underneath the capsule of the liver on the front edge of the liver. There was a small amount of free blood in the floor of the pelvis, undoubtedly associated with the liver laceration. Question, now doctor, did you review slides which were prepared in conjunction with the autopsy? Answer, yes, I did. And can you tell the jurors what the slides are? Answer, this was what I was referring to when I used the term histological. These are not slides like old 35mm photographic slides. This is something different. During the internal part of the examination in an autopsy, small tissue samples of areas that look normal or abnormal can be taken, and then they are processed by a laboratory such that they are cut in very, very thin slices and floated onto a glass slide. That tissue is then stained with specific kinds of stains that allow the pathologist to then see the cells under the microscope. So I did see the entire set of histological slides that Dr. Agassa had prepared in conjunction with his autopsy. Question, did you also review autopsy images? Answer, yes. Question, and can you tell the jurors specifically what image 151 depicted? Answer, image 151 was of a pulmonary contusion, meaning a blunt injury of the lung associated with bleeding. Now, there was a picture of it. It is, obviously you could see it. It's obvious that you could see it. It does not appear in his narrative description, but is depicted in the photographs. Question, and can you tell the jury about image 153? Answer, well, I have to refer to my report on that. Question, yes, doctor, if you could. Answer, 153 was a picture of the free blood that was in the pelvis. Question, can you tell the jurors about images 163 through 170, please? Answer, those were various views from different angles of the liver injuries. Question, what about images 172 through 178? Answer, those depicted injuries in different parts of the body. 172 to 75 were hemorrhage in the retroperitoneal tissue. Sorry about the jargon, but I mean, that's where it was. What is that? The abdomen is lined by a lining called the peritoneum. Retroperitoneum means bleeding underneath the peritoneum. This was towards the back of, where the backbone is. 76 to 78 was similarly hemorrhage, contusion, and it was in the area of his left shin, ninth rib. The area of his left ninth rib. That may well be what was associated, that trauma on that side may well be what was associated with the contusion of the lung itself on that side. And then, so yes, that takes us to 178. Question, okay, doctor, and did you review images 196 through 200? Answer, yes. Question, and can you tell us about those? Answer, these images were, I should preface this, I explained when I was talking about when an autopsy is approached in general, I do that incision in the front. In cases where it is important to do, the death of somebody in police custody, for example, or in this case, a potential child abuse case, you do a similar examination of the back. So you turn the body over and an incision is made along the midline of the back, and that skin is reflected so that you can see the muscles of the back. These images, 196 to 200, depicted soft tissue hemorrhage or contusions along the spine or the backbone that you could not see necessarily on the surface of the skin. There were certainly contusions on Corey's back, but there were also contusions that did not correlate with deep contusions that didn't correlate with contusions that were on the skin. Question, can you tell the jurors about the myocardial laceration depicted in image 0205? Answer, yes, and this is complicated. So you all remember from high school biology, right? The heart has these 4 chambers, the 2 upper chambers and the 2 lower chambers. And looking at Corey's heart from the outside, all that could be seen was an epicardial contusion on the front of the heart. The epicardium is just the lining of the outside of the heart. So we had a visible contusion on the outside of the heart, but it wasn't until the heart was opened in such a way that you could see the inside, each of the chambers, that this laceration was revealed. On the left ventricle, which is the lower left chamber of the heart, that is the muscle 1. That is the one that pumps the blood out to the rest of the body. And there were tear in the tissue. Dr. Ragasa described it as about 1.5 inches, and that comports with the photograph, a horizontally oriented tear near the tip of the apex of the heart into the muscle. It didn't go all the way through the heart wall. It was just a tear of the heart muscle in the internal surface of the left ventricle. Question, doctor, did you review images 206 to 220? Answer, I did. Question, and can you tell the jurors about that? Answer, this was a series of images of scalp contusions. Corey didn't have a lot to see externally on the scalp. There was maybe one abrasion or contusion near the eyebrow, but when one looked at the skin or underneath the skin, there was a contusion on the top of his head and a couple of contusions on the backside of his scalp that you couldn't see on the surface. Question, doctor, did you make any findings regarding bruising on the decedent's body, which was significant in regard to your formulation of your opinion? Answer, well, in assessing the potential for child abuse, it is not so much that contusions are life-threatening in and of themselves, but it is the pattern and distribution of injuries and also the presence of injuries of varying ages that suggest a child has been mistreated. And Corey had contusions over a wide area of his body of varying ages from under his chin, his head, his trunk, his extremities. There was one fairly large one just on the left side of his chest that looked to be very large, and that had been previously assessed. And particularly the presence of contusions on the back without a pretty clear-cut explanation is not diagnostic of abuse, but it's very suggestive of abuse, certainly given the company that it's keeping. So my concern was not so much with the severity of the bruising, but the pattern and distribution of bruising as being suggestive of child abuse. Question, doctor, did you make any findings regarding the decedent's liver? Answer, yes. Question, and can you tell the jury? Answer, well, as I said, there were 2 injuries. Question, Answer, one of them fairly minor. It was on the front edge of the liver, and it was just a contusion. That is not particularly uncommon after CPR, but there was a second, more significant injury, and that was out on the right side, the right lateral edge of the liver. It was described as a superficial contusion, but the photos clearly show that it was a contusion that goes fairly deeply into the liver tissue itself. And under the microscope, this was not a super fresh injury, so this was not an injury that could be attributed to CPR. So those are the 2 findings involving the liver. Question, doctor, were you able to formulate an opinion as to the time frames when these blunt force trauma injuries were inflicted? Answer, only in a general sense, giving a range of time. To dispense with the contusions first, many of them were sampled under the microscope, and many of them were pretty much all healed or mostly healed. You could see something on the surface of the skin, but not much going on underneath it. So other than to say on my gross inspection of these bruises, they appeared to be of varying age, that is as far as my opinion would go in regarding bruising. The internal injuries, on the other hand, have a little more objective evidence to offer in terms of timing. And the basis for that is something called the inflammatory process. So what does that mean? When tissue is injured, there's a fairly predictable sequence of events that occurs in the body's attempt to repair itself. That is what inflammation is, or one type of inflammation. So that inflammatory process involves the appearance of certain kinds of repair cells to the area of injury within a fairly predictable time frame. So I examined both and I did not generate new slides. These were slides that were done at the time of the original autopsy. So slides of injury and slides of the heart injury and slides of the liver injury. And in both of these injuries, there was a fairly well-established
because they're talking about her child.
The cells that make up the acute response are called, I've got to say it because they have a name, they're called polymorphonuclear leukocytes. Wow. Let's just call them polys. So polys are recruited to the scene within hours after an injury like this. The second wave of inflammatory cells are called mononuclear cells. Those are pretty rare. I only saw those here and there. After that, and those, take up to like 24 hours to get there. And then after 24 hours, you actually start to see some attempt to heal the tissues. Fibrins lay down, and you see other cells called fibroblasts. Those weren't present. All I was seeing was this acute inflammatory process that was fairly well established, and that was in both the heart and the liver. So what's that mean? Well, that means that, in my opinion, these injuries occurred at roughly the same time, and their age could have been as recent as 4 hours, but as old as 12 hours prior to when Corey actually died at 5:00 p.m. on the 2nd. That was the finding based on the histology. Additional evidence that I saw fine-tuned that time frame a little tighter. Question, and doctor, can you tell us about the additional evidence that you saw to fine-tune that time frame? Answer, so
Which one's the brother?
Time frame
the guy behind
12 hours. That would have been from 5:00 a.m. the day before to 1:00 in the afternoon on the 2nd. There was a video that was alluded to, and it wasn't an intentional video. There were no people in the video. You could basically see that the phone was on a car seat or something, and there was some colloquy in there. A question. Doctor, can you explain to the jury if there was an opinion or a determination or findings that you made after review of the materials regarding blunt force trauma and the CPR post-mortem? Answer, yes. I was specifically asked questions about that because I believe these were questions that were raised in the original autopsy report. In my opinion, given the age of these injuries, it is entirely incompatible with them having been produced by CPR because they wouldn't have had this inflammatory response that takes hours to develop. Furthermore, I don't know anybody who does CPR on the right side of the chest. CPR is done on the front of the chest. And like I said, the anterior liver injuries are not commonly seen with CPR, but not an injury out on the side of the liver that goes deep into the tissue. And thirdly, I've seen a lot of CPR injuries, more in adults than kids. Adults they have a lot of CPR injuries because our ribs fracture much more easily. I've seen a fair number of CPR-related injuries in pediatrics. I've never seen an endocardial or an internal laceration of the heart like this one. So in my mind, I'm quite confident that these injuries are not CPR related. Question. So doctor, were you able to determine that the injuries occurred while Corey was still alive because of the inflammation? Answer. Oh, exactly. Yes. Question. Did you make any findings regarding sepsis or infection? Answer. Once again, that issue came up on initial examination. And based not only on the autopsy findings, but my review of the medical records, there is zero, not one scintilla of evidence of sepsis or any other infectious process in Corey's autopsy. Question, doctor, did you note any findings regarding stress cardiomyopathy regarding the decedent's heart? Answer, I did. Question, and can you tell the jurors what stress cardiomyopathy is? Answer, cardiomyopathy. So cardio refers to the heart, myo is muscle, and pathy is pathology. So this is some sort of abnormality of heart muscle. As the name suggests, stress cardiomyopathy is an abnormality of the heart muscle that's produced by chronic ongoing stress. It is not visible to the naked eye. It is seen under the microscope. There are well-described changes of individual heart muscle, changes in the color, changes in the way that the innards of each cell looks under the microscope, changes in the way that the nucleus, the nerve center of each cell looks. These findings were pretty widespread in areas of Corey's heart. Some of the findings that are associated with what has been called stress cardiomyopathy, which is in the literature, are associated with CPR because the heart is dying at that point. And some of these findings can be seen also in CPR, but the constellation of all of these findings and the distribution of them throughout the heart says to me that this is not related to CPR, but it is related to chronic ongoing stress. So while Corey's immediate cause of death was the blunt impact injuries that he sustained the day he died, the presence of stress cardiomyopathy suggests that there was ongoing physiological stress, most likely due to the ongoing mistreatment or abuse. Let's see. And there was a recess at this point. Okay. Back with Ms. Leto questioning. Question, so if we may turn to what's marked as S97, please, already in evidence. Doctor, we now have up on the screen S97. Can you please tell the jurors what that is? Answer, that is a very small contusion. It looks like an abraded contusion, sort of a combination injury on Corey's forehead. Question, and is S97 a picture? Is S97 a photograph? Answer, yes, it is a digital image that was generated in conjunction with the autopsy. Question, okay, and can you just explain again what is depicted in S97 in the photograph? Answer, okay, Your Honor, may I stand? And then comes down to with the pointer.
I think so, because they're going back in time.
Okay. So it looks like we are looking at the left side of Corey's head. You can see his hairline is here. This is just the outer edge of his eyebrow on the left side there. And that is Dr. Regas's thumb.
There's been so many breaks, they're asking for information they haven't heard in a while.
That measures, no more than a half an inch, maybe 3/8 to a half an inch. Question, can we go to the next picture, please? And can you tell the jurors what S98, that photograph, depicts? Answer, a contusion behind the ear it really requires some sort of an explanation. That's an injury that at least raises, it's not a diagnostic, but it raises the question of mistreatment of a child. Question, and why would that raise that? Answer, well, because it is a protected area. It's not normally injured in a slip and fall. Now, if you fall against something, that it could conceivably, press your ear hard enough against that bony part, a mastoid process there. But most of the time, at least in my experience, it is generally associated with other injuries that suggest mistreatment. Question, can we go to the next picture? Can you tell the jurors what is depicted in S99, the photograph? Answer, just to orient you as to where we are anatomically, this is Corey's left shoulder, all right? The left side of his neck, left ear. So there is this linear contusion. It's a brownish, yellowish contusion up under his chin. You can also see this is pretty regular. I suspect this was some sort of EKG monitor pad. So that is not an injury. See how regular that is? It has a hole in it. So this main thing here is the contusion under his chin. Question, and what is significant about that? Answer, well, the significance of a contusion under the chin in and of itself is very little. But in the context of examining a child who has multiple injuries at varying ages in different parts of the body, particularly from under the chin and around the neck area, once again raises the question, of whether or not that child has been mistreated. Question, can we please go to the next photograph? Doctor, I'm calling your attention to what has been marked into evidence as S101. Can you please explain what has been depicted in that photograph to the jury? Answer, in S101, Corey has been rolled up onto his right shoulder. This is Corey's left ear. So that is his head, right shoulder, left shoulder. What is being emphasized in this image are two contusions. Now, in and of themselves, it's a little distal of a contusion, you know, a dangerous thing? No. But a contusion over the shoulder blade and sort of directly over the spine in a child without some sort of history of how that came about is not an area that you typically see injured in the run and play and slip and fall of a child. It is the context, it is the pattern and distribution that makes it an important one. Question, can we move to the next photograph, please? This is S100. Can you tell the jury what that depicts? Answer, so Corey is laying once again on his side, and we are looking at his hip area. So the buttocks would be down here, the back would be up here. And we are looking at a fairly broad abrasion. And we've talked a lot about contusions, but abrasions are a different kind of a blunt impact injury. If force is applied sort of tangentially or, you know, sweeping across the skin, it can raise the superficial layers of the skin up, raspberry, right? And that is the kind of injury that we are seeing here. This is an abrasion, a rather large confluent abrasion over his hip. Again, the context is what makes it important. That is not a lethal injury. It's not a life-threatening injury. But in the context of everything else that we are seeing, it is a significant injury. Question, can we please move to the next photograph? S60, doctor, can you tell us what that depicts? Answer, this depicts a contusion or a bruise that captured a lot of people's attention. So this is Corey's right shoulder, armpit area. There is the right nipple. There is the left. Just above it, there is this vaguely patterned contusion that is partially healed. It is fairly large, and it is in a very odd place. Unless there's a good explanation for it, it was evaluated by several care providers. Question, can we move to the next photograph, please? Now we have S59, a photograph. Can you tell the jurors what that is a photograph of? Answer, this is an internal photograph from the autopsy, the internal aspect of the autopsy. And it is a picture of the liver. And it is specific, the outer right side, that lateral edge of the liver. So on the surface of the liver, what you see is this. There is this little bit of bleeding, and then you can see the tissue that was torn. But Dr. Ragasa made an incision right in the middle of this injury to see what was underneath it. And you can see that all of this is abnormal. It should be uniformly this color. What you are seeing here is a fracturing or disruption or laceration of the liver tissue that comes when the liver tissue is compressed in some way. And as I said, CPR is performed in the front. It is not performed out here on the side. Question, doctor, is that a significant injury? Answer, it's not a life-threatening injury. As ugly as it is not a life-threatening injury. Had Corey presented with this and nothing else, they would have probably seen it on the CT scanner and maybe put him in the hospital and observed him to make sure that he did not have ongoing blood loss, and then discharged him to let him, with some physical restrictions, to let it heal on its own. So it's nasty, but it's not life-threatening. Question, can we move on to the next photo? Doctor, can you tell us what is depicted in S58, please? Answer, this is likewise another internal photograph from the autopsy. In this instance, you are looking at the heart. That doesn't look like any kind of a heart that you have ever seen before because it's been opened. So the heart has been opened to reveal the inner side or the inner surface of the left ventricle, the left lower chamber. What is seen here is an actual tear in the tissue. This wall should be continuous, and there is a tear on the internal surface of the heart near the septum. The septum is that muscular wall that divides the left and the right side. So it's got a partial thickness tear of the heart on the left, the inside left ventricle. Question. Now, doctor, can you tell the jurors about the severity of the tear and the relation to thickness? Answer, this is a severe injury. This is an injury that triggered Corey's death. Why?
Thank you, Kristen.
Well, he didn't bleed to death. This laceration didn't go all the way through the heart muscle. It is not a hole in the heart. It is not a tear that goes through the heart. In that case, there would have been an enormous amount of blood loss very quickly, and he would have never survived as long as he did. In this instance, in that it was a partial thickness, his heart could at least for some hours compensate for this injury. But I had mentioned the septum. The septum is where these specialized heart cells that control the rhythm of the heart live. So you've got these natural pacemakers on the upper part of the heart, and then they divide into specialized fibers that go down the septum. Disruption of this can trigger rhythm disturbances, arrhythmias of the heart. That's likely what happened to Corey in the CT scanner, why he went into cardiac arrest. With CPR, they weren't able to restore some sort of normal rhythm, but they were able to restore some sort of normal rhythm, but couldn't maintain it. He kept going into, I believe it was a rhythm called
Yeah, I figured you couldn't hear anymore.
And they ultimately could
That's a
not
long
resuscitate
testimony.
from that. So that is how that injury mediates his death. It's not,
Poor
trauma,
Brianna.
bleeding, exsanguination. This is trauma. The heart tries to compensate. The heart eventually decompensates, and he sustains a cardiac arrest due to his trauma. Question, now doctor, are you able to review the inflammation which you spoke about before in that photograph? Answer, no. The inflammatory process is something that you see under the microscope. So Dr. Ragasa took samples, well, from the other areas of heart as well, but from and in around this tear, and that is why I saw the inflammation that allowed me to draw an opinion or come to an opinion as to the age of that injury. Question, okay, can we go to the next photo, please? Doctor, I'm now showing you, or it is up in the courtroom, what has been marked into evidence, S-152B. Can you tell the jurors what that is? Answer, I received this image subsequent to my initial report, but I received it in conjunction with this question about timing. We already talked about the video at 9 o'clock. It has been represented to me, and I believe there has been some sort of analysis of the photo that indicates it was taken, on or about 2 o'clock in the afternoon. To me, I don't know, Corey could be sleeping, but it's certainly not inconsistent at all with him already having sustained what were ultimately his fatal injuries. And he presents an hour later to the emergency room looking not much
Yeah, I
different
don't think
from
she was in the
save
courtroom
for
for
the
this
fact that
testimony,
his
so
vital signs were unstable and
it's
his
very
color
hard
was
for her to have
ashen.
to listen to.
Question, so doctor, would that photograph be consistent with your opinion regarding the timing of the blunt force trauma injury? Answer, yes. Question, can we move to the next photo, please?
Yeah.
Oh, I think we are done. Okay. You could go back to the witness stand. Now, doctor, in conclusion, based upon everything that you have reviewed, what is your medical opinion regarding the cause and manner of death of Corey? Answer, Corey Michelot died of blunt impact injury of the chest with laceration of the heart, contusion of the left lung, and laceration and contusion of the liver. It is a traumatic cause. The manner of death is homicide. It was at the hands of another person. He didn't do it himself, and it didn't happen accidentally. And now we're going to do the cross-examination by Mr. Gallucci. Question, how are you, doctor? Answer, good to see you. Question, good to see you too. Have you ever been to Hanover? Have you been to Hanover lately? Answer, I haven't been to Hanover fairly recently. Question, all right, let's get to it. Answer, yes, sir. Question, did you review all the police reports in this case? Answer, I believe I reviewed police records. I cannot say for certain that I saw every single police report. Question, do you recall? Answer, I saw some. Question, I'm sorry, I didn't mean to interrupt you. Answer, I saw some. Question, did you review Detective Mitchell's 29-page synopsis of the case? Answer, I did. Question, okay. Did you review the records from Dr. Harry Larkin? Answer, that name is not familiar to me. Question, okay. Did you review the records from Southern Ocean Medical Center? Answer, yes, sir. Question, did you see any records in there from Dr. Larkin? Answer, I don't. That name, I don't look for names, so I can't recognize the specific name. Question, did you review Dr. Ragasa's medical examiner report? Answer, I did. Question, did you review his findings? Answer, I did. Question, did you review the Community Medical Center report? Answer, yes, sir. Question, and did you review Jersey Shore Medical's medical report? Answer, I did. Question, did you review Southern Ocean Medical Center's report? Answer, yes. Question, did you review the grand jury minutes in the case? Answer, grand jury minutes? I'm going to refer to my report. Answer, yes. Answer, I don't see it listed on my initial report or any of my supplemental reports. Question, okay, so you were hired by the Ocean County Prosecutor's Office sometime in September of 2021, right? Answer, correct. Question, okay, and do you recall if that was prior to the medical examiner issuing his report? Answer, no, I believe it was after. Question, okay, so are you still an ME in New Hampshire? Answer, I retired from state service in 2017. I maintain a consulting practice, and that is the role that I am playing here today. Question, prior to reviewing the file and agreeing to become an expert, or maybe after you agreed to become an expert, did you have an opportunity to speak to Ms. Lento? Answer, yes. Question, did you have an opportunity to speak to Ms. Schroen? Answer, we communicated primarily via email. My primary discussions were either with Detective Mitchell or Attorney Lento. Question, so did you speak with Detective Mitchell also? Answer, I did. Question, okay. And what was the first time you spoke with Ms. Lento? Answer, I don't recall specifically. I received the initial material for review, and we very likely had a conversation via telephone sometime between my receiving the material in late September and the issuance of my first report in February. So we undoubtedly talked one or more times in that interim. Question, and did you also, you said you spoke to Detective Mitchell, right? Answer, yes. Question, okay. Do you remember when you spoke to Detective Mitchell? Answer, no. Those were primarily conversations regarding transmittal of documents, timing, and scheduling of conferences with Attorney Lento. Question, so when you spoke with Detective Mitchell, and you've already testified that you read this 29-page report, did you notice anything in there about one of the medical examiners from Ocean County, from Dr. Harry Larkin? Answer, this is starting to ring some bells. Question, okay. Answer, I believe Dr. Harry Larkin might have been the initial responder in the Ocean County Medical Examiner's office, and please correct me if I'm wrong. Question, I will. Answer, no doubt. I believe he is the one who ordered the postmortem CT scan on the body of Corey Michelot. Question now and he's a medical examiner from Ocean County, right? If you know. Answer, that is his title. I don't know what his credentials are, but that is his title. Question, and you are a medical examiner, right? Answer, yes, sir. Question, and a medical examiner is the one that actually physically does the work that you just testified about? Answer, as far as autopsy goes, yes. Question, right. So when you were a medical examiner, you were the one that did the slides, right? Answer, I obtained the specimens. The laboratory generated the slides. Question, and you are the one that would open up the body? Answer, yes, sir. Question, and you are the one that would remove the organs? Answer, yes. Question, you are the one that, as we saw, the liver was opened up, right? You are the one that would do that? Answer, yes, sir. Question, and would you also take those pictures, or somebody else would take the pictures? Answer, depends on the agency. In New Hampshire, I take my own pictures. Question, so Dr. Larkin ordered a CAT scan after Corey had passed, right? Answer, yes, sir, yes, sir. Question, now, that is very unusual, right, for a medical examiner to order a CAT scan after someone has passed? Answer, again, that depends on the jurisdiction. Some offices, they are really, like Baltimore, they are very well endowed. They have a CT scanner in their office. So for them, it is not unusual. I don't know what the standard is in Ocean County. I certainly don't routinely or did not routinely do it in New Hampshire. So in New Hampshire, unusual. Baltimore, another day at the office, and everything in between. Question, so it was unusual then for Dr. Larkin to order a CAT scan in New Jersey? Answer, I don't know what the standard is here. I don't know how often it is done. Question, but he also ordered blood work at that time, right? Answer, that I don't recall. I recall the CT scan, and he certainly would have had access to the blood work that was already done in conjunction with the resuscitation effort. But I am not aware of any additional lab work he ordered. Question, are you aware of the blood work that was taken from the decedent after he had passed? Answer, the only thing I'm aware of that was taken post-mortem was the toxicology specimens that were taken in conjunction with the autopsy by Dr. Ragassa. Question, how about the blood work taken before he was deceased? Answer, that would have been blood work taken by the Southern Ocean. Is it Southern Ocean? Question, is Southern Ocean Medical Center. Answer, during the resuscitation effort. Question, and are you aware that in that blood work there was a high white blood count, high glucose level, and high lactic acid? Answer, yes. Question, that Dr. Larkin found that was indicative of sepsis and infection. Then we had a sidebar. Question, hi, Doc. Question, do you recall what Dr. Larkin's position was with the Ocean County Medical Examiner? Answer, I just knew that he had the title of medical examiner. I don't know his credentials or nor would know what his specific role was.
This is why she had to leave the room. They basically,
come up with your
especially the defense attorney,
Answer,
has
yes. Question, one of the
demeaned
reports you
Corey
just
from a
testified that you
child
reviewed
to
was
body
Detective
parts.
Mitchell's investigation report? Answer, yes. Question, did you rely somewhat on the report to make some of the conclusions you have here? Answer, in terms of timelines and that sort of thing, yes. Question, okay, so did you never went to Southern Ocean Medical Center, right? Answer, correct. Question, you never saw Corey, right? Answer, not physically, no. Question, you never ordered any of your own tests, right? Answer, no. Question, you never ordered any of your own CAT scans, right? Answer, no. Question, you just reviewed results of other people? Answer, yes. Question, and you relied on whatever they did to make your decision? Answer, that's fair. Question, and so you did read the report for Southern Ocean Medical Center's CAT scan. Do you know what the result of that was? Answer, yes. Question, okay. And the result of that was that there was an indication for extensive airspace disease in his upper lungs consistent with lung disease. You did read that, right? Answer, I read that, yes. Question, okay. And you also read the x-rays. Did you see the x-ray reports from Southern Ocean Medical Center? Answer, I remember the x-rays from Jersey, but I can't remember the specific wording of the x-ray reports from Southern Ocean. Question, okay, so let's use Jersey Shore then. At Jersey Shore, you are aware that they yielded negative results for any injury? Answer, yes. Question, okay, and did you review or go through any of Dr. Dante Regassa's reports? Answer, yes. Question, okay, so Dr. Regassa is actually the medical examiner in Ocean County, or one of them, I guess. Answer, one of them, certainly. He is the one who did the autopsy, the original autopsy on Corey. Question, so he's the one that did everything. He is the one that took Corey. He is the one that did the whole entire autopsy? Answer, yes. Question, okay. Now, he reported on a number of injuries, just like you discussed, and he said that they were due to life-saving techniques. Answer, yes. Question, okay. And are you disagreeing with that? Answer, yes. Question, now, you are also disagreeing with the results of the CAT scan showing disease, lung disease? Answer, I am not disagreeing with what the CAT scan shows. CAT scan shows what the CAT scan shows. My disagreement is in the interpretation of that CAT scan. This is a post-mortem CAT scan read by a clinical radiologist. Post-mortem CT scanning is occasionally used, but it takes special training to interpret the results of those post-mortem CTs because they don't look the same in dead people as they do in living people. For example, the appearance of lung disease is simply a manifestation of blood no longer flowing through the lungs. Whatever blood is in there is there. It's not moving. So if the blood is contrasted with air, so it looks like airspace disease. Furthermore, Corey had a well-demonstrated confluent contusion of his, I believe it was the left lower lobe. Now, the CT scan describes the upper lobe stuff, but a contusion on a CT scan, these are lights and shadows. This isn't having it in your hand. A contusion on a CT scan would look like pneumonia. So my disagreement is not in what it shows. My disagreement is in what it means. Question, so do you disagree with Dr. Regassa? Answer, in regard to question, life-saving. Answer, yes, sir. These are not CPR injuries. Question, so now that is a contrarian view. You would agree with me, you are contrary to what the medical examiner here in Ocean County said? Answer, no, I don't think it's a contrarian view. It is a second opinion. And as a matter of fact, it was reviewed not only by Dr. Regassa's supervisor, Dr. Falzone, the chief medical examiner for the state, but taken before a child fatality review committee. Dr. Regassa subsequently changed his report to reflect that this was a homicide. Question, and wasn't that after your report? Answer, yes. Question, okay. So the Ocean County medical examiner changed their report after you gave them your report? Answer, that's my understanding. Yes, sir. Question, so do you recall a case that I believe you were the medical examiner on called Patrick McCarthy? Answer, yes. Question, Patrick McCarthy, I believe, was a 10-year-old child? Answer, yes, he was. Question, in that case, you were, in fact, the medical examiner? Answer, yes. Question, so were you the actual one that did all the physical work? Answer, yes, sir. Question, okay, and in that case, you said as the medical examiner, it was not a murder? Answer, I did. Question, okay, 6 experts, including Dr. Bodden and the FBI, said it was a murder? Answer, no, I don't believe that's true. There were experts that said it was homicide. Likewise, there were a number of experts who agreed with me. And it was my understanding that the FBI, say for one agent who was very, very, let's say, emotionally connected to the case, was insistent that it was a homicide. New Hampshire Fish and Game, New Hampshire Crime Scene Unit, New Hampshire Department of Justice, and the prosecutor, the federal prosecutor in New Hampshire, all agreed that indeed Patrick had died of hypothermia. Now, there is disagreement. I never changed my determination based on what the others said because I did not find it credible. Nevertheless, the family has indeed for, I think it might be 20 years now, has established a website that portrays me as Satan incarnate because I am, quote, covering up a homicide. So yes, I don't think I will ever forget that case. Question now, you kept using a word on direct exam where you would say not of diagnostic value. What does that mean? Answer, I think I was using that phrase in the context of some of these contusions, like taken individually, one contusion is not diagnostic of child abuse. Multiple contusions varying stages of healing distributed over a suspicious area on the body is far more suggestive of inflicted injury than an individual bruise, which is not diagnostic. Question, so are you saying that if Corey was struck on the right hip by a blunt force that it would cause the laceration you see in the heart?
I do it all day.
Question, okay, are you saying that the injury to the chest, by the way, how old, if you know, how old was that injury to the chest? Answer, which injury? Question, the one that is not the one that was due to the hospital, the one in the middle of his chest. Answer, oh, the bruise? Question, yes. Answer, I don't know. Question, can you age bruising? Answer, to some extent. It is not nearly as reliable as inflammation internally. There are some criteria to use for aging bruising, but it is not as reliable. Question, so if that bruise was caused 12 days prior by the treadmill, and between the treadmill, we know that he played football, he went to football practice, he was in his mother's care, he was in his father's care, he was in his grandparents' care, could that heart contusion have happened on March 20th and persisted all the way through April 2nd? Answer, no. Question, okay, we just saw a series of pictures of different injuries that you say Corey received. Can you say with any degree of medical certainty whether any of these injuries that he sustained was what caused the injury to the heart and the liver? Answer, none of the skin injuries, the contusions can be correlated with what was seen internally. Question, okay, now you also said that initially you put your opinion that it occurred between 4 and 12 hours, right? Answer, yes. Question, okay, and then you changed your opinion based upon certain things that you were given afterwards, right? Answer, incorrect. Question, okay. Answer, I did not change my opinion. My opinion was amended or modified on the basis of new information. The basic opinion was still the same. The time frame was narrowed because of additional evidence that suggested that he couldn't have possibly have sustained those injuries prior to 9 o'clock. Question, so now when you met with Detective Mitchell and you met with Ms. Lento, did they discuss with you that if you put it between the 4 and 12-hour period, that he would have actually been in the care of his mother for some of that time? Answer, well, I knew that he did not get dropped off for custodial care to his father until 9 o'clock. So whether or not they mentioned
ex-lawyer,
it,
welcome to the chat.
I knew that that was the case. Question, so now you are stating that you saw a 33-second video of a child speaking to his mother.
It is very fast.
By the
I
way,
agree.
is that diagnostic or not diagnostic? Answer, it
We are
certainly aids in the
rereading Dr.
diagnosis.
Andrews'
It is
testimony
not diagnostic
right
in and
now.
of itself. However, a child is not going to respond in that fashion if he has already, or if he or she has already sustained those ultimately lethal injuries. Question, so in the 33-second video, do you recall it, by the way? Answer, I'm sorry. Question, do you recall it? Answer, the video. Question, yes. Answer, yes, sir, I do. Question, okay, do you recall that in the middle of the
Welcome
video,
to the
you hear
alternate point of
Corey
view.
moan? Answer, no, I don't recall that. Question, okay, do you recall in the middle of that video, you hear
Glad you
Corey
found us.
yawn? Answer, yawn. Question, yawn, like indicates. Answer, I don't recall that. Questions now, you also said that you saw a picture of Mr. Gregor that we just saw on the couch with Corey. And you said at that point that he could have been asleep. By the way, is that picture diagnostic value or non-diagnostic value? Answer, it is of aid in reaching, it is not diagnostic in and of itself. It's consistent with the time frame that I think this injury pattern occurred. Question, so are you saying based on a 33-second video and a picture and ancillary things to show you when that picture was taken and when that audio recording was done, that changed your whole opinion on the 4 to 12 hours? Answer, no, it modulated or amended the opinion. These injuries were of fatal potential, and they could have been certainly responsible for a change in Corey's demeanor and behavior. Therefore, behaving normally at 9 o'clock precludes that portion of the original range of time. Therefore, the clock, if you will, must by necessity start at 9, but it certainly doesn't go beyond 1 o'clock. Question, so with that contusion to the heart,
you're in
that
South
you showed
Africa
us,
too?
By the way,
awesome.
I'm not a doctor, but let me show you what has been marked as states S58. I'm assuming that is the heart. Answer, you are on point. Question, thank you, doctor.
Oh, she
Can
came
I
back.
give you a Sharpie? Answer, sure.
Bless
Question,
her.
can you circle the contusion? Answer, this is the, and there's some colloquy here.
We'll come back anytime, ex-lawyer.
Bear with me. Question, how are you, doc? So that is the liver, right? Answer, this is the liver.
I said you're in South
Question,
Africa. That's cool. We have a lot of people from South Africa
can you
on
draw
here.
a circle with the marker where the laceration on the heart would be? Some more colloquy.
And definitely come
Question,
back.
okay, how big was the laceration? Answer, it was described as, there's no scale on it. It was described by Dr. Ragasa as being 1.5 inches in length. Question, do you see it? Answer, yes, sir. Question, okay, is it about 1.5 inches in length? Answer, it certainly appears to be. Question, and about how long would a person live with a laceration of that size?
Oh, nice.
Answer, it's not a matter of size. It's a matter of where it is
Love
and
to
what
get
it's
your
doing.
insight on this
It's
one.
not going to cause blood loss because the heart is still intact, but it will disrupt the electrical
I'm glad you
activity
found
of the
us.
heart,
It's awesome.
which can only be compensated for
We're
limited
reaching
period
around
of
the
time.
world.
In Corey's case, it was from the time he was injured until the time he was pronounced 5:00 p.m. It is not going to be the same for every individual. Some people would die sooner. Some people may die after a longer period of time.
Thank you, Mars. I
It would
appreciate it.
certainly not be instantaneous. Question. So in Corey's case, you are saying that he could have lived for 4 hours with an 1.5 inch laceration to his heart? Answer. Given where it is and what it is, yes. Question. And are you saying that to a reasonable degree of medical certainty? Answer. I am.
We got a lawyer
We
in
have
the
redirect
house.
examination by Ms. Lento. Question. Doctor, are you aware that Dr. Larkin is an investigator with the medical examiner's office? Answer. I don't know who Dr. Larkin is. I know he's. Question. You don't have any information that he's the actual ME? Answer. Right. Question. Okay. And it was actually a radiologist at Soch who did the postmortem CT scan? Answer. They read it. Yes. Question. And why wouldn't you rely on a postmortem CT scan in regard
We
to
don't like him
determining
either.
cause and manner of death? Answer. A postmortem CT scan has to be interpreted in the context in which it is taken. In this context, it was simply a reflection of Corey's having been deceased and did not aid in determining a cause or manner of death. Reliance on the CT scan to say he had pneumonia is utterly without scientific basis. Question. Okay. All right. Question.
said
Now,
utterly
do blunt
without
force trauma
scientific
injuries
basis.
always leave bruising on the body? Answer. Not always, and especially in the case of children who have fairly elastic and elastic qualities and plasticity to their skin. You can apply blunt impact injury over a broad enough area to transmit force inside the body and internally injure the body.
That's
leaving
true,
a
sugar
contusion
baby.
on the surface of
His
the
voice
skin.
was,
That's not impossible.
he was just a
Question.
loud
And doctor,
talker.
can you explain how that is possible? Answer. It is possible because of the quality or the characteristic of the skin, particularly in pediatrics. Now, in a person who is not 6, but 66, a different story. But pediatrics is unusual in that regard. Question. And does the force of the blunt force trauma have any impact? Answer. It depends on the magnitude or the strength of the force.
Like I said yesterday, he sounds like an evangelical preacher that's like, give me your money.
And a blow that transmits enough force into the body to lacerate internal organs. So it depends on the magnitude of the force. Question. Okay, did you make any findings or were there any significant
Yeah, that was the best
findings
line he ever
regarding Corey's
said.
toxicology results? Answer. The only findings in Corey's toxicology results were medications that were given in conjunction with his attempted resuscitation. They gave him naxolone, which is an opiate. We have an objection. Question. Okay, can you tell the jurors who Dr. Falzone is? Answer. Dr. Andrew Falzone is the chief medical examiner, or was at the time. I expect he still is. Chief medical examiner of the state of New Jersey. Question. And did he review this case? Answer. It is my understanding he did, yes. Question. And did he speak to Dr. Regassa about that? Answer. That is what has been represented to me, yes. Question. And after that, did the Ocean County Medical Examiner's Office determine what the cause of death and the manner of death is homicide? Answer. That is my understanding.
Who knows? We're trying to relate everybody in the gallery to somebody.
Judge, there were 2 portions, I think, that were left out, like right after objections, if I could direct to the 2 sections.
Can I write down what
Page
you
and
just
line.
said? Say it again.
Is that okay?
What is he charged with?
Everybody needs to write down what you just
Kirsten,
said.
is that what you're
Sorry.
asking?
There were 2 spots right after objections that I think there was some testimony that wasn't read.
Okay.
Okay.
Is that okay, Judge?
You want to do that sidebar?
Yes. Sure, Judge.
Okay. While they're sidebarring. So he's charged. Boo-boo, get down. He's got several charges. His first charge is endangering and abuse of a child for the treadmill video. That's why that treadmill video is in. I was very confused. I thought they only used that to show a pattern of his behavior, but it's actually a charge. The second charge is murder, and that the state has to prove beyond a reasonable doubt. Hi, Nicole. Welcome. And that the state has to prove beyond a reasonable doubt that he did so purposefully and knowingly murder Corey. Now, they threw in a couple of extra lesser charges. The other one is aggravated manslaughter, and that is that he showed extreme indifference and acted recklessly with disregard for life, gross negligence. And the other is reckless endangerment manslaughter, and he had to show his conduct caused the death so recklessly, and he was aware and had disregard for life. Each of these charges carry lesser sentences than the other. So he has 3 different: murder, aggravated manslaughter, or reckless manslaughter. So different types of charges. We'll see what the jury comes back with. They could come back with that murder charge, or they could come back with a lesser manslaughter charge. Yeah. The problem is, so what I know, I looked up the sentences for each charge. So murder, he could get anywhere from 30 years to life. For the aggravated manslaughter, it's 10 to 30 years. For reckless manslaughter, it's only 5 to 10 years. So fingers crossed. Yeah, he will get the, yeah, I don't think murder is going to sit. I agree with you, ex-lawyer. We kind of come to the conclusion that he did intentionally abuse Corey, but we don't think he intentionally murdered him. We think he just went too far on this particular day. So I think that's why the prosecution threw in those extra lesser charges. As I explained to everyone yesterday, when I found out they were throwing those lesser charges in, that they didn't feel strongly enough about their case to throw those in there. Hi, Amazing G. Yeah, the child abuse and endangerment, he can get up to 30 years for that, believe it or not. So we'll see what happens. It's in New Jersey. So yeah, I don't think he intended to murder Corey. I think if Christopher had his way, my opinion, I don't know about anyone else, but I believe if Christopher had his way, he would have abused that child for as long as he possibly could have. He would have made that child's life a living hell. Yes, in essence, he will get away with murder, but he is going to get some sort of penalty. Yes. But I believe he would have tortured this child for as long as he possibly could have and enjoyed every second of it. So that's me. That's what I think. Welcome anyone who's been joining our live stream and isn't in the chat. I appreciate it. With murder, he could get 30 to life. But again, I don't know if they have proved murder beyond a reasonable doubt. That's a big mountain to climb. No matter how awful of a person we think he is or know he is, that's a big one. It would never be enough. I don't think there's anything that he could get that would be enough. Yeah, I hope the judge will at least, I'm thinking he's at least going to get 30 years combined with all of the charges. Yeah, Corey was definitely afraid of him. It did not take long. And I feel like even the granddad may have been abusive because, I mean, just hearing the granddad's testimony that he was in charge, you know, of his backpack, of his homework, of his getting to and from the bus, but the granddad couldn't say what school he went to. That's a pretty telling situation, family dynamic. Yeah. Like, how can you be so involved if you can't even tell what school he went to? Yeah, no parental instincts whatsoever does Christopher have. Definitely. Like I've been saying all along, I've been using the word authoritarian for the whole time. I definitely believe that's how his father was. Yeah, I think our system is pretty backwards. Like I'm on the fence at how we treat children that commit, I guess, adult crimes, whatever you want to call it. Like kids' brains are not developed, you know, until they're 25. And here we are treating children like adults when they do things that are, I mean, obviously they're terrible. But I think it's hard for us to, like the case you're talking about, the 14-year-old girl.
Ladies and gentlemen, the court reporter, I thought did a great job of reading back because that was actually Rachel Chickalis, the court reporter that day. So she was reading from a transcript taken by another reporter.
Right.
Once or twice at the area of a couple of the objections or sidebars, there might have been a couple words that were missed. I reviewed those with counsel, and I don't think that overall changes what the doctor testified to. And I think it would be inappropriate now to go back and read a word or two or three to you out of context. So I've ruled that the readback is satisfactory. Given the time, it's about 4:34. Do you want a couple minutes to talk, or you just want to say, want to recess for the day and come back tomorrow?
Yeah, I guess for a
Right,
minute.
do that. And then I'll get the key too, because I have to give you the key to lock up the evidence. So,
It won't be long then.
okay. All right, understood. So please resume your deliberations or discussions and let us know.
All right.
Oh, no. No.
Yeah, I think we should just stay.
Yeah, she did a really good job reading that. Oh, no, they have to come back with a verdict today. They're just toying with my emotions right now.
Is right now, I have a feeling they're going to be coming back out pretty quickly.
Oh.
Yes, that's fine.
Do you want to do this or going right?
To what?
For what? I want to talk about that.
No, I don't want. Oh, man.
Sidebar?
Sure.
Why do you need a sidebar? Oh. I'm sorry to hear about your mom, Gwen. Oh. I mean, that's a lot of information to take in for them, though. So. I mean, yeah, the jury might, I don't know, they might want to hear some more stuff. Who knows? At least they're taking their time. I mean, they are actually deliberating. The prosecution did throw in those other charges. They have to take those into consideration. It would be hard to decide. And keep in mind, they don't know what the sentencing is to each of these charges, like we know. So yeah, that's like the Sidney Powell case. You know, kids, they don't understand consequences and repercussions these days. But I don't know. Like I feel weird. I had some people tell me on my channel, because I look at these kids and they do these things, and I'm like, I just feel like they're not understanding what they're actually doing, and that it's permanent, it's forever. And should we actually be punishing them, like putting them in adult prison and treating them that way? And I've had people actually like come after me and say, you know, they committed the crime, they do the time. But I'm not sure if they really fully understand what they're doing. He's looking pretty nervous, you guys. Yeah, it's crazy. Where are you from, Mars? She's from Mars. Oh, nice. I like North Carolina. It's pretty. I used to live in Charlotte. My oldest lives in North Carolina now. He's a teacher in Greensboro. That's right. Party on Mars. Pluto's still a planet. I don't care what anyone says. Oh, I'm sorry, Kirsten. Well, people say a lot of people, kids are a gift from God. That's what they say. But let me tell you, my 24-year-old has his goal in life is to drive me absolutely insane. So it's a catch-22. Yeah, North Carolina is great. It's one of my favorite states. I've lived all over the country, all over the world. So yeah, they might be getting ready to take him out.
I'm going to have my inmates and other calendar matters reported 9:30 tomorrow. Otherwise I had a sentencing calendar on. I tried to cut it down. I adjourned some of the ones I could. So my plan would be to have the jury report at 9, get them in the jury room, and then try and handle some things out here. Any objections, I tell them I'll just be handling other things out here in general, and that, that's why they should knock, and it may take us a little longer to bring them in or anything like that. All right. And then if there's a readback request or a long question or whatever, those people are just gonna have to wait. So I tried to cut it down to about half of what it would normally be.
I know, Kirsten. That's what I'm saying. Tomorrow, what the heck? Hey, look, but guess what? We can do another live and we can all be together again. My 24-year-old's married now. And I keep calling his wife his girlfriend still, and I need to stop doing that. But they did get married in December. My gosh, I need to get past it. I don't go to the zoo. I don't like animals in captivity. I never took my kids to the zoo. I'm a bad parent. I was like, I didn't do the zoo or the circus or any of that stuff. The girlfriend is now the wife. I can't. I keep calling her the girlfriend, but she's his wife now. It took me a while. So everybody keeps reminding me, like, you were at the wedding. She's his wife. He's my baby boy. I still track him on my phone. I track both of them because he's a truck driver. So I have him on Life 360. Yeah, I'm that mom. He's like taking the app off. He took the app off of his phone while they were on their honeymoon because they went on a cruise. And I noticed that he was not on the app. And I was like, put the app back on your phone. He was like, I'm on my honeymoon. I'm not going to do that. It takes up too much Wi-Fi. Yeah, I'm that mom. He calls me a tiger mom. Yeah, I'm terrible. Yeah, everyone makes fun of me. They're like, you're terrible. I'm like, no. And I'll even call my boyfriend, like, get him back on the app right now. But I track my sister too. I made her download the app. I don't care. I'm gonna find you. I mean, I have a crime channel, for God's sake. What are you talking about? Get the app on your phone. I need to know where you are at all times. Right? I know. Anyone can become a lampshade at any. I mean, yeah, they're just sitting around. So I think he's thinking they're gonna. They can stay. They can deliberate as long as they want to. They can deliberate till 8 o'clock tonight, 9 o'clock. They can deliberate as long as they want to.
Open the door and give the key to the foreperson and ask her to lock up.
Aye.
The evidence, all their notes.
Oh man, Jenny, I still can't let go. That's funny, China. I have to say, I love our chat. I love our group. We have a great group. You're so sweet, Kirsten. What's great is we have people from all over the world and everybody's just super cool. Super cool. Oh, I love that you're here. This group wouldn't be so cool if it wasn't for each and every one of you guys. Seriously.
Can you arrange that, Sergeant?
One officer.
Hopefully it's empty out there.
Oh, that's awesome, Mars. Thank you. Yeah, Selena's been here ever since we've gone live. Everybody's been great. And every person that joins just seems to like vibe. Man, I guess we're coming back tomorrow, you guys. Well, because we got to be here. We've been doing this every day this week, so we got to do it.
Hi, Joe number 13. We figured we'd talk to you at sidebar about your scheduling issues.
Yes.
Uh-oh. Yeah, God works in mysterious ways, you guys. When are your grandkids coming, Julia? Tomorrow or? Well, Julia had to watch and get stuff done because she's got grandkids coming. I love that. I love people are just stumbling across my channel. Oh, Saturday. Okay, so if we meet tomorrow, you can come on tomorrow. Oh, hi, Lorraine. Welcome. Another person from South Africa. This is so cool. How are you guys getting on this channel? This is great. Yes, we can definitely start tomorrow with a prayer for Corey because I think the jury needs more. We need more prayers for Corey and for this jury to be in the hands, God's hands, because they definitely are gonna need it. Because I'm very thankful. I'm gonna thank God tonight that they are taking their time. I'm very, very thankful that they're not rushing this decision. I know how badly we want a verdict. I know we do, but I'm super
all the
thankful
evidence in black cat.
they're taking their time.
Before you come out, all the notes and your binders and everything, all the subjects, lock it up, bring it up.
Oh, thank you, Kirsten. I think it's appropriate that they're taking their time. We should thank God for that, for sure. Thank you, Lorraine. I'm so glad you got on here with us.
Great. The 12 deliberating jurors have sent out a note, which is marked as Court Exhibit C20 in evidence. Quote, "Dear Judge Ryan, we have had enough for today. We can recess. No verdict yet. Thank you, juror number 1." End quote. So counsel agree we can bring the jurors out and excuse them for the day?
Yes, Judge, thank you.
Very good. Jury out.
All right, y'all. We're going to be back tomorrow. You guys are awesome. I love it.
And we need the 2 alternates?
They're coming.
Very good.
Okay, there were 3 alternates. Now there's only 2. So somebody got dismissed. In case you didn't notice that.
Okay.
Yeah, we have several people from South Africa on here. Yes, the defense can definitely appeal. And he will appeal.
It's okay. No worries.
Yeah, y'all are my POV team. Thank you so much, Silencing Whispers. I hope you get on here tomorrow. I hope your therapy goes well. We'll pray for you.
So, ladies and gentlemen, thank you. A couple of announcements. Juror number 13 was one of the 3 alternates. She advised us, we were able to speak to her at sidebar, that she has some personal obligations for tomorrow, and the timing of those changed, and she would have to leave early, so we've all agreed she could be excused. So we're down to 2 alternates, which should be just fine, obviously, since we've already commenced
in America, they have so many appeals they can
Please stop your
do.
deliberations now. Continue to follow my instructions about no research, no outside contact or communication. Don't look up anything on the news media, and don't have anyone do that for you. Give you an update what's going to happen tomorrow. You can be seated, folks. Thank you so much. Tomorrow, I already had a calendar scheduled of multiple matters that would come in, typically what we do on most Fridays. Because you're deliberating, I've tried to cut that down as much as I can. I'm going to have that calendar start at 9:30. So I ask you to come at 9. Hopefully get over here, get in the jury
See you
room,
tomorrow,
start
China.
deliberations, and then you may hear us out here, maybe have people coming in and out or whatever.
See you
I'll
tomorrow,
try and get
Julia.
through those matters. That doesn't affect you though. So if you have a question, you want to read
See you
back, or
tomorrow,
any other
Mars.
issue, you just tell us.
They're not
and then
sequestered.
those people have to wait or get moved somewhere else or get
They
postponed.
get to go home.
So other than just giving you the courtesy of letting you know what's going on, I don't want it all to affect your thinking, or I don't want to say, oh, well, I can't ask for readback because the judge is busy. That's absolutely not the case. You can ask for whatever you want. You're the priority. Just that some of those things I have to handle, but if I had to handle them at the end of the day, I would do that. Just telling you that. So it may take me an extra 5 or 10 minutes if you send a note out to get everything here cleaned up and get the courtroom empty and then be able to proceed with you. Madam Foreperson, you're
Have a good
handing me the
therapy
key
tomorrow,
back. Is the
Silencing
evidence in your
Whispers.
notes locked up in the cabinet?
Yes, sir.
All right. So I acknowledge receipt of the key for the evidence cabinet from the foreperson, and I'll return it to you tomorrow. And that way we can have staff clean the jury room and without seeing any of your evidence. Anything else from counsel?
No, Judge, thank
No,
you.
thank you.
Thank you so much again. We'll see you tomorrow
So
at
Kirsten,
jury assembly, of course.
he's going to appeal this because if you haven't noticed, this trial has been a total circus show. He's going to appeal on poor defense. But it takes a while to appeal. Yes, 9 a.m. But it'll be 8 our time, Central Time. 8 Central, 9 Jersey time, Eastern. So we'll be up and at it early in the morning again. So, yeah, I can tell you in the American system these days, I would not trust 12 people with my life in their hands, to be honest with you. So.
It's 4:55. The jurors have left the courtroom. Anything from counsel? No, Your Honor. Thanks, everyone. We'll see you tomorrow.
Thank you,
All
Judge.
right. We will see y'all tomorrow.
Yes.
Thank you so much. You guys are
You're gonna
amazing.
take
I
your
appreciate
laptop
you.
home, right?
Yeah.
Y'all have a great night.
Ma'am, take it to, all right.
Chad Daybell, by the way, was guilty all counts. So if you guys want to check out that sentencing, I think they're going to be having that soon. So I will see y'all tomorrow. Prayers, you guys. Mars, you're so funny. Thank you, guys. I'll see you in the morning.